10,096 meeting of the Security Council is called to an order. The provisional agenda for this meeting is the promotion and strengthening of the rule of law in the maintenance of international peace and security, reaffirming international rule of law, pathways to reinvigorating peace, justice, and multilateralism. The agenda is adopted. In accordance with Rule 37 of the Council's Provisional Rules of Procedure, I invite the representatives of Algeria, Angola, Argentina, Armenia, Australia, Austria, Azerbaijan, Brazil, Brunei Darussalam, Cambodia, Canada, Chile, Costa Rica, Cuba, Democratic People's Republic of Korea, Djibouti, Egypt, Eritrea, Estonia, Ethiopia, Finland, Germany, India, Indonesia, the Islamic Republic of Iran, Israel, Italy, Japan, Kazakhstan, Kenya, Kyrgyzstan, Lebanon, Liechtenstein, Lithuania, Malaysia, Maldives, Mexico, Morocco, Mozambique, Myanmar, Namibia, Nepal, the Kingdom of Netherlands, Niger, New Zealand, Paraguay, the Philippines, Poland, Portugal, Qatar, Republic of Korea, Romania, Rwanda, Kingdom of Saudi Arabia, Sierra Leone, Slovenia, South Africa, Spain, Switzerland, Thailand, Timor-Leste, Tunisia, Turkey, Ukraine, United Arab Emirates, the Bolivarian Republic of Venezuela, and Vietnam to participate in this meeting. In accordance with Rule 39 of the Council's Provisional Rules of Procedure, I invite the following briefers: His Excellency to participate in this meeting. His Excellency Mr. Mahmoud Ali Yusuf, the Chairperson of African Union Commission, and Judge Abdul Qawi Yusuf, Founding President of the African Institute of International Law. Is so decided. In accordance with Rule 39 of the Council's Provisional Rules of Procedure, I also invite His Excellency Mr. Stavros Lambardinis, Head of the Delegation of European Union to the United Nations, to participate in this meeting. It's so decided. Security Council will now begin its consideration of the item 2 of the agenda. I wish to draw your attention of the Council members to the document S/2026/28, a letter dated 13 January 2026 from the Permanent Representative of Somalia to the United Nations, addressed to the Secretary General, transmitting a concept paper on the item under consideration. I warmly welcome the Secretary General, His Excellency Mr. Antonio Guterres, and give him the floor.
Thank you very much, Mr. President. Mr. President, distinguished members of the Security Council, I congratulate Somalia on its presidency of the Council, and I also welcome my fellow briefers, His Excellency Mahmoud Ali Yusuf, Chair of the African Union Commission, and Judge Abdul Qawi Yusuf, former President of the International Court of Justice and founding President of the African Institute of International Law. Mr. President, the rule of law is a cornerstone of global peace and security, the key to friendly relations among the countries and regions of the world, and the beating heart of the United Nations Charter. For 80 years, it has helped humanity avoid a third world war and ease the human toll in countless smaller conflicts. The Charter, along with the Universal Declaration of Human Rights and the core human rights treaties, the Geneva Conventions, the Friendly Relations Declaration of 1970, and the Declaration on the Rule of Law of 2012 have all contributed to a collective security system that is robust and resilient. A system that prohibits the threat and use of force and binds all states, large and small, to the same rules, and that respects the principles of sovereignty, political independence, and territorial integrity of states. For smaller and less powerful countries, and those suffering from historical inequities and the damaging legacies of colonial rule, international law is a lifeline promising equal treatment, sovereignty, dignity, and justice. And for powerful countries, it is a guardrail defining what is acceptable and what is not in times of disagreement, division, and outright conflict. The founders of this organization understood that global problems can only be solved by wielding not the weapons of war, but instead the tools of diplomacy, supported by a system based on international law. By dialogue, not the zero-sum rhetoric of division, and by collaboration, not geopolitical competition. In 2024, member states adopted the Pact for the Future, which included a commitment to act in accordance with international law and fulfill obligations in good faith. But words are not being matched with action. Around the world, the rule of law is replaced by the law of the jungle. We see flagrant violations of international law and brazen disregard for the UN Charter. From Gaza to Ukraine and around the world, the rule of law is being treated as an à la carte menu. We see states flouting the rule of law with impunity through the illegal use of force, the targeting of civilian infrastructure, human rights violations and abuses, the illegal development of nuclear weapons, unconstitutional changes of government, and denial of life-saving humanitarian aid. These violations set dangerous precedents, encouraging other countries to do what they want instead of what they are required to do under international law. They breed mistrust and division among nations, and they undermine people's faith in our ability to find solutions together. 8 decades after this multilateral system was created, we need to get back on track. And this Council must lead the way. Mr. President, the rule of law is foundational to the United Nations and our mission of peace. I'm determined to keep driving our relentless push for just and sustained peace. Peace firmly anchored in international law, and peace that endures because it tackles the root causes of conflict, not just the symptoms. Too many crises today persist in limbo. Fragile ceasefires, stalled processes, or agreements that evaporate the moment the ink dries. The rule of law is also foundational to our work here in this chamber. In an era crowded with initiatives, the United Nations Security Council stands alone in its charter-mandate authority to act on behalf of all member states on questions of peace and security. The Security Council alone adopts decisions binding on all. No other body or ad hoc coalition can legally require all member states to comply with decisions on peace and security. Only the Security Council can authorize the use of force under international law as set out in the Charter. Its responsibility is singular, its obligation is universal. And that is why reform is essential. That is why we must act without delay to enhance the representation and effectiveness of this Council. To safeguard, looking ahead on questions of the rule of law, I see 3 areas where member states and this Council can take action. First, countries must keep their promises. The purposes and principles of the United Nations Charter are not optional. All countries have an obligation to uphold them, to settle disputes peacefully. In an era crowded with to safeguard the human rights and dignity of all people, to act in conformity with international law, and to adhere to the letter and the spirit of the principles of self-determination of peoples and the sovereign equality of member states. Our collective security system requires trust. And the best way to reinforce trust is for all countries to meet their commitments under international law. Second, I urge member states to make full use of the dispute settlement mechanisms spelled out in the Charter to prevent conflicts from starting in the first place. As this Council knows, the best and often only pathway to peace depends on the hard work of negotiation, inquiry, mediation, conciliation, arbitration, and other means set out in Article 36 of the Charter. Preventing conflicts also means building strong partnerships with regional organizations in accordance with Chapter 8 of the Charter. Security Council Resolution 2719 set a good example by establishing a framework for predictable financing of African Union-led peace support operations authorized by the Security Council through assessed contributions. And as the Pact for the Future, my new vision for the rule of law and the new agenda for peace remind us, preventing conflicts also means investing in development and institutions that people can trust. Poverty, hunger, inequality, corruption, injustice, and exclusion erode people's hopes for the future, drive communities further apart, and send shockwaves of unrest, violence, and even conflict across countries and regions. Sustainable development is possible only by adhering to the rule of law, including the requirement to safeguard the rights and dignity of all people at all times.
Excellencies. And third, we must continue to promote the use of fair, independent judicial proceedings. It is encouraging to see increasing recourse to international courts and tribunals, including the International Court of Justice, the principal judicial organ of the United Nations. As the court commemorates its 80th anniversary, I reiterate my call for all member states to accept its compulsory jurisdiction without reservations and to respect and fully implement the court's binding decisions. It is also time to ensure accountability and to end impunity. The International Criminal Court, the central institution of the international criminal justice system, must be able to operate independently. There can be no sustainable or just peace without accountability. The rule of law must prevail. Mr. President, ladies and gentlemen, members of the Council, for 8 decades, the rule of law has been the greatest equalizer of global relations. It is time for all countries to recommit to the full respect of international law, to live up to the promises and obligations outlined in the United Nations Charter. Members of the Security Council bear a special responsibility to lead by example. Through my good offices and the continued efforts of United Nations envoys and mediators, I look forward to supporting this Council's efforts to advance the rule of law and to build a more stable and secure world for all. Thank you.
I thank the Secretary General for his briefings and now give the floor to His Excellency Mr. Mahmoud Ali Yusuf. Your Excellency, we cannot hear you. Maybe it's muted.
You are muted. Can you unmute?
Excellency, they're saying you are muted. Can you unmute your phone?
If not, we move to the next.
Okay. Okay. Let us move to the The next, while we're fixing the His Excellency Mahmoud Ali Yusuf's site, and now call the His Excellency Mr. Judge Abdul Ghawi.
Can I take the floor? Can you hear me?
Yes. Yeah, we can hear you now. Yeah.
Excellence, Monsieur Boubacar Bahem.
Excellency, Permanent Representative of Somalia, President of the Council for January 2026, Mr. Secretary General, Judge Abdul Kafi Yusuf, Excellencies, ladies and gentlemen, members of the Security Council, ladies and gentlemen. I wish to begin with a warm word of thanks to Mr. Robert Hardai, President of the Security Council for January 2026, for convening this high-level debate. I also welcome the leadership of Somalia at the helm of this council and the trajectory of Somalia, and this is a strong message of resilience and of hope generated by international rules-based order. I also wish to thank the Secretary General, Mr. Antonio Guterres, for his statement and for his leadership. Ladies and gentlemen, we have gathered at a critical juncture for multilateralism. The international system, which for nearly 8 decades has facilitated a relative degree of stability, has been weakened. Conflicts have proliferated. Multilateral action has been weakened, and trust in international institutions is being chipped away. That having been said, the position of Africa is clear and it is steadfast. We remain fully committed to multilateralism. We are aware of the fact that no state, regardless of its weight, single-handedly, no state can tackle present-day challenges, including terrorism, climate change, pandemics, poverty, insecurity. These threats know no borders. They require collective responses rooted in international law and meaningful and sincere cooperation. On the basis of this clear framework, we are addressing matters related to international law. For Africa, this is not an abstract notion. Rule of law is the very bedrock of sovereignty, of dignity, of stability, and of sustainable development. The Constituent Act of the African Union enshrines democratic governance, human rights, rule of law, and good governance as binding principles. It also reaffirms the territorial integrity and the intangibility of borders and peaceful coexistence in an increasingly unstable world. These principles define the identity of Africa and guide our collective action. Africa's commitment to peace is not merely limited to principles. It is reflected in action. And the relevant Security Council resolution has marked a significant step in the partnership between the United Nations and the African Union. We recognize the role of regional organizations in the maintenance of international peace and security. African troop-contributing countries, specifically in Somalia, continue to undertake significant efforts and make contributions. We honor the memory of those men and women who lost their lives as they sought to advance peace, and we applaud the determination of Africa to shoulder a greater degree of responsibility for its own security in partnership with the international community. This commitment is undergirded by tangible commitments, including through the AU Peace Fund. African states increasingly leverage legal mechanisms in order to peacefully resolve their disputes, specifically the ICJ and regional jurisdictions. This reflects a deeply rooted conviction that rule must prevail, law must prevail over force. Discussions of international law lead to an alarming recognition of an alarming reality. There are divisions in this council. 80 years After the establishment of the United Nations, a continent of 1.8 billion people and 55 member states still does not have a permanent seat in a body which helps to shape its future. This is not just an injustice to Africa. This is a matter of credibility and a problem of effectiveness for the Council itself. Africa's position is clear and we stand united. As is reflected in the Swahili consensus and the Sirte Declaration, a permanent seat with all of the prerogatives, including the right of a veto and 5 non-permanent seats. This is not a matter of privilege. It's a matter of equity and correcting a historical injustice. We call for greater cooperation between the United Nations and regional organizations, specifically the African Union, in accordance with Chapter 8 of the Charter, as well as for partnership rooted in mutual respect, complementarity, and responsibility sharing. Excellencies, breathing new life into multilateralism requires more than rhetoric. This requires respect for good faith, respect for international relations, peaceful dispute resolution, more equitable global governance, and political courage to reform institutions which fail to reflect present-day realities. We stand ready to play our role, guided by the 2063 Agenda and by the Charter of the United Nations. We extend a hand to all those who aspire to a more just, a more peaceful, and a more inclusive world order. For Africa, rule of law is neither optional nor selective, nor is it negotiable. A rule of law is a very prerequisite for peace. Let us see to it that succeeding generations do not inherit a weakened system, but that they inherit renewed multilateralism that is more robust, more fair, and worthy of trust. Thank you.
I thank to His Excellency Mahmoud Ali Yusuf for his briefings, and now give the floor to Judge Abdul Qawi Yusuf.
Mr. President, Ambassador Abubakar Osman, Mr. Secretary General, Excellency Mahmoud Ali Yusuf, Chairman of the African Union Commission, distinguished delegates. It is a great pleasure for me to see Somalia, Mr. President, presiding the Security Council after more than half a century. My warmest congratulations to you and to the entire delegation for Somalia's election to the Council and to the presidency of the Council for this month. A debate on the rule of law is both timely and topical. We live at a time of many threats to the international legal order. We therefore have to remind ourselves of the crucial role of the rule of law, both at the domestic and international levels, for peace and security. Every society needs to determine how the relations among its members are to be governed. All societies establish for that purpose rules and principles. This applies also to the international society. At the international level, available options for states certainly include the rule of law, but also the legitimization of the use of war as a means of foreign policy, including as a means to settle disputes or enforce legal rights. This was indeed the case before the adoption of the UN Charter. It led to 2 destructive and catastrophic world wars in the first half of the 20th century, not to mention the numerous wars in Europe in the 19th century and the colonial wars in Africa and Asia, which resulted in the death of millions of people. In 1945, through the Charter, the founders of the United Nations chose the rule of law and rejected the rule of force, which had hitherto prevailed. This choice did not come from nowhere and was not a sudden decision. It was a result of the evolution of human civilization. It was a result of the realization that the old system, which had made war permissible to right wrongs, was not only brutal, but fundamentally unjust. The international rule of law is therefore a recent human achievement and represents a model of an international order based on the rules of international law, as opposed to a model governed by the claims of power of a few states over the others. The old expression, might is right, has never helped humanity to live together in peace and harmony. Mr. President, the emergence of an international rule of law in the second half of the 20th century and the underlying respect for the principles and rules of the UN Charter, maybe not all the time, but very often, acted in the past 80 years as a bulwark against widespread wars and violence in the world. Sovereign equality of states, equal rights and self-determination of peoples, the prohibition of the threat or use of force against the territorial integrity of other states, and the peaceful settlement of disputes are the fundamental principles and rules, to mention just a few, which brought us all peace and stability. They serve it also as an engine of freedom and emancipation for the peoples of Africa, Asia, and the Caribbean from colonial rule, and enabled them to consolidate their independence. They serve it equally as an engine of economic development and prosperity in many parts of the world, which enjoyed for the first time in their history uninterrupted peace and stability for almost a century. The embodiment of the rule of law in the UN Charter went hand in hand with a significant increase, not only in the rules applicable to relations between states, but also those applicable to individuals and those meant to facilitate the life of peoples when crossing borders for whatever reason, or communicating with others outside their countries or continents. That increase was due to the conclusion of international agreements in a wide range of fields, from aviation to telecommunications, from labor standards to trade and investment, from human rights to humanitarian law, and all the way to environmental law, global warming, and the protection of biological diversity. It also gave rise to thousands of treaties establishing cooperation among the states, both at the bilateral and multilateral level. The international rule of law, as compared to the domestic rule of law, we have to recognize is in its adolescence. 80 years is a very short period in the history of humanity. As we all know, adolescence is a transitional period marked by social change and challenges. We cannot therefore expect that the rule of law among nations displays all the time maturity and solidity. It will experience challenges as it grows. It will occasionally suffer from shortcomings. It will be affected by strong headwinds in its progress. This happens to be the case today. However, there is no reason for despair. The vitality of a legal order is for the long haul. There will always be periods of turbulence, but the dangers lurking behind those turbulences should convince the states to stay the course, to uphold the rule of law, because the alternative is much less desirable. We need to recall that the binding character of the large majority of rules of international law rests upon the consent of states. The obligations assumed by states through international agreements are not incompatible with state sovereignty. The conclusion of any treaty by which a state undertakes to perform or refrain from performing a particular act is itself an attribute of state sovereignty. It is therefore in the exercise of their sovereignty that states establish the rules governing their relations with other states. They should therefore respect them. A world without rules or legal guardrails is not in the interest of any state, small or big, weak or powerful. Lawlessness and chaos do not benefit any nation's security or development, nor does arbitrariness in relations with other states. The advantages of stability and predictability offered by the web of international legal rules established in the post-war period outweigh any possible constraints that it imposes on states. Without an international rule of law, arbitrariness would increase, predictability would diminish, uncertainty would disappear. Hopefully, cooperation and coordination through the United Nations and its organs will help us all avoid such a situation. I thank you, Mr. President.
I thank Judge Abdul Qawi Yusuf for his briefings. I shall now make a statement in my capacity as the representative of Somalia. Excellencies, distinguished delegates, ladies and gentlemen, it's a great honor and privilege for Somalia to preside over the high-level open debate at the Security Council today. This honor is even more meaningful given that it's the first time Somalia has held the Council's presidents since January of 1972. I extend my gratitude to the Excellencies, the Secretary General, Mr. Antonio Guterres, the Chairperson of African Union, Mr. Mahmoud Ali Yusuf, and Judge Abdul Qawi Yusuf for their briefings. Their insights and commitments to upholding the principles of the Charter of the United Nations are deeply valued and are basis for these timely deliberations today. Excellencies, we meet at significant milestone, the Charter's 80th anniversary. This is time not just for commemoration, but for an honest reflection. This is a time not just for commemoration, but an honest reflection. We must ask ourselves, are we living up to the vision that shaped this institution? Are we upholding the principles intended to promote peace, justice, and human dignity for all? I think there is a debate to be had here. In Somalia, we say, haddii aad maanta la fiirin wixii shalay dhacay, berri horumar ma leh. This translates as if what happened yesterday is not examined today, there is no progress for tomorrow. Somalia is a proud nation of poets. We turn to our proverbs in moments of reflection. This reminds us that progress is intentional, that only by looking honestly to our past can we correct course and build a better future. For my country and the majority of United Nations member states, the rule of law among nations is not an abstraction. It safeguards sovereignty, anchors justice, and preserves dignity. Yet, today, in too many places, the rule of law is under pressure from conflict and weak global adherence to the international agreements. This is a legal and diplomatic race to the bottom, which risks undermining all achieved international successes in the international development. The UN Charter clearly states, we, the people of the United Nations, are determined to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. This guiding noble ambition, born out of destruction of 2 world wars, must continue to guide us toward peace and prosperity in these uncertain, turbulent times. To achieve the aspirations of UN Charter, we must strengthen our resolve on 4 critical areas. First, peaceful settlement of disputes. The Charter is clear. States must resolve their differences by a peaceful means. Peace is more than absence of war. It demands lasting solutions built on trust in the legal institutions. Across the world, we have witnessed nations opting for courts, not arms, to resolve disputes. Every legal pathway must be utilized to prevent conflict and injustices from escalating. Second, respecting for sovereignty and territorial integrity. When borders are unilaterally altered through the use of force, the very architecture of the international legal order is threatened. This undermines the collective sovereignty and security of all states. This principle, enshrined in Article 2, Chapter 4 of the United Nations Charter, and further affirmed in the 1970 Declaration on Friendly Relations, finds its most profound regional expression in the Constitutive Act of the African Union. In particular, for post-colonial states, is a fundamental legal reality. We maintain that global stability and prevention of conflict depend entirely upon the rigorous and consistent application of this principle without exception or selective interpretation. Third, equal rights for all people. The sovereign equality of states and equal rights of all people are the twin pillars upon which the international system is built. As affirmed by the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights, all human beings possess an inherent dignity that admits no hierarchy, distinction, or exception. The rule of law is fundamentally incompatible with a rhetoric that demands entire population or dismisses voices based on creed, religion, or national origin. Such a conduct constitutes a direct assault on the UN Charter's commitment to international cooperation. The rule of law and the fundamental human rights are indivisible and mutually reinforcing. When dignity of one people is diminished through contempt or a systematic exclusion, the legal framework protecting us all is fractured. True international order cannot exist where equality is treated as a conditional privilege rather than an absolute right. Fourth, the rule of law is the cornerstone of multilateralism. The challenges we face today transcend borders. They demand collective actions anchored in trust and legal obligations. Treaties not honored erode the trust. We must support the established international legal systems which help resolve disputes and restore faith in the global order. Excellencies, the UN Charter provides the international legal architecture to enforce the rule of law, yet we stand at crossroads. One path leads to a world where power eclipses principles and justice to reserve for the few. Another path lies the promise of our Charter, a world governed by law, where sovereignty is protected and justice is within each of all. As we look forward to the next 8 years, it's crucial to recommit to learning from the yesterdays and acting with a purpose today. Building a world where multilateralism is strengthened, not weakened, and territorial integrity is respected not only in principle, but in practice. The Security Council must do more than bear witness. We must act as stewards of the rule of law and defenders of multilateralism. What is needed now is the will to apply them consistently and without double standards. Somalia returns to this important council reflects a renewed commitment to the principles that anchor this this chamber, dialogue over division, law over force, and cooperation over conflict. For the betterment of all people and for the advancement of international order and generations yet to come, we must breathe renewed life in the UN Charter. We must ensure that we all match our words with deeds and recommit ourselves together to the rule of law among nations. This is the real road to global peace, security, and economic prosperity for all nations. I assume my function as the President of the Security Council. I now call the representative of the Kingdom of Bahrain for his.
السيد الرئيس يطيب لي بداية.
Mr. President, I'd like to begin by welcoming the presidency of Somalia to this public debate. And I also would like to thank His Excellency Mr. Antonio Guterres, Secretary General of the United Nations, as well as Mr. Mahmoud Ali Yusuf, AU Commission Chairperson, as well as Judge Abdul Qawi Yusuf, from the International African Institute for International Law. I thank them for their precious comments, which are adding to our discussion. The international community is going through an increase in security challenges, the intensification of armed conflicts, and a lack of trust with regard to multilateral mechanisms. International order is therefore subject to unprecedented pressures, which is threatening global peace and stability, the very foundations of it. The international community is now commemorating the 80th anniversary of the adoption of the UN Charter. This occasion does not just represent a symbolic milestone, it also constitutes a renewed opportunity to reaffirm the central and pivotal role of the rule of law as the comprehensive framework regulating relations among states, and enables us to entrench the principles of justice, peace, and international cooperation. The Kingdom of Bahrain firmly believes that the rule of law, nationally and internationally, is a cornerstone of the preservation of international peace and security in accordance with the provisions of the UN Charter with regard to the respect for sovereignty, non-interference in the internal affairs of states, and the peaceful settlement of disputes, as well as the good faith implementation of international obligations. This is the true guarantee that will prevent conflicts and promote international stability. Confronting emerging threats to the rule of law requires the adoption of preventive and cooperative strategies at the national, regional, and international levels, based on preventive diplomacy, strengthening institutional capacities, as well as consolidating the role of regional organizations in order to address conflicts in their early stages whilst fully respecting the particular circumstances of the states concerned. The Kingdom of Bahrain shares the responsibility with all member states and members of the Council within the framework of the Council to uphold the rule of law in a consistent, impartial manner in accordance with the UN Charter. My country believes in the peaceful settlement of disputes, including mediation, good offices, and judicial mechanisms. In this regard, the Kingdom of Bahrain would like to stress the importance of making greater use of the provisions of the United Nations Charter, particularly those contained in Chapter 6, which provide effective legal tools for the peaceful settlement of disputes and prevents conflicts escalating between states. Bahrain also calls for activating legal frameworks for regional organizations and for strengthening of coordination and constructive complementarity between these regional organizations and the United Nations in accordance with the provisions of Chapter 8 of the Charter in order to support international efforts aimed at preserving international peace and security. Mr. President, in conclusion, my country believes that the rule of law cannot be fragmented or applied selectively. The rule of law must be respected and applied by all without exception. The Kingdom remains committed to working constructively within this Council and with all partners in order to strengthen the primacy of the rule of law and to support international peace and security on the basis of justice, peace, and international cooperation. Thank you.
I thank the representative of the Kingdom of Bahrain and now give the floor to the representative of Pakistan.
Thank you, President. We wish to congratulate Somalia for its successful presidency this month and for organizing this important debate. We see this as a continuation of a series of high-level debates around the UN, multilateralism, and international law over the last year, including in this Council. I would also like to thank Secretary General Guterres, Chairperson of the AU Commission, Mr. Ali Yusuf, and the founding President of the African Institute of International Law, Judge Yusuf, for their insightful remarks. The Secretary General described rule of law as the beating heart of the UN Charter, and Judge Yusuf urged fully respecting and strengthening it. It is therefore obvious that this debate is timely. The erosion of respect for international law is increasingly translating into conflict, humanitarian crises, and weakened multilateral cooperation. Reaffirming the international rule of law is therefore not an abstract legal exercise. It is a prerequisite for peace, justice, and collective security. The purpose of international law is to inject stability into the international system by making interstate conduct predictable and subject to agreed rules and boundaries. When that function is compromised, international law risks losing its meaning and compliance can become optional. A stable, peaceful, and productive international order can only endure if the rule of law is applied equitably, consistently, boldly, and without discrimination. Yet, today, respect for international law is being tested as rarely before. Selective application of legal norms, erosion of treaty obligations, and unilateral actions have weakened trust among states and strained the multilateral system anchored in the UN Charter. When law yields to power or expediency, instability deepens, disputes entrench further, and peaceful coexistence is jeopardized. The core principles of the Charter, sovereign equality, non-interference, political independence, and territorial integrity, the prohibition of the threat or use of force, and self-determination are being increasingly challenged. Attempts to normalize unilateral actions outside the Charter undermine collective security and weaken the credibility of multilateral institutions. Pakistan itself has experienced such violations. Last May, India carried out an unprovoked military aggression in breach of international law and Pakistan's sovereignty. Acting in accordance with Article 51 of the Charter, Pakistan exercised its inherent right of self-defense in a responsible, restrained, and proportionate manner. Our response established that there can be no new normal based on coercion or impunity. Respect for international law remains the only legitimate norm governing interstate conduct. And that conflict also reminded that the root cause of instability in South Asia remains India's illegal occupation of Jammu and Kashmir in gross violation of Security Council resolutions. The continued denial of the right to self-determination of the Kashmiri people has grave human rights consequences and imperils durable peace in the region. India's unilateral suspension of the Indus Waters Treaty is another blatant breach of international obligations, threatening the lives and livelihoods of millions and endangering peace and security. Pakistan rejects the weaponization of water and critical natural resources. Treaty compliance is a cornerstone of the international legal order. As a country with unwavering faith in international law and multilateralism, Pakistan is committed to pacific settlement of disputes. And this was evident when, within weeks of defeating the military aggression, Pakistan led the unanimous adoption of Resolution 2788 on peaceful settlement of disputes by this Council last July, reaffirming the Council's collective commitment to dialogue, mediation, judicial settlement, and other peaceful means as the first recourse in resolving disputes. President, while some in the West are saying it now, we know that due to double standards and lack of full compliance, the international system has often failed and fallen short of fully benefiting many countries, particularly in the global South. Yet, the developing nations have continued to place their faith in the UN Charter and in an equitable and just international order. Their aspirations for peace, security, and development must remain central to the evolution of multilateralism and the reform of the United Nations. A reform towards equality, democracy, and accountability, away from unbridled power and entitlement. A reform for all, privilege for none. Reinvigorating the rule of law is essential to restoring that confidence. President, but not everything is pessimistic, as Judge Yusuf also pointed out. Despite geopolitical tensions, the international legal framework remains resilient. The entry into force of the BBNJ agreement and the International Law Commission's work on sea level rise demonstrate the capacity to respond to emerging challenges. We also welcome the advisory opinions of the International Court of Justice on Palestine and climate change. These opinions must be respected and applied universally, because selective acceptance would undermine the authority of the court and confidence in international adjudication. As the Secretary General also noted, rule of law is foundational to our work in this Council. It requires full compliance with Security Council resolutions on all items on its agenda. The situation in Palestine starkly illustrates the consequences of selective adherence to international law. The continued denial of the Palestinian people's inalienable right to self-determination, persistent violations of international humanitarian law, and disregard for relevant UN resolutions erode the credibility of the international system and international legitimacy. A just and lasting peace can only be achieved through full respect for international law and equal application of legal principles to all. President, the corpus of international law stems, amongst other sources, from the resolutions of this Council. It is imperative that Member States fulfill their obligation under Article 25 of the Charter to implement the Council's decisions. To strengthen compliance and prevent selective application of international law, we would like to make the following suggestions. First, the Security Council should devise effective mechanisms to systematically monitor the implementation of its own resolutions and to take action in cases of persistent non-compliance. Second, the Council should engage the International Court of Justice more systematically where legal disputes on its agenda risk undermining the implementation of its decisions, particularly in situations of prolonged political deadlock. Third, the Council should institutionalize regular legal briefings by the Office of Legal Affairs on situations on its agenda, including on the legal implications of non-compliance with Council resolutions and international treaties, to ensure that the Council's deliberations and decisions remain firmly grounded in international law. Finally, the UN organs and bodies should have easier and more frequent recourse to ICJ's advisory opinions on specific disputes and on fulfillment of the legal obligations of member states and international organizations. President, the international rule of law cannot be sustained by deliberations alone. It requires consistent conduct and credible accountability. If multilateralism is to endure, law must prevail over force and principles over expediency and justice over impunity. Pakistan remains committed to a UN Charter-inspired, rules-based international order in which disputes are resolved peacefully, obligations are honored, and the United Nations serves as a true guarantor of peace, justice, and dignity for all. I thank you.
I thank the representative of Pakistan for his statement, and now give the floor to the representative of Denmark.
Thank you, Mr. President. Let me also thank the Secretary General, Mr. Ali Youssef, Chairperson of the African Union Commission, and Judge Youssef for their insightful briefings. We commend Somalia for convening this timely debate today. Mr. President, around this table, we must recall that the rule of law is not an abstract principle. For civilians in Sudan, it's the promise that tomorrow will be safer than today. For families in Haiti, it means safety from gangs and a justice system that functions. For communities in Ukraine, and indeed around the globe, it is the assurance that sovereignty matters. Put simply, it's the promise of the UN Charter in action, that relations between nations are built on the law and mutual respect for the law. Today, however, that promise, upon which so many rely and which all of us have committed to uphold, is under unprecedented threat. Urgent action is needed to reverse course and to promote and defend the rule of law. Mr. President, there are many ways to put this principle into practice. However, the first is as fundamental as it is simple. It is upholding the principles enshrined in the UN Charter. Principles of sovereignty, territorial integrity, and political independence. Of all states, without exception. It is resolving disputes peacefully. It is ending immediately the illegal use or threat of use of force. These aspects are foundational and they are non-negotiable. Mr. President, the rule of law is also built on strong, independent legal institutions. Later this year, we will mark the 80-year anniversary of the International Court of Justice. This offers not only an opportunity for celebration, but for recommitment to the Court's central role in upholding international law and the peaceful settlement of disputes. We, the Member States, must fulfill our obligation under Article 33 and seek solutions to any dispute by peaceful means, and we encourage all Member States to accept the compulsory jurisdiction of the Court. Strong independent criminal courts at both national and international level are also essential. Since the International Criminal Court's establishment, Denmark's support for the Court and the Rome Statute has been and continues to be unwavering. As a part of our commitment to the ICC, we are pleased to announce the candidacy of Danish High Court Judge Mette Lyster Knudsen for the upcoming ICC judicial election in December 2026. Mr. President, the rule of law is the backbone of peaceful, just, and inclusive societies. It is vital to both ensuring immediate security and the necessary stability for peacebuilding to take root. It is fundamental to achieve economic and social progress and development, and to ensure the protection of human rights. Denmark believes that this Council must therefore continue to provide strong rule of law mandates in peace operations. Such mandates support and build national institutions and capacities, reduce the risk of conflicts re-emerging, and enable effective transition and exit strategies. At a time of increased financial pressure, they are cost-effective investments in peace. However, our tools will remain ineffective, our resolutions empty words on a page, if we, members of the Security Council, do not muster the political will to use and implement them. Too often, that will is blocked by the misuse of the veto. Denmark's view is clear. It is time to reform the Security Council to represent the world in this century. It is time to restrict the use of the veto and take seriously initiatives to this end. Above all, it's time to break the paralysis and deadlock that too often hinders our work. Mr. President, in closing, the credibility of this Council and of the multilateral system as a whole rests not solely on our decisions, but on the principles we defend. When we place the rule of law at the center of our work, we reaffirm that peace is built on justice and accountability. We remind the countless civilians trapped in conflict that their rights matter, that they matter, that the purposes and principles of the UN Charter continues to guide us. Denmark's support to these principles was resolute 80 years ago, and it remains so today. It will also remain so in the future. I thank you.
I thank the representative of Denmark for her statement, and now give the floor to the representative of China.
Thank you, President. I welcome the initiative of Somalia for convening today's open debate. I thank Secretary General Guterres, Chairman Yusuf of the African Union Commission, and Judge Yusuf for their briefings. For 80 years, driven by the deep reflection on the two world wars, states have worked together to establish an international system with the United Nations at its core, an international order based on international law, and the fundamental norms governing international relations based on the purposes and principles of the UN Charter. Fast forward to today, we're alarmed to witness the resurgence of unilateralism, the rampant rise of power politics, and the unbridled resort to bullying, all of which severely undermine the international rule of law. More than ever, we need to strengthen unity and cooperation, revitalize the rule of law at the international level, and strive to realize the vision of peace, security, prosperity, and progress. First, we must resolutely uphold the purposes and principles of the UN Charter. The United Nations Charter is the fundamental guideline for handling international relations and an important bedrock for stable international order. the myriads of challenges that the world faces today does not mean that the Charter is outdated, but rather that its purposes and principles have not been effectively implemented. All states should treat each other as equals, respect each other's sovereignty and territorial integrity, commit themselves to the peaceful settlement of disputes, oppose the use or threat of force in international relations, and abide by the golden rule of non-interference in the internal affairs of other countries. Secondly, we must staunchly maintain the authority of international rule of law. International law is a common standard that is equally and uniformly applicable to all states. It does not and should not have any exceptions. We never believe that any country has the right to act as international police, nor do we accept that any country can style itself as an international judge. The world cannot revert to the law of the jungle, where the strong prey on the weak. All states must abide by universally recognized international rules, honor commonly agreed international treaties, and fulfill their respective international obligations. Major powers should play a leading role in this regard. They must refrain from double standards or selective application, nor should they impose their own will on others. Third, we must follow the principles of extensive consultation, joint contribution, and shared benefits. An increasingly multipolar world and the democratization of international relations are the irreversible trends of our times. The future of the world should be jointly shaped by all countries. International rules should be formulated by all states, and the benefits of development should be shared by all nations. No single country should dictate terms based on its power, and a winner-takes-all approach is unacceptable. We must advocate and practice true multilateralism, promoting equality of rights, rules, and opportunities among all states, and continuously increase the representation and voice of developing countries in the international system. Fourth, we must support the United Nations in playing its central role. The United Nations is the most universal, representative, and authoritative intergovernmental organization, and an important platform for all countries, especially small and medium-sized ones, to participate in international affairs on an equal footing. The more complex this international situation, the more important it is to uphold the authority and standing of the United Nations. The role of the UN must be strengthened rather than weakened. We shall not cherry-pick our commitment to the organization, nor shall we bypass the UN and create alternative mechanisms. The Security Council bears the primary responsibility for the maintenance of international peace and security. As such, its status and role are irreplaceable. President, the victory of the Second World War defended the moral red line of humanity and gave rise to the modern international law system. 80 years ago, the International Military Tribunal for the Far East tried Japanese war criminals and handed down severe punishment against the main perpetrators whose hands were stained with the blood of peoples of victim countries. The tribunal's rulings upheld international justice, maintained human dignity, and represented a stern warning against any illegal attempts to resurrect militarism or revive aggression and expansionism. Recently, however, Japanese Prime Minister Sanae Takaichi made some regressive statements that defy the tide of history. She blatantly linked Taiwan province of China to the so-called situation of existential crisis for Japan and sent a wrong message, implying Japan's possible armed intervention in the Taiwan question. China's recovery of Taiwan is a victorious outcome of the Second World War and an integral part of the post-war international order. This ironclad fact has been affirmed politically and has irrefutable historical and legal bases. Takaichi's preposterous remarks constitute a brazen intervention in China's internal affairs, an open breach of Japan's international obligations as a defeated state, a wanton challenge to the international order based on international law, and a gross violation of the basic norms governing international relations founded on the purposes and principles of the UN Charter. We urge Japan to face up to the history, reflect on the wrongdoings, and take concrete actions to address the concerns of the international community in a responsible manner. President, more than 70 years ago, China put forward the 5 principles of peaceful coexistence, setting a historical benchmark for the rule of law at the international level. Last year, President Xi Jinping proposed the Global Governance Initiative, with adherence to international rule of law as one of its core principles. As a firm defender of the international rule of law, China has joined almost all universal intergovernmental organizations and acceded to more than 600 international instruments and amendments, faithfully fulfilling its treaty obligations and genuinely honoring its international commitments. China remains committed to working actively with all countries to build a community with a shared future for mankind and make renewed contributions to strengthening the international rule of law and promoting world peace and development. Thank you.
I thank the representative of China for his statement and now give the floor to the representative of the United States.
Thank you, Mr. President. I would also like to thank the Secretary General and our other briefers today. In convening this debate, we appreciate that Somalia has asked us to reflect on the rule of law, not as an abstraction, but as a guarantor of sovereignty, dignity, and justice, and as an element of concrete steps that we can take at the UN to advance peace. Upon his election, President Trump inherited a world on fire. As an answer to this, he did not issue strongly worded letters or theoretical word salad speeches at meetings about meetings. He speaks bluntly, clearly, and he took action. Colleagues, the Trump administration has already taken a number of concrete actions to usher in a new era of peace. These actions include the President's leadership in brokering numerous peace agreements, our consistent calls for compliance with those agreements, and concrete steps in the Security Council to advance peace and further the rule of law. For example, to address the crisis in Sudan, we are actively working with partners to facilitate a humanitarian truce and to bring an end to external military support to the parties. The United States, via President Trump's vision, plays a central role in addressing the situation in the DRC, calling for the DRC and Rwanda to uphold their commitments under the Washington Accords, supporting MONUSCO's role in realizing these historic agreements. Indicating the potential and importance of the role of the Security Council, on Gaza, the Council endorsed President Trump's 20-point peace plan via its historic resolution on the implementation of the peace plan and authorization of an international stabilization force for Gaza. On Haiti, the Security Council also adopted an innovative approach, spearheaded by President Trump, to address the urgent security crisis, authorizing the Gang Suppression Force and the UN Support Office, and taking into account the key roles of regional bodies to include the OAS. These measures are aimed at addressing the drivers of insecurity in Haiti, thereby supporting the rule of law at the national and international levels, and helping the Haitian government to ultimately reassume security responsibility. On Western Sahara, the U.S. penned resolution adopted in October resulted in the Council voicing strong support for negotiations to reach a mutually acceptable resolution based on Morocco's credible and realistic autonomy proposal. The United States has also strongly supported faithful and full implementation of UN sanctions to counter threats and ultimately support stability and the rule of law. This includes the recently renewed al-Shabaab sanctions regime to combat impunity and instability in Somalia, and our continuing efforts to press for full implementation of the Council's reinstated sanctions on Iran, which are targeted at countering the proliferation threats that Iran continues to pose. The regime has posed a threat to international peace and security for decades through violence and intimidation. As a result of putting money in the pockets of terrorists and funding its nuclear and missile programs instead of the basic needs of the people of Iran, we have seen that the Iranian people have had enough. We expect full implementation of UN sanctions measures on the DPRK to address the illicit activities that generate revenue for its WMD and ballistic missile programs. For example, too many countries are failing to implement UN sanctions, thereby allowing North Korean cyber actors and IT workers to continue malicious cyber activities that it uses to fund the unlawful development of weapons of mass destruction. Finally, we continue to take action to safeguard and support freedom of navigation and maritime security. These include countering threats to maritime traffic in the Red Sea and the Gulf of Aden. Unfortunately, we also have to continue to express deep concerns about China's expansive and unlawful maritime claims in the South China Sea that do not have a basis in the law of the sea convention. In closing, Mr. President, the United States, via President Trump's singular commitment to peace and security, remains committed to further advancing the cause of peace around the world. Thank you.
I thank the representative of the United States of America for her statement and now give the floor to the representative of Panama.
Gracias.
Thank you, Mr. President. It is an honor for my delegation to welcome you at your signature event of the Somali presidency, and we appreciate you for organizing this debate. We welcome the convening of this open debate dealing with a highly timely topic at a time when the international order is facing serious threats and challenges. We welcome and are grateful for the participation today of Mr. Antonio Guterres, Secretary General of the United Nations, His Excellency Mahmoud Ali Yusuf, Chairperson of the African Union Commission, and Judge Abdul Qawi Yusuf of the African Institute of International Law. We thank them all for their valuable interventions. President, after the horrors perpetrated during the Second World War, the international community consolidated the essential principles of international law in the Charter of the United Nations. This foundational document, together with other documents covering norms of international law and international humanitarian law and their application, have served as a moral and legal compass in the building of a more just world in which the nations and peoples of the world can coexist in harmony. This rules-based order has allowed us to coexist for 80 years in recognition of our interdependence and of our shared humanity. Through this universal and legally binding framework, we have been able to defend our national interests and address historical and ongoing injustices that threaten global coexistence and continue to be used as strategies of division and domination, such as colonialism, apartheid, segregation, territorial disputes, acts of aggression, and other unilateral measures. However, this system, built upon the sacrifice of millions of human lives and the collective commitment of the world's nations to peace, is under siege. In the current global context, short-term thinking appears to be gaining ground over the vision of sustainable peace upon which the United Nations was founded. In 2024 alone, 2.7 trillion US dollars was spent on military expenditures. This figure represents a development financing gap of $4 trillion. These resources could have been better used to address urgent needs, such as humanitarian assistance, climate adaptation, and education for peace, amongst others. Thus, in a contradictory exercise between discourse and practice, some who claim to defend peace continue to fuel war in a downward spiral that ignores the need to deprive conflict of the resources that sustain it. Mr. President, this challenging scenario works to the detriment of humanity and undermines the credibility of this organization. The perceived erosion of the principles of the Charter does not stem from a lack of legitimacy or effectiveness of the institution, but rather from a chronic deficit of political will and coherence among its member states, especially those vested with the special power of veto. It is urgent that we restore the trust that the world has placed in this organization, and this can only be achieved through concrete actions, such as the urgent reform of this body, amongst others. In the same way, it's also necessary to support peacekeeping operations in their efforts to strengthen the rule of law. It is equally important that this Council continue to grant these operations robust mandates, given their preventive role in reducing the risk of relapse into conflict and in strengthening national capacities. Because we need the United Nations in the same way that the United Nations needs us. In light of the threats facing the international legal system, we believe it is essential to elevate the role of the International Court of Justice and the International Criminal Court, as these bodies represent the backbone of the international rule of law. In this context, it is necessary that from now on, this Council be able to always receive and hear directly from the authorities of both courts as a complement to the reports that we receive. Mr. President, Panama, as a country that continues to place its faith in peace, believes in the collective responsibility that we have to bring to justice those who strive to create more wars, more conflicts, and greater division. In this regard, we believe that the rules-based international order must apply equally to all countries, regardless of size, economic or military power, or any claim to political or moral superiority. If we wish to guarantee international peace and security, we must recognize our sovereign equality under international law. This principle also reminds us that the laws governing relations among states may evolve, they may expand and reorganize, provided that the fundamental principles of the Charter are respected. Then the global standard of dignity and justice established in the Universal Declaration of Human Rights is upheld, the protection of civilians is guaranteed, and the loss of human life is prevented. For this reason, clear limits and red lines that must not be crossed are necessary. Using spurious arguments to violate human rights or to kill innocent civilians are actions that, in bad faith, seek to distort international law. In this sense, strengthening our support for international legal mechanisms for the peaceful resolution of disputes is essential. In July 2025, Security Council Resolution S/Res/2788 was adopted under Chapter 6 of the Charter on the peaceful settlement of disputes. This demonstrates that there remains political will and a shared understanding to commit and move forward together toward the ideals that once united us. It is also crucial to strengthen the role of mechanisms that are already revitalizing the foundations of international law, such as the Peacebuilding Commission and regional organizations through initiatives that promote negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, and peacebuilding. Finally, Mr. President, allow me to express our sincere thanks to the countries of the African continent for their tireless pursuit of peace and sustained dialogue. This pursuit has been made evident through the work of organizations such as the African Union, a continent that, despite having suffered the injustices of colonialism, exploitation, and the appropriation of its resources, persists in its mission to achieve and practice the ideals of a shared humanity, in line with its philosophy known as Ubuntu, embodied by leaders such as Nelson Mandela and Patrice Lumumba. This is a powerful example of the notion of peace building. Peace is only built when everyone benefits. May this principled leadership remind us that it is indeed possible to work for the common good of the peoples of the world. Diplomacy, unlike war, is not and must not be a business. The old politics that gave supremacy to the law of the strongest should have ended with the Second World War. Let us unite so that diplomacy may prevail. Thank you very much.
I thank the representative of Panama for his statement and now give the floor to the representative of France.
Merci, Monsieur le Président.
Thank you, Mr. President. I wish to thank the Secretary General for his briefing, which serves as a reminder of our duties before the Charter of the United Nations, and I thank the Chairperson of the African Union, Mahmoud Ali Yusuf, and the President of the African Institute of International Law, Judge Abdul Kawawi Yusuf, for their briefings. Mr. President, Somalia has quite rightly chosen today's theme on pathways for reinvigorating peace, justice, and multilateralism. The principles of the Charter of the United Nations are the cornerstone of effective multilateralism and international law, and rule of law must prevail over law of force. The principles of the Charter are the linchpin for effective and efficient multilateralism, where international law, sovereign equality of states, and peaceful dispute resolution prevail over unpredictability, power struggles, or war. Violations of international law, including international human rights law and international humanitarian law, are legion, far too frequent, be it in Sudan, the Great Lakes, Gaza, and Ukraine. The desire of certain states to adopt obstructive positions undermine the ability of the Security Council to act, and yet each instance of silence in the light of these violations worsens mistrust and weakens our collective credibility. In this context, we, France, intend to reaffirm our commitment to effective and efficient multilateralism. We remain wedded to the principles underpinning our identity, bringing together a majority of states throughout the world. For example, together with Brazil, with China, Jordan, South Africa, and Kazakhstan, we launched a global initiative for international humanitarian law, heralded by the ICRC, which to date brings together more than 100 states. An international conference for this initiative will be held at the end of this year in Jordan. France also reaffirms our commitment to international judicial institutions and to their independence, specifically the ICJ and the ICC. We emphasize this commitment as we near the beginning of negotiations to establish a multilateral legal framework to better tackle the matter of crimes against humanity. Mr. President, international law is not an abstract notion. International law is a tool of protection of peace through its security architecture, protection of fundamental rights through conventions with a universal mission, a reinforced protection of civilians in times of conflict through international humanitarian law. This protection, this tangible protection, is vital and it must be upheld. This protection must be subject neither to exceptions nor to compromise, and international law must not be invoked selectively. Mr. President, defense of international law is also a recognition of the fact that multilateralism needs to evolve. In 2026, France shall continue to advocate for more representative, more effective and efficient, more operational global governance. We will continue to remain fully engaged in achievement of Security Council reform in order to enhance its representativity and its legitimacy through expansion in the two categories of membership and through enhancement of the African presence within it. We cherish the conviction that reform is possible in this area and that there's a need to begin negotiations on the basis of a draft text without awaiting unattainable consensus. Moreover, consensus which is not required under the Charter. Furthermore, we will continue to promote our initiative, which is jointly being advanced with Mexico, to limit exercise of the veto in the event of mass atrocities. This initiative is currently supported by 107 states. Responsible exercise of the veto is a guarantee for greater effectiveness and efficiency of the Security Council. France will continue to call upon the Security Council to fully shoulder its responsibility and to leverage all tools entrusted to it by the Charter. This includes implementation of Chapter 6, as was the case in Sudan, for example. For the same reason, the Council must not bar itself from referring to the ICJ, whose growing operations reflects its key role in peaceful resolution, architecture for disputes, and enhancement of the law. In a world riven by crisis, international law remains our best guarantee against lawlessness and violence. France will continue at the Security Council and beyond to act for effective multilateralism rooted in law, in accountability, and in respect for international institutions. Thank you.
I thank the representative of France for his statement and now give the floor to the representative of Russian Federation.
Mr. President, we thank the Somalian delegation for organizing the open debate on a very topical and relevant matter of rule of international law for reinforcement of international peace and security. We closely listen to the statement delivered by the Secretary General Guterres. Unfortunately, the Secretary General did not find the time and apparently desired to listen closely to the statements from the members of the Security Council. I do hope that this part of our statement will be conveyed to the Secretary General. We also closely listened to the chairperson of the African Union Commission, Mahmoud Ali Yusuf, as well as the president of the African Institute of International Law, Abdul Qawi Yusuf. The modern-day international law is based on the Charter of the United Nations in all of its integrity, is an asset of humanity, the protection of which is one of the main objectives of our organization. And the principle of the United Nations Charter is not a menu from where one can pick provisions geopolitically beneficial to former Western partners. These former Western partners. This is a holistic document in all of its integrity, and it is interconnected. And if you turn to one principle enshrined in the Charter, do not forget to quote the others. The principle of sovereign equality of states, which gives a vote to all states irrespective of their size, economic and military capabilities. The principle of self-determination of peoples, which allow them to throw off the colonialist shackles for the majority of countries in the world. The principle of the prohibition of use of force other than in accordance with the Charter of the United Nations, which continued to prevent a global catastrophe of a world war. This is a norm without which humankind cannot exist, at least in the form that can be called humanity. The world where there is legitimacy for intervention in domestic affairs of states and disrespect for their immunity and independence is a fertile ground for economic and technologically powerful states, and their victims must obediently accept this reality. We will not forget the meticulous sweeping under the rug of the principle of cooperation. Ask yourselves, when was the last time you heard about the existence of it? And yet this principle is just as much a legal principle as the above mentioned. Moreover, the International Court of Justice rightly stated that in accordance with Article 1 of the Charter of the UN, the pillars of organization, in addition to the maintenance of international peace and security and conducting international cooperation in resolving international problems of an economic, social, and humanitarian nature, is the development of friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples. Do we remember that? And the 1970 Declaration speaks of the same. Who at the organization is working to make this objective a reality? Not a single one of the reforms being carried out today, not a single one of these reforms even mentions that. Mr. President, we all see what is transpiring in this world against the backdrop of events which took place in just the first few weeks of 2026. A legitimate question arises. Is international law not mere noise? Perhaps we would be well advised to acknowledge it as being dead, and perhaps we should turn to the idyllic world, the idyllic garden of rule by force. Here there's a need to recall how modern-day international law was established. This was not the product of academic professors or romantic thinkers. The Charter of the United Nations and the body of the core multilateral conventions were written down by people who endured the agony of the Second World War, who saw firsthand how a world where respect for treaties began to be viewed as a mere formality looked, where a single state proclaimed itself to represent the exceptional race with rights to the resources of its neighbors near and far, where populations residing on these territories had to either be decimated or simply to die of starvation. These very people who achieved a victory over the hideous ideologies of fascism, Nazism, and militarism set out the above-mentioned principles and founded the organization whose aim is to defend them. It is indeed those who managed to prevail in the armed and economic struggle against evil, determined that military and economic might must not rule the world. These are the people who gave pride of place to cooperation, not confrontation, even though at that time they were divided by stark ideological barriers. These were the people who enshrined in the UN Charter that, I quote, "We, the peoples of the United Nations, determined to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained." End of quote. Mr. President, far from all of the objectives placed before the organization have been met. For some time, it appeared that ideological confrontation stood in the way. However, when it ended, it seemed that an epoch of peace and economic cooperation and prosperity should have been ushered in. Something went awry. We began to be told, and we continue to be told, that the principle of cooperation and the establishment of friendly relations exist only for the chosen or the anointed, and economic warfare for purposes of sonority named sanctions is a legitimate tool and a norm of international law. That technological cooperation needs to be organized in such a way as to, for centuries, entrench the technological delays of developing nations. That expansion and rearmament of the military bloc of NATO, which was punctuated by a spate of illegal armed actions from Yugoslavia to Libya, that this is a measure that facilitates the attainment of peace and security. And the country against which this bloc and alliance was established needs to calmly behold the advancement along its borders of high-tech military infrastructure. In 2007, in Munich, President Putin directly put forward the question, against whom is this aggression intended, this expansion intended? And what happened to the assurances our Western partners made after the dissolution of the Warsaw Pact? Where are those declarations today? Nobody even remembers about them. Mr. President, the ideologues of this aggressive approach were confident and even openly stated that the Russian Federation would remain silent, even if this expansion is conducted in breach of existing international legal obligations, as was the case with Ukraine, which assumed the obligation not 2, participate in military alliances in its declaration on state sovereignty. And subsequently, also, the Treaty on Cooperation with Russia assumed the obligation not to allow its territory to be used to the detriment of the security of the Russian Federation. Russia had to remain silent even when, in order for the expedited implementation of the plans to transform the country into an anti-Russia in Ukraine, a Western-sponsored coup was carried out with the participation of neo-Nazi groups, and the government, which seized power, essentially became the avatar of NATO forces, which unleashed warfare against the Russian residents of Donbass and who do not even wish to put an end to this date. In this way, a unique opportunity was allowed to slip away, a unique opportunity for meaningful, genuine cooperation for the benefit of all, not for the benefit of some, and the world spiraled into confrontation. As President Putin stated in the above-mentioned statement in 2007, in international relations, increasingly there's a desire to resolve a given question according to so-called political expediency. And this, of course, is exceedingly dangerous, and this results in the fact that nobody feels safe any longer because nobody can hide behind international law as behind a stone wall. End of quote. Some of our European partners are now feeling this firsthand. This is how their so-called rules-based international order works. This order which they themselves advanced, and now they are its victims. The revolution, as is known, is devouring its own children. Mr. President, let us pose a question. Was this a rational choice even for those who opted for confrontation? We believe no. The world is falling into the abyss of geopolitical economic crisis, which is causing suffering even for the populations of those countries who banked on domination through force. We believe that the way out of the multifaceted crisis does not lie, contrary to the beliefs of the elites of those countries, does not lie through building the idyllic garden behind whose barbed enclosure the majority of population is suffering. We mustn't allow for the most dreadful predictions of fantasy writers to materialize, where people are divided into the privileged ones who enjoy longevity and those with short lifespans who provide for the well-being of the former. For this reason, restoration of respect for international law is not a theoretical challenge, but it is the only path to salvation of humankind. If we allow this opportunity to slip away, there may be no second chance. Mr. President, we believe that not a single sensible person would like to live in a world where, for example, international law of the sea does not work, where freedom of navigation in the open seas can be threatened through acts of force based on domestic legislation of certain states, where, in breach of international aviation law, civilian aircraft does not fly, which falls under national prohibitive measures, where the sovereign assets of states protected under immunity, money earned by entire populations, where these assets can be stolen by a posse of greedy global elites who for many long years have been plundering humanity using fraudulent financial institutions, not to mention the abduction of a head of an independent state on the basis of an arrest warrant issued by a municipal district court of a certain country. A world living on the basis of these rules can hardly last long, and if it does, then it will hardly be a world of humanity. Rather, this will be a dystopian hellscape. Mr. President, we all must fight for international law. Each voice here counts. The fight for international law is a fight for the standard meaning of words, where violation is called a violation. We are aware that for many countries, speaking truth is an act of courage, which is frequently fraught with threats and coercion. But defense of truth is no easy feat. An important role in this fight falls to the United Nations. Now we must recognize that the United Nations is not at its best. In order to remedy this situation, it must revert back to independence and not take the side of the mighty and the wealthy as it is currently doing. This is a difficult task, but we must prevail. Otherwise, the United Nations will lose its role and significance with catastrophic consequences for the entire world. Thank you.
I thank the representative of Russian Federation for his statement. I now give the floor representative of China who asked for the floor. Latvia and China. No, sorry, my apology. I'll give the representative of Latvia to the floor.
Thank you, Mr. President. We thank the Somali presidency for choosing the rule of law as theme for today's signature open debate, which is both essential and timely. We thank Secretary General, His Excellency Antonio Guterres, Chairperson of the African Union Commission, His Excellency Mahmoud Ali Yusuf, and founding President of the African Institute of International Law, Judge Abdullah Kafi Yusuf, for their insightful briefings. Mr. President, my country's history reflects both the fragility and the resilience of international law. When the principles of the United Nations Charter are upheld, nations can reclaim their independence and build free, democratic, and prosperous societies. When those principles are disregarded, the cost is measured in human suffering and denial of fundamental rights. The rule of law is not merely a set of norms. It is a vital shield against tyranny, oppression, and violations of human rights. In this context, I would like to make 3 points. First, the rule of law is what transforms power into responsibility and vulnerability into rights. It is a dividing line between a world governed by rules and a world governed by force. By translating sovereign equality into legal equality, the rule of law provides stability, predictability, and protection for all states, regardless of size or influence, and supports cooperation based on mutual respect. Upholding the rule of law is not a concession by major powers, but it is a strategic necessity that serves long-term interests of the entire international community. Second, the Charter provides a clear legal framework for maintaining international peace and security. Its provisions must be applied fully and consistently, not selectively. The norms of the Charter are binding legal commitments that form the backbone of international peace and security. In this context, consistent application of peaceful settlement mechanisms, as reflected in the Article 33 of the Charter, would strengthen preventive action and reduce both the risk of escalation and the number of conflicts. Likewise, respect of the Article 27.3 would further support the proper functioning and credibility of the Council by ensuring that decision-making reflects restraint and adherence to the Charter framework. Third, reaffirming the rule of law requires more than rhetoric. It requires consistency. It requires that same rules are applied by all states without exception. It requires credible accountability for grave violations of international law, including violations of international humanitarian law. And it requires the Security Council to act in a manner that reinforces legality, predictability, and respect for international law, as affirmed by multiple presidential statements in the past. Mr. President, as we mark the 80th anniversary of the United Nations, this Council has a responsibility to demonstrate that international law still matters. Upholding the rule of law is not about constraining states, it's about protecting them, all of them. Latvia stands ready to work with all members of the Security Council to strengthen respect for the rule of law and to ensure that the principles of the Charter continue to safeguard present and future generations. I thank you.
I thank the representative of Latvia for his statement and now give the floor to the representative of Liberia.
Liberia thanks Somalia for convening this important debate and the distinguished briefers for their insightful contributions. Mr. President, Excellencies, we are meeting at a time when the international legal order, the foundation of multilateralism, is being tested not by the absence of rules, but by uncertainty in application. The question before us is not whether international law exists. It is whether it still governs conduct when it matters most. For Liberia, the rule of law is practical, not ornamental. It does govern conduct. As the briefers and many speakers before us have rightly pointed out, the rule of law allocates responsibility. By producing consequences, it serves as a guarantor of peace and security. Guiding the interaction among states, international law is the architecture that makes peaceful coexistence possible. In a system of unequal powers, international law allows sovereignty to be more than a mere declaration, and peace to be more than a pause between conflicts. Liberia was present in San Francisco in 1945 when this journey began, one of only 4 African countries. Liberia therefore feels it has the credibility to say the Charter of the United Nations was drafted with clarity of purpose. It did not promise convenience. It promised restraint. It did not privilege power. It disciplines it. Its objections and obligations are not optional, and its principles were never intended to apply selectively. The Charter assumes something fundamental, and it is that peace cannot be sustained if rules are treated as discretionary, or if commitments are honored only when aligned with immediate interests. It places responsibility where it truly belongs, on all states without distinction, recognizing that influence brings obligation, not exemption. Mr. President, the credibility of the international system depends on consistency. All of the briefers have made this point clearly. When international law is invoked in one context and disregarded in another, trust erodes, not only in specific outcomes, but in the system itself. Over time, this weakens deterrence, fuels grievance, and erodes the predictability on which international peace and security depend. Africa's recent experience offers a different path. Across the continent, states have increasingly turned to judicial and arbitral mechanisms to resolve boundary and maritime disputes. These decisions have not always been easy, but they have been respected and they have been necessary. What's more, they have prevented escalation in conflicts. They have demonstrated that law, when used, actually works. Yet, these gains are fragile. Confidence falters when access to justice appears uneven, when accountability is constrained, or when compliance becomes negotiable. A system perceived as unequal cannot command lasting respect. Certainly, this council can agree to that. There is an African proverb that captures these stakes. When the elephants fight, it is the grass that suffers. Today, the grass is suffering. Civilians in conflict zones, smaller states navigating geopolitical rivalries, and communities bearing the consequences of decisions taken too far from their own realities. The erosion of legal restraint does not remain abstract. It produces human cost. Mr. President, Excellencies, peace is not sustained by declarations alone. It is sustained by conduct, predictable, restrained, and consistent with agreed rules. The Charter provides tools, useful tools, for this purpose, and they include negotiation, mediation, arbitration, judicial settlement, and regional arrangements. These mechanisms are not signs of weakness. They are truly safeguards against escalation and insecurity. When they are bypassed, ignored, or applied unevenly, the Council's preventive capacity ultimately diminishes. Liberia believes the Security Council can restore confidence and reinvigorate multilateralism by acting with greater discipline in 3 areas. 1, by affirming clearly and consistently the binding character of international judicial decisions and encouraging their use as instruments of prevention, not last resort. 2, by strengthening operational coherence between the Council and regional mechanisms, particularly in Africa, so that political engagement, mediation, and legal processes reinforce rather than undercut one another. 3, by exercising restraint and consistency in the interpretation and implementation of Charter obligations, ensuring that Council action reflects principles, not expediency. Mr. President, Excellencies, as many have already noted, this year marks 80 years since the adoption of the United Nations Charter. The Charter's relevance has not diminished. What is at issue is fidelity to it. If we want a system governed by law rather than leverage, then adherence must be uniform. If we want peace that lasts, then justice cannot be selectively applied. And if multilateralism is to remain credible, then this Council must lead by example. This is why, for Liberia, the choice before us is not between law and politics. It is whether politics will continue to be guided by law, as we promise it will be, to ensure global justice, equality, security, and peace for all of mankind. I thank you.
I thank the representative of Liberia for his statement, and now give the floor to the representative of Colombia.
Gracias, señor. Thank you, Mr. President. I'd like to thank Somalia for proposing this very timely, open debate, and I would like to thank the Secretary General and the briefers for their presentations. Mr. President, the rule of law has been and must continue to be the cornerstone of the multilateral system. Today, more than ever before, the world needs to reaffirm that all power is subject to the law, and that international law constitutes the common ground that makes peaceful coexistence among nations possible. The Charter of the United Nations continues to be our guide and essential reference. In the face of the serious challenges confronting humanity, the genocide in Gaza, interference in the internal affairs of other states, the intensification of conflicts in various regions of the world, or the climate crisis, it is imperative to recall that the Charter is not a programmatic text. No, it's a legally binding treaty that obliges all states by virtue of the principle of pacta sunt servanda. Respect for sovereign equality, the prohibition of the use of force, the peaceful settlement of disputes, and the good faith fulfillment of international obligations are not abstract principles, they are concrete guarantees of international peace and security. No state may invoke particular interests to depart from the principles of the Charter, nor forget that weakening international law undermines the multilateral order and increases the risk of conflict. Defending the international rule of law is, in essence, defending stability, predictability, and peaceful coexistence. Colombia likewise believes that any national, regional, or global strategy to address new threats to the rule of law must be grounded in what is prescribed in the Charter, a text that provides the necessary tools to respond to the challenges that we face as societies. Any collaborative process must adhere to its purposes and principles, and must also take into account the differing contributions of countries, given their varying levels of development, to the causes of those challenges, as well as their respective capacities to respond to them. For its part, the Council must contribute to strengthening the rule of law in each of its actions. It must reinforce the fundamental principles and purposes of the Charter, not depart from them, and recognize that, whilst threats may evolve, responses must remain anchored in the existing legal framework. Even in light of the evolving concept of threats to peace under Article 39, the international legal framework itself provides the tools necessary to respond in a legitimate and effective manner. Additional instruments available to the Council, such as the establishment of peacekeeping operations or special political missions, also serve preventive functions by reducing the risk of relapse into conflict and strengthening national capacities. Any response, however, must emanate from the principle of cooperation among states and must consist of collective and coordinated interventions with the organization at their center. Accordingly, we call for the actions of the United Nations and its member states to focus on complementing efforts and work in a harmonious and concerted manner. Now, having said that, we believe that there could be better coordination within the UN itself, and that the respective mandates of entities across the system could be implemented more coherently and therefore enhance their impact. All that is required for this is the political will of the community of states. The Sixth Committee of the General Assembly and the Special Committee on the Charter are natural fora for such coordination. The Secretary-General's annual report on the strengthening and coordination of UN activities aimed at promoting the rule of law should serve as the starting point for these discussions. The Council, for its part, must continue to be the privileged political forum for discussing issues related to the rule of law when these affect international peace and security. The Council also bears the responsibility of providing robust mandates and issuing instruments that are always anchored in international law, in all its actions and in every context. Mr. President, Colombia would emphasize that the full application of international law is the only way to respond to the multiple challenges that we face together, and it is also the only possible means of ensuring their sustainability and effectiveness over the long term, as well as fostering a sense of ownership among local communities. The rule of law has been the achievement of all of our countries, built over decades, and as the result of our collective decision to establish it as a central element of our joint action. There is no better alternative, and the well-being of all our citizens depends on its implementation and respect. The 80th anniversary of the organization offers us a timely opportunity to renew commitments. Colombia therefore invites the members of this council to defend the Charter as the supreme framework for international coexistence, without downplaying it when it limits the use of power in favor of law, to promote the rule of law without selectivity, convenience or undue interference, and to ensure an inclusive and gender-responsive approach across all policies and programs. Lastly, Colombia reiterates its strict adherence to international law in each and every one of its actions and invites the states of this council to do the same. Thank you very much.
I thank the representative of Colombia for her statement, and now give the floor to the representative of United Kingdom.
Thank you, President. I thank Somalia for convening today's meeting on this important topic. We also thank the Secretary-General and the Chairperson of the African Union Commission and Judge Yusuf for their briefings. The United Kingdom's ongoing commitment to the rule of law is a key part of our national story, beginning over 800 years ago when the Magna Carta was signed, guaranteeing rights to justice and a fair trial. The rule of law remains fundamental to the international system. It is the bedrock of stable democratic societies and prosperous economies. As embodied in the UN Charter, it is key to the maintenance of international peace and security. We must never lose sight of why nations first came together in this forum and the principles that continue to bind us together. Respect for international law is fundamental to offering a better future to citizens from the Middle East, to Sudan, to Haiti and beyond. And of course, in Ukraine, which has been on the receiving end of an egregious breach of the UN Charter. President, the UK stands firm in our support for the institutions which defend and advance the international rule of law. The International Court of Justice's demanding workload is testament to its impartiality, independence, and legal rigour. We also remain steadfast in our support for the International Criminal Court and its vital work to end impunity for the gravest crimes. The UK believes that international law delivers real benefits and helps us address contemporary global challenges. For example, the recent entry into force of the BBNJ agreement marks a major milestone in safeguarding our shared marine environment. As we speak, work towards a convention on crimes against humanity is underway, representing a significant opportunity to strengthen prevention and accountability. And progress on a draft convention for the protection of persons in the event of disasters reflects the importance of legal frameworks that enhance preparedness and cooperation. These efforts show what is possible when states work collectively to build and refine the international legal order to address new and emerging challenges. In this context, the UK was pleased to recently pledge additional voluntary contributions to a range of UN funds supporting participation in these initiatives and the rule of law. These include the UN Programme of Assistance on International Law, the operationalisation of the BBNJ Agreement, participation of developing states at the PPED Negotiating Conference, and the ICJ Judicial Fellowship. President, the UK's enduring commitment to the rule of law is unwavering, reflecting our firm commitment to peace, international cooperation, accountability, and to the UN Charter. I thank you.
I thank the representative of the United Kingdom for his statement. I now give the floor to the representative of Greece.
Mr. President, as we reflect on the 80th anniversary of the UN Charter, this debate offers an opportunity not only to reaffirm principles, but to renew political commitment. Revitalizing multilateralism requires ensuring that international law guides action, rather than follows it. It means ensuring that international law and the UN Charter apply to states in the same way that might does not make right. That solidarity and responsibility towards each other prevail over war, repression, and polarization. Indeed, Greece attaches great importance to the preeminence of international law, respect for the UN Charter, the resolution of disputes among states through peaceful means, including recourse to judicial proceedings. We wish to highlight the following points as regards the international rule of law as a pillar of multilateralism and as a means to achieve justice and peace. First, a major achievement regarding the rule of law and at the international level and multilateralism relates to the conclusion of a wide range of important multilateral treaties under the auspices of the United Nations, a number of which contain provisions on dispute resolution, judicial or non-judicial. We underscore in this respect the advancement of the rule of law within the United Nations in the framework of the protection of human rights contemplated in Article 1, Paragraph 3 of the Charter through the conclusion of the core human rights conventions. Major achievements of multilateralism regarding the international rule of law also include conventions such as those on the law of the sea, a major achievement in this respect being the United Nations Convention on the Law of the Sea as regards its universal and unified character. We welcome in this regard the recent landmark development with the entry into force on the 17th of January 2026 of the BBNJ agreement. The agreement implements UNCLOS and sets specific legally binding provisions on the conservation and sustainable use of marine biological diversity in areas beyond national jurisdiction. Second, Greece wishes to underscore the impact of the jurisprudence of the International Court of Justice on the settlement of disputes and of its advisory opinions on the clarification and consolidation of international law. Besides, alongside the ICJ, the jurisprudence and advisory opinions of regional and sectoral courts and tribunals are providing considerable contributions regarding the interpretation and application of international law. Third, serious challenges are, however, present or lying ahead. We must absolutely counter the increasing trend around the world of actions which undermine multilateralism, its institutions, and the international rule of law. A world without the rule of law at its core pillar is a more dangerous, a violent world. A world without peace or justice, particularly for smaller states. The Security Council bears a particular responsibility in this regard. When violations of international law go unaddressed, the credibility of the Council itself is at stake. Reaffirming the rule of law must therefore be accompanied by a renewed commitment to restraint, consistency, and support for peaceful settlement and accountability mechanisms. In this context, threats or use of force against the territorial integrity of states in stark violation of Article 2, Paragraph 4 of the Charter continue unrelenting. In a number of instances, these threats are also directed against states which are invoking a legal right that is well established under international law. Furthermore, in a number of cases, states parties to international disputes are taking actions aggravating or endangering the maintenance of international peace and security or impeding the peaceful settlement of disputes. They equally disregard decisions of the International Court of Justice and other international tribunals. Moreover, important legal gaps on criminal accountability still exist. There is no legal binding international instrument currently in force on the prevention and punishment of crimes against humanity. The process leading to the convening of a UN diplomatic conference to elaborate and conclude a legally binding instrument has just started. Moreover, the number of states accepting the optional clause of the Statute of the International Court of Justice showed no significant increase in comparative terms for years. Lastly, Mr. President, the rule of law at the international level has an obvious impact on the domestic level as regards accountability mechanism, a comprehensive system of judicial remedies, and a range of independent authorities and institutions. Transparency, the fight against corruption and organized crime, as well as the respect of international human rights law, constitute essential components reflecting developments at the international level. In concluding, the rule of law at the international level, multilateralism, and the peaceful settlement of disputes are closely intertwined. Their enhancement leads to justice among nations and to the maintenance of peace and security internationally, with tangible effects also on the rule of law at the domestic level. Greece will always stand on the side of the international rule of law and all efforts to enhance peace, justice, and multilateralism. Thank you.
I thank the representative of Greece for her statement and now give the floor to the representative of Democratic Republic of Congo.
Monsieur le Président.
Mr. President, the Democratic Republic of the Congo would like to congratulate the Federal Republic of Somalia on its presidency of the Security Council, and we thank you for organizing this open debate. I'd also like to take this opportunity to thank the Secretary General of the United Nations, Mr. Antonio Guterres, as well as the Chairperson of the African Union Commission, Mr. Ali Yusuf, and finally Judge Abdul Qawi Yusuf, founding President of the African Institute of International Law. This debate is being organized at a pivotal time as we celebrate the 80th anniversary of the Charter of the United Nations. A country affected by armed conflicts, the Democratic Republic of the Congo remains deeply committed to the promotion of international peace and security founded on respect for the rule of international law. Mr. President, 80 years after the adoption of the Charter, the Security Council is called upon to engage in a clear-eyed reflection on the progress achieved, but also with regard to the persistent challenges relating to respect for the rule of law among nations. The gradual erosion of this normative foundation weakens multilateralism, and it fuels a crisis of confidence in international institutions. International rule of law constitutes the cornerstone of the multilateral system. It is based on respect for the UN Charter, on the good faith observance of international obligations, as well as on the strengthening of the organization's three pillars: international peace and security, human rights, and development. Mr. President, the principles enshrined in the Charter, particularly respect for the sovereignty, territorial integrity, and the prohibition of the use of force, continue to be severely tested in several regions of the world. These recurring violations undermine the credibility of the international legal order and weaken trust among states. In this regard, the persistent security situation in the eastern part of the DRC illustrates the challenges facing the multilateral system when the fundamental principles of the Charter are not fully respected. Despite my country's engagement in regional mechanisms for the peaceful settlement of disputes under the auspices of the African Union, and in accordance with Chapter 8 of the Charter, results on the ground remain below expectations. This reality recalls the importance of the effective implementation of Security Council decisions, particularly those calling for strict respect for territorial integrity and the cessation of any unauthorized foreign military presence. Mr. President, multilateralism is currently going through a phase of weakening marked by the resurgence of armed conflicts, the rise of unilateralism, and the effects of global crises. In this context, it is imperative to reaffirm that the international rule of law remains the preferred path for preventing conflicts, promoting justice, and ensuring lasting peace. Chapter 6 of the Charter of the United Nations relating to the peaceful settlement of disputes remains an essential and sometimes underutilized tool. Its more systematic activation, combined with increased recourse to mediation, preventive diplomacy, and international judicial mechanisms, would help substitute law for force in the conduct of international relations. Mr. President, strengthening the international rule of law also requires better coordination among the various organs of the United Nations in full respect of their respective mandates. Coherent action by the Security Council, the General Assembly, the International Court of Justice, and regional organizations would enhance the legitimacy and impact of collective efforts in favor of peace. As part of all of this, regional organizations, particularly African ones, are playing an increasingly important role in the peaceful settlement of disputes and in strengthening the legal and institutional capacities of states. Mr. President, the Democratic Republic of the Congo calls upon the Security Council to fully assume the responsibility entrusted to it under Article 24 of the Charter by placing the promotion and strengthening of the rule of law at the heart of all United Nations actions. This notably entails rigorous implementation of adopted resolutions, increased support for fragile states, and coherent use of the instruments at the Council's disposal. Furthermore, in situations of conflict, it remains crucial for the Council to ensure that humanitarian actors are guaranteed unimpeded access in order to assist civilian populations needing aid. In conclusion, the Democratic Republic of the Congo reaffirms its unwavering commitment to the ideals and principles of the Charter of the United Nations. It remains engaged in collective action aimed at building an international order founded on law, justice, and multilateralism, guarantors of a lasting and inclusive peace. Thank you.
I thank the representative of the Democratic Republic of the Congo for her statement, and now give the floor to the representative of China, who has asked for the floor to make further statement.
Thank you, President. China firmly rejects U.S. representatives' erroneous remarks on the issue of the South China Sea and is compelled to make a stern response. I wish to emphasize that China has indisputable sovereignty over Nanhai Zhudao and the adjacent waters, and sovereign rights and jurisdiction over relevant waters. China's territorial sovereignty and maritime rights and interests in the South China Sea are grounded on solid historical and legal basis. I also wish to remind the U.S. representative that the United States is not a party to UNCLOS, and it has no right to presume itself as a judge of UNCLOS and point fingers at other countries. The United States, in total disregard of the historical context and objective facts regarding the South China Sea, has been stirring up trouble and sowing discord everywhere. It has even deployed offensive weapons, including land-based intermediate-range missiles in the South China Sea, and under the pretext of freedom of navigation, has frequently dispatched advanced ships and aircraft for military reconnaissance and drills in the South China Sea, and intruded into China's territorial waters and space, as well as waters and airspace surrounding China's islands and reefs. Who is engaging in coercive and bullying practices in the South China Sea? Who is disrupting regional stability and threatening navigational freedom and security? Who is undermining international rule of law? The facts are self-evident. Thank you, President.
I thank the representative of China for his statement. And I wish to remind all speakers to limit their statements to no more than 3 minutes in order to enable the Council to carry out its work expeditiously. The flashing lights on the microphone will prompt the speakers to bring their remarks to a close after 3 minutes. I now give the floor to the representative of Kazakhstan.
Mr. President, I thank Somalia for convening this open debate and for selecting the theme which rightly stands at the center of the Security Council's agenda. Kazakhstan views the rule of law as a central pillar of international peace and security. Lasting peace is impossible without the rule of law, and international peace and security can be maintained only on the basis of the Charter of the United Nations. Today, it is crucial to reaffirm once again the rules agreed by all member states must be respected by all. This common understanding has underpinned the Council's previous deliberations aimed at a deeper discussion of how, within the United Nations, we can uphold peace and security through the promotion of the rule of law. In this regard, Kazakhstan highlights several priorities. An important element of the rule of law is strict compliance with international law. Selective application of norms, double standards, and the politicization of legal mechanisms undermine the international order. We call on all states to refrain from the threat of use of force, to respect sovereign equality and territorial integrity, and to resolve disputes exclusively by peaceful means. We equally call for the fullest compliance with the existing international norms against the use or threat of use, as well as testing of nuclear weapons or any other types of weapons of mass destruction. In this regard, we believe the upholding of existing CTBT and NPT regimes to be a key collective priority. The Treaty on the Prohibition of Nuclear Weapons that marked the 5th anniversary since its entry into force just a few days ago is also becoming an integral part of the international legal architecture, with the majority of the UN member states having joined it. We also note the particular importance of the global initiative to galvanize political commitment to international humanitarian law launched by Kazakhstan together with a group of states and the International Committee of the Red Cross. To date, 99 states have joined the initiative. In this regard, we encourage all states to engage actively in its implementation and to participate in the high-level conference on humanity in war scheduled to take place later this year in Amman, Jordan. Moreover, where serious breaches of international law occur, it is important for the international community to act consistently and to ensure that existing mechanisms function effectively. The Security Council should therefore support the strengthening of national justice systems and the rule of law in post-conflict societies. In this regard, UN peace operations play an important role in supporting national institutions, including judicial, police, and rule of law structures. Kazakhstan underscores that strengthening the rule of law should be regarded as an integral and strategic component of peacekeeping, contributing to sustainable peace and nationally owned post-conflict recovery. Enhancing the role of international justice and the peaceful settlement of disputes also remains an important priority. Kazakhstan supports close interaction between the Security Council and the International Court of Justice and calls upon states to implement in good faith the decisions of the principal judicial body of the organization. Mr. President, Kazakhstan is convinced that strengthening peace and justice and multilateralism begins with the return to the letter and spirit of the Charter of the United Nations and with respect for international law as our shared language of security. We stand ready to work with all members of the Council to reinforce the legal foundations of conflict prevention, mediation, and peace building so that international law once again becomes not a subject of dispute, but a pillar of trust. I thank you.
I thank the representative of Kazakhstan for his statement and now give the floor to the representative of Egypt.
Sayyid Rais.
Mr. President, allow me at the outset to thank Somalia for its initiative in convening an open debate on this important topic. I also thank Mr. Antonio Guterres, Secretary General of the UN, for his statement. I would also like to extend my sincere thanks to His Excellency Mahmoud Ali Yusuf, Chairperson of the African Union Commission, as well as the esteemed Judge Yusuf for their valuable briefings. The United Nations was established after decades of severe human suffering and a harsh historical experience, through which the international community came to realize that the logic of power and force would only lead us all toward further tragedies, conflicts, and disputes. Thus, the United Nations Charter emerged to embody the will of humanity to turn the page on the past and rebuild a new international order one that safeguards international peace and security, strengthens cooperation among nations, upholds human rights, grants peoples their freedom and right to self-determination, and enables them to achieve development and prosperity. Despite our firm adherence to the UN Charter and its principles, yet we must acknowledge that the international system that was established 8 decades ago and reshaped later after the end of the Cold War is now undergoing profound transformations. It has experienced a state of fluidity and uncertainty and suffers a decline in its credibility and effectiveness. The gap continues to widen between the provisions and principles of the Charter and the practices observed on the ground. Growing polarization, friction, tension among major powers have also weakened multilateral institutions and undermined their effectiveness. The selective application of international law and persistent grave violations of its rules, along with the inability to enforce United Nations resolutions, all have caused that many of our peoples lose confidence in the fairness of the international system and its ability to protect them. Acknowledging these challenges is not intended to undermine multilateral action or diminish the role of the UN. Rather, it represents an effort toward candor and transparency to develop a clear and realistic vision for the steps required to restore confidence in the organization and in multilateral mechanisms. Egypt believes that the ongoing efforts to reform the United Nations, foremost among them the UN80 initiative, these efforts must be seen as an opportunity for an objective assessment of the organization's performance and its various bodies, with the aim of restoring their effectiveness, developing their working methods, enhancing their efficiency, and improving their ability to respond to current challenges. This requires that the reform process be comprehensive, participatory, and transparent, that it is based on the priorities of all member states, particularly developing countries. In conclusion, Egypt affirms that the international peace and security is subject to our ability to safeguard the Charter and the rules of international law, and to give priority to multilateralism and joint action. As such, we reiterate our commitment to work with all partners in order to strengthen and enhance the effectiveness and credibility of the UN and safeguard its pivotal role as a place for all of us to work collectively to achieve peace and security. Thank you, Mr. President.
Thank the representative of Egypt for his statement, and now give the floor to the representative of Philippines.
Thank you, Mr. President. I have the honor to deliver this statement on behalf of the member states of the Association of Southeast Asian Nations, Brunei Darussalam, Cambodia, Indonesia, Lao People's Democratic Republic, Malaysia, Myanmar, Singapore, Thailand, Timor-Leste, Vietnam, and the Philippines. We thank Somalia for convening this debate at a time when the world is facing increasingly complex and cross-cutting challenges to the rule of law. ASEAN reaffirms its strong commitment to upholding multilateralism and a rules-based international order. ASEAN member states stress the utmost importance of upholding the principles of the Charter of the United Nations, including the principles of sovereign equality of states, respect for sovereignty, territorial integrity, and international law. We affirm our commitment to the Declaration on Principles of International Law concerning friendly relations and cooperation among states in accordance with the UN Charter. We also continue to promote the rule of law in all its aspects and affirm our commitment to peace and security, good governance, and the promotion and protection of human rights enshrined in the ASEAN Charter. In this regard, ASEAN reaffirms the importance of upholding international law, including the UN Charter and the 1982 UNCLOS, as well as ASEAN's shared values and norms enshrined in the ASEAN Charter and the Treaty of Amity and Cooperation in Southeast Asia, among others. We further emphasize the importance of strengthening preventive mechanisms in addressing emerging and existing challenges to promote peace and security, including through diplomacy, confidence-building measures, and inclusive dialogue, in line with international law and ASEAN's long-standing commitment to conflict prevention. Mr. President, as a rules-based intergovernmental grouping, ASEAN is committed to stability and security in the region. ASEAN treaties and instruments have paved the way for our success. ASEAN member states continue to work with China towards the early conclusion of an effective and substantive code of conduct in the South China Sea, consistent with international law, including UNCLOS, and within a mutually agreed timeline. Mr. President, ASEAN is committed to strengthen the ASEAN community and the peaceful resolution of disputes, including through the respect for legal and diplomatic processes without resorting to the threat or use of force, in accordance with the universally recognized principles of international law, including UNCLOS. As we mark the 80th year of the Charter and the 50th year of the Treaty on Amity and Cooperation, ASEAN reaffirms the rule of law and underscores the importance of reinforcing its role through the observance of international obligations in good faith, the peaceful settlement of disputes in accordance with international law, including the Charter of the United Nations, the prohibition of the threat or use of force against the territorial integrity or political independence of any state, and the strengthening of multilateral cooperation. In this context, ASEAN underscores the importance of the Security Council acting in an efficient, consistent, transparent, and non-selective manner, particularly in the application of international law, in order to uphold its credibility and effectively safeguard international peace and security. Thank you, Mr. President.
I thank the representative of Philippines for his statement, and now give the floor to the representative of Indonesia.
Thank you, Mr. President. Indonesia aligns ourselves with the statement of ASEAN delivered by the Philippines and would like to add the following in our national capacity. Mr. President, in the last 80 years, the world has largely benefited from a rules-based multilateral order. Indeed, it's true that much remains to be done. Access to justice remains a luxury to many, as most evident through the long overdue quest for justice of the Palestinian people. Nevertheless, for Indonesia, international law provides not only legal clarity, but also a moral compass in navigating increasingly complex global challenges. This derives from Indonesia's principled foreign policy, an independent and active foreign policy implemented through mutual respect and partnership, as exemplified, among others, through the 1955 Bandung Principles, the first ASEAN Concord of 1976, and the second ASEAN Concord of 2012. We never believe that power determines justice. Instead, we believe that with great power comes even greater responsibility. Responsibilities to uphold international law without double standard, to embrace others and uphold the principles of equality among nations and peaceful settlement of disputes. In the words of my president, Prabowo Subianto, and I quote, "We must stand for all, the strong and the weak. Might cannot be right, right must be right." Therefore, whichever forum of international arrangements Indonesia has decided to join, please rest assured, Indonesia will bring our firm commitment to the UN Charter to the table. We will uphold the principles of multilateralism, and we will be the voice of reasons, particularly the voice of developing nations and those left behind. Amid that background, I wish to underline 2 points. First, now more than ever, the world must come together to uphold the sanctity of international law. Indonesia has repeatedly underlined that a la carte implementation of international law will never work. Instead, it will open a dangerous Pandora's box. Expectations are high that the Council can effectively serve as a bastion of international law. Placing international law at the heart of the Council's every decision will enable the Council to rise above the paralysis that has become unfortunately more evident in recent years. paralysis that unfortunately has allowed some grave humanitarian situations unanswered in Gaza and some other parts of the world. Placing international law at heart means the Council will ensure accountability across all situations without exception. We call for every veto cast in the Council to be accompanied by legal justification. Thus, we'll reaffirm that its exercise is subject to legal responsibility. Further, the Council should also serve as a critical intermediary for dispute settlement, bridging political dialogue and judicial resolution before recourse to the ICJ. Second, amid imperfections in the multilateral system, we should come together to improve it. Imperfections should not lead to retreating from the multilateral system. It should lead to reform through genuine engagement. Worth highlighting also the need for a stronger and mutually reinforcing process among UN organs to ensure effective implementation of international law. Having regular substantive dialogue between the Security Council with the General Assembly and the ICJ, as well as with regional organizations, will help to ensure that international law prevails in all conflict situations. Mr. President, Indonesia will never rely on a broken multilateral system, nor entrust our future to a world that defies international law. We will continue to work with all to reform the multilateral system to be more effective in maintaining international peace and security, one that is based on the principles of multilateralism and shared responsibility to uphold international rule of law. Thank you.
I thank the representative of Indonesia for his statement. I now give the floor to the representative of South Africa.
Mr. President, South Africa welcomes the convening of this timely open debate presided over by His Excellency President Hassan Sheikh Mohamud, whose presence signifies the importance of its theme in the current international environment. We thank the distinguished briefers for their insightful comments. South Africa has always believed in the international rule of law, with the United Nations Charter at its core, an international system based on the fundamental legal principles of the sovereign equality of states, territorial integrity, and political independence inherently benefits all nations, large and small. It has led to the prohibition of interventions in the internal or external affairs of other states, the prohibition of the use of force that is not in line with Article 51 of the Charter or duly authorized by this Council, obligations to respect and implement treaties in good faith, cooperation among states, the peaceful settlement of disputes, as well as respect for human rights and the self-determination of peoples. Furthermore, it has provided a framework for development by defending the vulnerable against exploitation and coercion. We therefore reaffirm our commitment to the rule of law as well as the principles enshrined in the UN Charter. The debate today aimed at reaffirming the international rule of law is therefore very opportune given the current geopolitical developments, largely characterized by the wanton disregard for international law, a deficit of trust among nations, erosion of the spirit of cooperation, and the inability of the institution, especially the UN Security Council, to act when required. We therefore appreciate Somalia's leadership on this issue, building on the Security Council Presidential Statement, PRST 2014/5. Mr. President, when countries ignore the Charter and act contrary to the central premise, it undermines the credibility of the entire system within which we all undertake our international relations. It erodes trust that law will protect those most vulnerable to the excesses of power. At times like these, our collective action is required to build a just and more humane world. Key for the United Nations is the reform of the Security Council to allow this principal organ of the UN to fulfill its mandate and enable the enforcement of the rule of law as a backbone for the maintenance of international peace and security. The unfettered exercise of the veto has largely hindered much needed action to protect the most vulnerable, even in the midst of a genocide committed in full view of the global public, with national interests prioritized over the maintenance of international peace and security. In this regard, we have seen how the General Assembly has stepped in to address pressing issues in the face of the failure of the Security Council to act. While all principal organs of the UN contribute to the maintenance of international peace and security, it is also important to recognize the reinforcing nature of all three pillars of the UN, and thus the promotion and respect for human rights and access to justice to ensure accountability will have a meaningful impact in the lives of peoples. Finally, Mr. President, we must be clear that the violations of international law are the exception to the normative progress we have all made. Therefore, it is incumbent on all of us to ensure accountability for gross violations which threaten all of us. A precedent of impunity for those wielding unrestrained power is a dangerous one, which threatens the very bedrock of international peace and security. We must therefore be united as we had been in the past and rally behind the UN in its lofty and noble ambitions set out in the Charter. As I conclude, Mr. President, South Africa aligns itself with a statement to be delivered by Austria on behalf of the group of friends of the rule of law. I thank you.
I thank the representative of South Africa for her statement, and now give the floor to the representative of Germany.
Mr. President, I would like to first commend Somalia for organizing this timely and important debate, and thank the chairperson of the AU Commission, as well as Judge Yusuf and the Secretary General for their important contributions. The rule of law lies at the very heart of the international order, and if we do not adhere to international law, trust between states will inevitably erode. And if there is no accountability for serious crimes within states, societies will not be able to achieve sustainable peace. But how do we strengthen international law with all the conflicts that we're seeing? We strengthen it by learning from the past, building on successes that we've seen and made, by enhancing knowledge about the significance of international law, and by working concretely on its development. And I would like to be very concrete in the following points. First, the deliberations last week in the Preparatory Committee for the Convention on Crimes Against Humanity underlined that, unlike genocide and war crimes, crimes against humanity are not yet governed by a universal treaty dedicated to their prevention and punishment, and Germany firmly believes that this normative gap must be closed. So we call upon all member states to engage in the negotiations in order to ensure an outcome of global and historical importance. Second, in 1994, this Council established the International Criminal Tribunal for Rwanda. And not only did this court make history in handing down the first international judgment based on the 1948 Genocide Convention, but it also contributed to the legal development of establishing international jurisdiction over crimes against humanity. And it contributed to justice and accountability after the atrocious genocide against the Tutsi in Rwanda. And I would like to recall this and maybe to revisit the judgment of this court for the historic relevance and the legal distinction between genocide and crimes against humanity. Furthermore, clarity in law goes hand in hand with clarity in the facts. And conflicts often arise, just as an example, around border disputes. Certainty about borders can avoid conflict, war, and suffering. And I would like to highlight the African Union Border Program, which is, as many of you undoubtedly know, a delimitation and demarcation project to clarify legally and factually the exact line of over 9,000 kilometers of borders between several countries in Africa. And my country has been proud to support this initiative since 2008 with over 90 million US dollars. Mr. President, colleagues, Germany is particularly committed to international law and international criminal law, not the least because of our own history. 80 years ago, in the wake of devastation and unprecedented human suffering, a new international order began to take shape. And the Nuremberg trials were revolutionary because they introduced a new principle in international law, that individuals should be held accountable for grave violations of international law, and this legacy is still visible today. 3 years ago, almost 4, in 2022, a judgment of the higher regional court in Germany in Koblenz convicted a man of crimes against humanity for his crimes committed in a prison in Damascus. And this is only one of the prominent examples of how Germany is committed to ensuring accountability and bringing justice to victims of crimes. Excellency, in summing up, let us all learn from the past that peace and justice are inseparable, that international law plays a decisive role in keeping the peace between nations and, after conflict, finding back the way to peace. Let us reconfirm that respect for each other requires us to prevent the recurrence of crimes against humanity, and that adhering to international law is at the heart of preventing conflict and keeping the peace. And let us strengthen international law by supporting the UN and its institutions, including the International Court of Justice, the International Criminal Court, and by reforming the institution and reforming those parts that have been a need for reform for a long time, including the Security Council. I would like to assure you that Germany stands ready to do its part in working with all of you and in this endeavor. Thank you very much.
I thank the representative of Germany for his statement, and now give the floor to the representative of Ukraine.
Mr. President, distinguished members of the Security Council, in just a few weeks, the world will mark 4 years since the start of Russia's unprovoked and treacherous full-scale military invasion against Ukraine that has brought immense suffering to the Ukrainian people. In recent months, intensive diplomatic efforts initiated by the United States and supported by our European allies and like-minded countries have been underway to stop this barbaric war and to achieve a peace that would be lasting and just. One of the central questions before us today is accountability. We often hear that argument that in order to reach a stable peace, justice should be set aside or at least not be overemphasized. Some claim that holding perpetrators accountable might complicate negotiations and endanger peace. But is it really true? History gives us a clear answer. Justice and accountability are not obstacles to peace, they are its foundation. After the Second World War, the Nuremberg Tribunal established a basic principle of international law. Those who commit the gravest crimes are individually accountable, regardless of rank or position. Decades later, the international tribunals for the former Yugoslavia and Rwanda demonstrated that justice contributes to sustainable peace by breaking cycles of violence and enabling reconciliation. In these cases, tribunals did not obstruct peace, they made peace possible. The same principle must apply to Russia's aggression against Ukraine. This invasion has brought systematic atrocities against civilians in occupied territories, mass killings such as those uncovered in Bucha, forced deportations, torture, and sexual violence. These crimes were not isolated instances. They were part of a broader, deliberate pattern and clearly constitute crimes against humanity. Today we witness yet another form of Russia's criminal conduct, the deliberate destruction of Ukraine's energy infrastructure, plunging entire cities into darkness and cold and leaving millions of Ukrainians without heating, electricity, and water. These are just a few instances in the history of humankind when suffering on such a magnitude has been inflicted so intentionally on a civilian population. Can we simply look away from crimes of this scale and move on at the negotiation table? Can sustainable peace be built on deliberate indifference to such violations? Ukraine's position is clear. All those responsible for the crime of aggression, for crimes against humanity, and for crimes of war must be held accountable. There can be no selective justice and no immunity. Important steps have already been taken. The ICC has issued arrest warrants. Last June, an international convention was signed in Strasbourg that establishes a special tribunal for the crime of aggression against Ukraine, a milestone in restoring justice for this gravest crime under international law. The rule of law is the foundation of peace. A peace built without justice is fragile and temporary. A peace built on accountability has a chance to endure. And my last point, Mr. President, we have just heard the Russian delegate accusing Ukraine in violating our international obligations regarding military alliances. First of all, this is a lie. And second, there can be no justification for a war of aggression. I thank you.
I thank the representative of Ukraine for his statement. I now give the floor to the representative of Liechtenstein.
Thank you very much, Mr. President, for convening this important discussion. In ratifying the Charter, member states have established a system under which relations between states are governed by agreed-upon rules with the peaceful settlement of disputes, a core purpose of the United Nations. An important dimension of the current rule of law crisis is the erosion of respect for Article 2.4, which obligates all of us to refrain in our international relations from the threat or use of force against the territorial integrity or political independence of any state. Under the Charter, the use of force is only lawful in self-defense in accordance with Article 51 or when authorized by the Council. When invoking Article 51, states are to report measures taken to the Council and to provide a clear legal justification. The steady decline in the Council's practice in this respect has created dangerous results for international peace and security. The right of self-determination, which occupies a central place in the Charter and in the history of the United Nations, is also under significant pressure, both through the overall negative trends on the respect for international law and new challenges such as sea level rise. In reaffirming the rule of law, we must also reaffirm unequivocally the right of all peoples to freely determine their political status and freely pursue their economic, social, and cultural development. Mr. President, international courts play a crucial role in upholding international law, in particular the Charter. The International Court of Justice has played a key role in adjudicating territorial disputes between states and has the competence to settle disputes between states under numerous UN treaties, hopefully the Treaty on Crimes Against Humanity soon to be added to this list. Also, in exercising its advisory role, the ICJ has been able to play an important role in settling disputes, as illustrated in the Chagos advisory opinion. The International Criminal Court ensures accountability for the most serious crimes under international law: genocide, crimes against humanity, war crimes, and the crime of aggression. All these crimes are of direct relevance for the work of the Council, which is why it has the power to refer situations to the court, warranted in situations of particular gravity, such as most recently in the Islamic Republic in Iran. The court's role with respect to the crime of aggression deals with the most serious violations of the prohibition of the use of force under the UN Charter. We hope that more states will join the jurisdictional regime of the ICC over this crime and that this jurisdiction is elevated to the level of the other crimes. At a time when international law is challenged in an unprecedented way, political attacks on international courts are sadly almost inevitable. Standing up in their support is indispensable for the reaffirmation of the rule of law. Mr. President, we live in times that none of us have witnessed before. International relations are at the risk of being thrown back not only to a time prior to the creation of the United Nations, but indeed to a far more distant and darker past. International law is owned by all of us who have agreed to the rules in the Charter, and it benefits the peoples in whose name we work. It is ultimately the task of those who believe in international law to stand together and to stand up for it, and to place it again, as we did in 1945, at the center of international relations. We look forward to working with all members, including members of this Council, to that end. I thank you.
I thank the representative of Liechtenstein for his statement. I'll now give the floor to the representative of Malaysia.
Thank you, Mr. President, for convening this open debate. Malaysia expresses its appreciation to the Secretary General and the briefers for their valuable insights. We align ourselves with the statement by the Philippines on behalf of ASEAN. Mr. President, Malaysia firmly believes that this debate is both timely and essential, particularly in light of recent events that starkly demonstrate the concerning trend of disregarding the rule of law with impunity. Today, we are witnessing blatant acts that erode the very foundations of international law, foundations that we, the international community, has painstakingly built and upheld over decades. Israel's illegal occupation of Palestine and its systematic atrocities against the Palestinian people, which are brazen violations of international law, including international human rights and humanitarian law, are clear examples. In addition, we have been witnessing increasing violations of international law and the sidelining of the UN through unilateral actions and the detestable flexing of power. Could we be at the onset of a dangerous breakdown of the international world order based on international law and regressing into a world where only might is right? Mr. President, the United Nations was established with a clear mandate to maintain international peace and security, to prevent conflict, and to uphold international law. Yet, this mandate remains severely constrained, particularly within the Security Council, where the repeated use of the veto or the threat thereof by permanent members has undermined its effectiveness, and because of it, the United Nations' credibility. Malaysia therefore reiterates that upholding the rule of law within the United Nations system must begin with meaningful institutional reform, especially of the Security Council. Persistent concerns relating to accountability, transparency, and equitable representation demonstrates the urgent need to align the United Nations structures with contemporary global realities. Mr. President, Malaysia maintains its long-standing position that reform of the Security Council is no longer optional, but an absolute necessity. While immediate measures to regulate the use of the veto are necessary, Malaysia firmly believes that the veto has no place in a modern, democratic, multilateral system and should ultimately be abolished. Such reform is essential to restore confidence in the international legal order and to prevent its further erosion. It is the only way to ensure equality of all sovereign states before the law. In conclusion, Malaysia reaffirms its unwavering commitment to strengthening the rule of law, upholding human rights, and advancing justice at both the national and international levels. I thank you.
I thank the representative of Malaysia for his statement. I'll now give the floor to the representative of Chile.
Thank you very much, Mr. President. We'd like to thank Somalia for convening this high-level debate at a time when the erosion of the international rule of law threatens not only peace and security, but also confidence in multilateralism. We also thank the Secretary General, Mr. Mahmoud Ali Yusuf, and Mr. Abdul Qayyum Yusuf for their participation this morning. Chile agrees that reaffirming the rule of law among nations is indispensable to preserving a rules-based, fair and legitimate international order. Chile considers it a priority to develop preventive and cooperative strategies both at the regional and global levels that allows threats to the rule of law to be anticipated before they escalate into conflict. This requires lasting frameworks for collaboration collaboration between the United Nations and regional organizations based on effective diplomacy, early information sharing, and the strengthening of institutional capacities, especially in regions affected by historical legacies of inequality and institutional weakness. In this regard, the Security Council and the UN system as a whole must act with greater coherence and predictability to prevent the erosion of international law. This entails a firm commitment to the Charter, respect for international humanitarian law and human rights law, and the rejection of all forms of impunity. The Council must strengthen its preventative role and ensure that its decisions and mandates are implemented consistently without double standards. Mr. President, Chile underscores the importance of actively promoting negotiation, mediation, arbitration, and judicial settlement, as well as strengthening recourse to regional mechanisms. The African experience, marked by an increasing use of regional and international judicial bodies, demonstrates that law can and must replace the use of force as an instrument of international relations. In this context, it's essential to make fuller use of the tools already enshrined in the Charter of the United Nations, particularly those aimed at the peaceful settlement of disputes. These provisions, designed to prevent the escalation of conflicts and to strengthen the rule of law among nations, remain essential, but they are still insufficiently utilized. Advancing the rule of law among nations requires better coordination among the various organs of the United Nations. Political, technical, and resource-related barriers persist that hinder coherent action. Overcoming them requires pragmatic reforms, greater alignment among peace, development, and human rights, and the allocation of resources that reflects these priorities. Effective cooperation between the Security Council, the General Assembly, and the specialized bodies is key to maximizing impact and legitimacy. Finally, Mr. President, Chile reaffirms its commitment to people-centered multilateralism, grounded in international law and oriented toward peace. Reaffirming the rule of law is not only a legal obligation, but a collective responsibility to ensure dignity, justice, and security for present and future generations. Thank you very much.
I thank the representative of Chile for his statement. There are still a number of speakers remaining on my list for this meeting. I intend, with the concurrence of the members of the Council, to suspend the meeting until 3 p.m. The meeting is suspended.
10,096th meeting of the Security Council is resumed. I wish to remind all speakers to limit their statements to no more than 3 minutes in order to enable the Council to carry out its work expeditiously. The flashing light on the microphone will prompt speakers to bring their remarks to a close after 3 minutes. I now give the floor to the representative of India.
Mr. President, I congratulate Somalia for assuming presidency of the Security Council for the month, and thank you for convening today's open debate. The theme of today's debate bears immense significance in the current context and the ongoing geopolitical developments. The rule of law is at the very heart of the core mandate of the United Nations Security Council, maintenance of international peace and security. It's critical to addressing conflicts and fostering trust among member states. The multilateralism of universal membership with the United Nations at its core is under strain. The challenges facing this organization go far beyond the budgetary realm. Paralysis, a lack of effectiveness in tackling conflicts remain a significant shortcoming. People around the world do not perceive the United Nations as an organization that delivers on international peace and security. Conversations and discussions have moved on to parallel plurilateral frameworks, some even involving private sector actors, to bring about outcomes on peace and security outside the United Nations framework. Today's debate provides a timely opportunity to reflect upon some of these challenges, identify the causative factors, and explore the means to reinvigorate peace, justice, and multilateralism. At the outset, I'd like to highlight that India upholds the rule of law as a cornerstone of its national governance, enshrined in its constitution and reinforced through the independence of its judiciary and initiatives that expand access to justice. These deep roots of rule of law in India at the national level inform and guide our commitment towards rule of law at the international level. Mr. President, India would like to make the following points in this backdrop. First, The rule of law is barren without enforceability. The focus must shift from arcane constructs to pragmatic solutions and outcomes that positively impact the daily lives of our citizens. Second, the world is changing and transforming at a rapid pace across different domains. The legal and institutional framework governing international rule of law must keep up with this rapidly transforming landscape. Continuous review, updation, and reinvigoration are an imperative to avoid obsolescence. Third, for multilateralism and international rule of law to remain effective and credible, global governance structures must evolve to reflect contemporary realities. The current architecture of the United Nations, particularly the composition of the Security Council, reflects the geopolitical reality of a bygone era. In light of the profound global transformation of the last 8 decades in power dynamics, demographics, and the nature of global challenges, there's an urgent and compelling need to undertake comprehensive reform, including expansion in the permanent and non-permanent categories. Such reform is essential to enhance the Council's legitimacy and ensure its continued relevance and effectiveness in addressing the present-day challenges. Fourth, identifying and building on synergies among the principal organs of the UN would help in advancing rule of law. This could result in greater alignment between mandates, avoiding duplication, leading to enhanced impact. Process-oriented reforms are instrumental for achieving these ends. Predictable and adequate resource provision, capacity building, and technical assistance tailored to local contexts are key elements of these reforms. Fifth, international rule of law should not be weaponized to question state sovereignty and interfere in internal affairs of states. International law principles from the colonial era that helped in self-determination and emergence of new member states from colonial rule should not be weaponized to attack the unity and territorial integrity of states. Contexts and situations are ever-changing, and if multilateralism treats outcomes and solutions as immutable and cast in stone and unable to pragmatically adapt to change, it would be an impetus for alternate formats of engagement to emerge. Finally, the application of international rule of law calls for consistency, objectivity, and predictability with no double standards. Mr. President, I now respond to the comments of the representative of Pakistan, an elected member of the Security Council, which has a single-point agenda to harm my country and my people. He has advanced a false and self-serving account of Operation Sindoor in May last year. The facts on this matter are clear. Pakistan-sponsored terrorists killed 26 innocent civilians in a brutal attack in Pahalgam in April 2025. This august body itself called for holding the perpetrators, organizers, financiers, and sponsors of this reprehensible act of terrorism accountable and brought to justice. That is exactly what we did. India's actions were measured, non-escalatory, and responsible, and focused on dismantling the terrorist infrastructure and disabling terrorists. Till 9th of May, Pakistan was threatening more attacks on India. But on the 10th of May, the Pakistani military called our military directly and pleaded for a cessation to the fighting. The destruction caused to multiple Pakistani air bases by the Indian operation, including images of destroyed runways and burnt-out hangars, are in the public domain. We have heard talk from the representative of Pakistan about the new normal. Let me reiterate again that terrorism can never be normalized as Pakistan wishes to do. It is not normal to tolerate Pakistan's continued use of terrorism as an instrument of state policy. This hallowed chamber cannot become a forum for Pakistan to legitimize terrorism. We will do whatever required to protect and ensure the safety and security of our citizens. Furthermore, Pakistan has no locus standi to comment on matters that are internal to India. The Union Territory of Jammu and Kashmir has been, is, and will always remain an integral and inalienable part of India. India had entered into the Indus Waters Treaty 65 years ago in good faith, in a spirit of goodwill and friendship. Throughout the 6.5 decades, Pakistan has violated the spirit of the treaty by inflicting 3 wars and thousands of terror attacks on India. Thousands of Indian lives have been lost in Pakistan-sponsored terror attacks. India was compelled to finally announce that the treaty will be held in abeyance until Pakistan, a global epicenter of terror, credibly and irrevocably ends its support for cross-border and all other forms of terrorism. Pakistan is well advised to introspect about the rule of law. It could start by asking itself how it has let its armed forces engineer a constitutional coup through the 27th Amendment and giving lifetime immunity to its Chief of Defense Forces. In conclusion, India would like to reiterate that strengthening the international rule of law framework and reforming multilateralism are a strategic necessity for the United Nations to effectively discharge its responsibilities with regard to maintenance of international peace and security. I thank you, Mr. President.
I thank the representative of India for the statement. I give the floor to the representative of Slovenia.
Thank you, Mr. President, and I congratulate Somalia on the successful presidency of the UN Security Council this month, as well as for choosing this timely topic for your signature event. My delegation also aligns both with the statement to be delivered by the EU and the one to be delivered by Austria on behalf of the group of Friends of the Rule of Law. Mr. President, international peace and security depend on rules and their implementation. Or in the words of Secretary General of this morning, the rule of law is a cornerstone of global peace and security. And although these rules, entrenched in the very fabric of these United Nations, prevented another global war, lack of their implementation these days triggers more conflicts than ever after the Second World War. Violations of international humanitarian law have become systemic and too many to count. The decisions of the International Court of Justice go unimplemented, as do this Council's decisions. Fight against impunity for the most serious international crimes is becoming increasingly difficult. International judicial officials are facing threats and sanctions for doing the very job we ask them to do, ensuring accountability. And the Security Council is willingly or not turning itself into a silent observer. All of these resulting in the highest number of civilian victims of conflicts and refugees, and resulting in increasingly unstable international environment. Mr. President, these trends need to be reversed, and this begins by acknowledging the existence of and accepting the rules, and it continues with their implementation. It is imperative to respect and ensure respect for international law, including international humanitarian law and human rights law. This includes respect for the decisions of the international courts and tribunals, most notably the ICJ as the highest judicial organ of the United Nations. This Council's primary responsibility for international peace and security is neither a right nor a privilege. It is an obligation and a reflection of trust that all UN members have placed in it. Members of this Council should have this in mind when returning to this chamber. The world is watching and history will be judging. There are no alternatives when it comes to accountability. This was well understood after the Second World War and after the wars in the former Yugoslavia and Rwanda. The ICC is a culmination of decades-long efforts by states to ensure that perpetrators of the most atrocious international crimes do not go unpunished. The importance of the ICC was recognized by this Council when it referred two situations to the ICC. The ICC deserves our respect and our support, and Slovenia will continue to do so, and we call on all states to do the same. And in our aspirations, we should go even beyond. These very days, states have begun discussions on the process for concluding the International Convention on the Crimes Against Humanity. 40 states have already signed the Ljubljana-The Hague Convention, which will strengthen national systems for accountability. The International Court of Justice and the ICC are fulfilling their mandate as entrusted to them. There are more and more loud and important voices emphasizing the need and the importance of international law and the rule of law. Let me therefore end with a message of hope. These are bleak times for international law, and most of all for the millions of victims of its violations. Yet we must remember that international law was created in and especially for times such as these. While it may occasionally appear fragile, history, with a little help from all of us, will again prove its resilience. Because peace is not a self-sustaining state. Rather, it's the outcome of collective action and mobilization by member states, both within and beyond the Security Council. Thank you.
I thank the representative of Slovenia for the statement. I give the floor to the representative of Portugal.
Thank you, Mr. President. We thank Somalia for convening this meeting on this important subject. As the Secretary General often reminds us, respect for international law, it's not optional. It's the bedrock of international peace and security. As recalled in the GA Resolution 67/1, the rule of law at both national and international levels is essential for peaceful coexistence and for cooperation among states. In these bleak times, we believe action is needed at 5 different levels. First, a credible international rule of law requires that all states are bound to respect the same fundamental legal norms, regardless of size, power, or geopolitical influence. The consistent application of international law is therefore key. There should be no selective compliance. Second, strengthening the rule of law requires renewed fidelity to the UN Charter. Respect for sovereignty and territorial integrity is essential. So is the peaceful settlements of disputes and the prohibition of the use of force. These principles are paramount for an effective multilateral order. At the same time, the integrity of treaty regimes must be preserved, including human rights law, international humanitarian law. Legal predictability depends on their full respect. Third, international courts, tribunals, and monitoring bodies give practical meaning to the rule of law. They are the guardians of legality. Their independence must be respected, their authority upheld, their adequate resourcing ensured. This is particularly true to the ICJ and the ICC. Fourth, the international rule of law is ultimately lived and enforced at the national level. International obligations must be properly incorporated into domestic legal systems. Capacity building efforts are therefore essential to strengthen judicial independence and to ensure due process. Finally, the Council should speak clearly in support of the rule of law. When addressing conflicts, it must confront unilateral reinterpretations of agreed norms. Decisions and actions should be exercised according to agreed rules, not according to arbitrary will. This is what safeguards the legitimacy of our collective decisions and ensures their sustainability. Mr. President, in practice, Portugal contributes to strengthening the rule of law through concrete engagements with the United Nations by supporting ORALC's capacity-building initiatives, namely on justice and security sector reform, as well as engagement in fragile and conflict-affected settings. We contribute to UN mechanisms to promote accountability. We support mediation efforts and the peaceful settlement of disputes, including as a proud member of the Group of Friends of Mediation. We also contribute to strengthen and promote the international treaty framework, and we did it recently during our presidency of the GA6 committee, which took 2 concrete steps towards the 2 new conventions. Finally, we consistently support the work of international courts. Mr. President, the international rule of law is not self-executing. It is an obligation, and it must be actively defended, consistently applied, and collectively renewed. In a fragmented world, the rule of law remains our strongest common language for peace, for justice, and for cooperation. As a candidate to an elected seat on this Council for the 27th and 28th term, Portugal reiterates its commitment to the international law and to the principles of the UN Charter. I thank you.
I thank the representative of Portugal for the statement. I give the floor to the representative of Australia.
Thank you, President. We meet, obviously, at a time of great global uncertainty. There's more conflict, more people displaced and hungry. The United Nations faces great uncertainty, and confidence is being undermined across all 3 pillars of the Charter: peace and security, development, and human rights. In some, the world is becoming less equal, more unstable, and more dangerous. These changing circumstances have more countries asking anew, how can we ensure that we live in a world where every country has a voice, where no country dominates and no country is dominated? And in this context, the role of international law and legal institutions are at the forefront of public debate across the world. So I thank Somalia for convening this timely debate and its enduring role on international law and its enduring role in safeguarding our shared global interests. Let me start by underscoring why international rules and norms matter to Australia and to all of us. They matter because international rules and norms deter conflict, enable free trade and underpin our collective security and prosperity. Multilateral treaties and arrangements promote economic development, guard against the spread of nuclear weapons, and mandate the rules for the maritime domain. Global agreements on satellite orbits enable the internet to reach the most remote of places and set the standards that keep thousands of flights and 12 million passengers safely in the sky every day. For the region Australia calls home, the Indo-Pacific, these international rules and norms have underpinned a generational economic transformation. But international rules and norms do not exist in a vacuum, and nor do they enforce themselves. We all have a role to play in making sure that the system which has enabled the rise of new powers safeguards the rights and aspirations of every nation, big and small. Australia is doing its part. In response to the appalling rise in attacks on humanitarian workers, last September, Australia launched a new declaration for the protection of humanitarian personnel. The declaration renews international commitment at the highest political level to upholding international humanitarian law and protecting aid workers. In line with our commitment to protecting the ocean under the framework of UNCLOS, we're pleased to be co-chairing the Preparatory Commission for the UN High Seas Biodiversity Treaty, or BBNJ. In response to the threats presented by sea level rise and the important role of international law in protecting the status and rights of affected nations in the Pacific, Australia is strongly committed to securing a comprehensive declaration on sea level rise, and I'm delighted to be co-facilitating that negotiation with the Permanent Representative of Cape Verde. Australia is an active user of international courts and tribunals. We respect their decisions and we work tirelessly to defend their independence. Australia's engagement in the Timor Sea compulsory conciliation process under UNCLOS demonstrated our commitment to the rule of law and the peaceful settlement of disputes, and we have welcomed last year's landmark opinion of the International Court of Justice on climate change. We have supported and actively engaged in recent UN treaty negotiations, including this week's Preparatory Commission on a treaty preventing crimes against humanity. These are all efforts in which we are collectively engaged to use the United Nations framework to strengthen and support an international rule of law, and we cannot afford to give up. As we meet here in the Security Council, and having listened to previous interventions, it's clear that this organ has an integral role in this project. We all depend on the Security Council to uphold the Charter, to act and deploy its legal powers for good, and to actively defend international courts and tribunals. Australia is committed to bringing this approach to the Security Council as part of our campaign for a 2029-2030 term, and we will champion issues like conflict prevention, peace building and protection of civilians, all areas where a strengthened international rule of law can save lives and protect the most vulnerable. Thank you.
I thank the representative of Australia for the statement. The representative of Pakistan has asked for the floor to make a further statement. I give them the floor.
Thank you, Mr. President. My delegation is availing of its right of reply to response to spurious claim made by India in its statement. It is an old ploy in India's playbook to level preposterous calumnies against Pakistan to deflect criticism from its illegal occupation of Jammu and Kashmir. Jammu and Kashmir has never been a part of India. It never will be. As per UNSC resolutions, Jammu and Kashmir is a disputed territory pending a final resolution. India brought Kashmir dispute to the United Nations, made solemn pledges in this organization, most significantly with the Kashmiris for a UN-supervised plebiscite in the disputed territory. It now stubbornly refuses to honor its international obligations and remains in violation of international law and relevant Security Council resolutions. This is the abuse of sanctity of Security Council which deserve strongest condemnation. Sermons on law, justice, and fairness ring hollow, in fact comical from a country which is peddler of lies, planner of global assassination campaigns, and a plotter of terrorism in the region and beyond. So much so, it does not even shirk from politicizing a field as innocuous as that of sports. At the same time, by unilaterally and illegally suspending Indus Water Treaty, India now attempts to effect desertification of the ancient fertile plains of Pakistan. We would counter this latest provocation, this water terrorism, with the same resolve, clarity, and success with which we defended our country against India's aggression in May last year. India represents a classic case study of how tyranny of majoritarianism can disrupt social fabric of a political entity. Sham claims of the world of being world's largest democracy cannot belie state-sponsored pogroms led by Hindu extremist organizations against Muslims, Christians, Sikhs, and other minorities in India. Instead of belligerence against Pakistan, robbing Kashmiris of their inalienable right of self-determination and ghettoization of its own minorities, India is advised to fulfill its international legal obligations by implementing UNSC resolutions on Jammu and Kashmir and end the repression and systemic grave violence of human rights of the Kashmiris, mollify its ethnic minorities, and pursue a path of dialogue and diplomacy for an environment of peace and stability, for a better future and prosperity for billions in our region. I thank you.
I thank the representative of Pakistan for the statement. I give the floor to the representative of Spain.
Mr. President, we're grateful for the convening of this open debate to contemplate and explore pathways to revitalize the pillars that underpin peace, justice, and multilateralism. We're grateful for your emphasis on the rule of law, nationally and internationally, as is also seen in the annual resolutions of the General Assembly on this issue. The expression rule of law refers to the centrality of law in the management of our societies and in the international community. It has become a common heritage of humankind, universal in nature. Indeed, in fact, between the 16th and 17th centuries, the Spanish lawyer Francisco Suarez was already affirming that that international law was not born of one people, but rather of the consensus of humankind as a whole. Over the last 80 years, we've built an architecture of multilateral cooperation with the United Nations at its heart. It is based on consensus. This architecture has allowed us to make progress towards peace, justice, respect for human dignity, and shared prosperity. We've garnered achievements such as the Paris Agreement, Agenda 2030, and the Beijing Declaration on the Rule of Law. The multilateral order based on international law and the universal principles of the United Nations Charter is being questioned and eroded. As a response, we must maintain our collective action rooted in these principles and reaffirm the centrality of the UN system. We must develop proactive strategies both regionally and globally to tackle new threats to peace and thwart the attacks on the principles which underpin multilateralism. Conflict prevention must be the central thrust of our collective action and not a belated response to crises already spiraling out of control. This work must be done with a holistic perspective based on the defense and promotion of human rights, as well as sustainable development and respect for the rule of law. Spain staunchly supports strengthening early warning systems, as well as preventive mediation mechanisms and platforms for information exchange between the UN regional organizations and local actors. The Security Council and the United Nations as a whole have a central role to play in this endeavor. Spain champions a more systematic use of diplomatic tools under Chapter 6 and clearer mandates for peace operations. Mandates, too, which must be tailored to the local context. Elsewhere, accountability is vital to avoid decreasing compliance with the rule of law. The Security Council, the General Assembly, and the UN system in general, as well as regional cooperation organizations, must promote accountability. This through international and regional justice mechanisms. The credibility of the multilateral system depends on doing just that. President, we have tools to strengthen international compliance with the rule of law and to contribute to the maintenance of international peace and security. The Pact for the Future must be implemented with ironclad resolve. The Pact for the Future pinpoints more effective and coordinated actions to broach current challenges. It urges states to emphasize preventive diplomacy, to strengthen early warning systems, and to integrate climatic, technological, and social risks the analysis of those risks into their work. It underscores that lasting peace depends on tackling the structural causes of conflicts. It seeks to ensure that international institutions are more inclusive, effective, and tailored to the challenges of the 21st century. That is crucial for peace and security. We must step up the implementation of the Pact for the Future. Regarding the role of regional organizations, there is a framework established by Council Resolution 2719 on peace support operations in Africa. That resolution is a good example of the potential of such regional organizations. We have a strategic partnership with Africa, and we're fully committed to that approach. We need reformed multilateralism to respond to outlined challenges and restore, in so doing, trust in the system. The UN has a crucial role to play in this endeavor. We support UN80 to make the organization able to act with greater efficiency, agility, and coherence. In parallel, we will continue to work to bring about a more inclusive multilateral architecture which reflects current geopolitical realities. To achieve that goal, we are championing the implementation of the Sevilla commitment adopted at the 4th Conference on Financing for Development. To conclude, Spain reaffirms its belief that international law and the universal principles of the UN Charter are not an option. Rather, they are the crucial pillar of peaceful coexistence between nations. Reinvigorating multilateralism is a shared responsibility. It is only in so doing that we will guarantee that international rule of law remains the pillar which underpins peace and security in decades to come. Thank you.
I thank the representative of Spain for the statement. I give the floor to the representative of Finland.
President, I have the honor to speak on behalf of the Nordic countries, Denmark, Iceland, Norway, Sweden, and my own country, Finland. The Nordic countries welcome the timely theme of this open debate. Amidst global geopolitical turmoil, our collective reaffirmation of the international rule of law is of key importance. We often quote the Charter in this room to remind each other that the UN was founded to save us from the scourge of war. One of the key objectives of the UN from its establishment is to uphold international rule of law. In the less frequently cited part of the preamble of the Charter, the UN was set up to establish conditions under which justice and respect for obligations arising from treaties and other sources of international law can be maintained. The Charter also reaffirmed the faith in fundamental human rights and in the dignity and worth of the human person. The founders of the UN understood that the rule of law is integral to maintaining international peace and stability. The Charter itself lays out the central tenets which have governed international relations since World War II. These core rules of international law have at times been tested, even violated. In recent years, they have been challenged perhaps more than in decades. However, the vast global majority of states, including the Nordic countries, continue to abide by them, to respect them, and to call all member states to do the same. Prohibition of the use of force against territorial integrity and political independence of any state, and the commitment to peaceful settlement of disputes in conformity with international law hold existential value, not only for small states but for all. Stability and predictability allow all countries and their citizens to concentrate on the peaceful pursuit of wealth and happiness rather than in preparing for potential aggression and other lawless actions by others. One proof of the universal acceptance of the Charter is the high number of regional organizations and arrangements with their founding instruments mirroring key norms and principles of the UN. Not only did our nations make the sovereign decision to adhere to the Charter when joining the UN, but most of us have also reaffirmed the same commitment at regional level. The Nordic countries also underline the central importance of international courts and tribunals in resolving disputes and upholding international law. They are there to be used. The Nordic countries reiterate their firm and unequivocal support to the ICJ and the ICC. Our support is also reflected in our presentation of a Nordic candidate for the ICC judicial election in December 2026, Judge Mette Lyster-Knudsen. In closing, the Nordic countries reiterate that rule of law is not optional luxury. It is a prerequisite for peace and stability and for the protection of human rights. For the same reason, also strengthening the rule of law at national level is important. Compliance with international law, including international humanitarian law, also strengthens states' international standing as reliable and trustworthy partners. I thank you, President.
I thank the representative of Finland for the statement. I give the floor to the representative of Austria.
Thank you, Mr. President. Let me commend Somalia for assuming the presidency of the Security Council for January and for convening today's debate. As this is my first statement in the Council this year, let me also congratulate Bahrain, Colombia, DRC, Latvia and Liberia for assuming the role as elected members of this Council. I have the honor today to deliver this statement on behalf of the following members of the group of Friends of the Rule of Law: Australia, Bahamas, Belgium, Burkina Faso, Canada, Cabo Verde, Colombia, Costa Rica, Croatia, Czech Republic, Denmark, Republic of the Congo, Finland, France, Germany, Guatemala, Iceland, Italy, Japan, Jordan, Latvia, Liechtenstein, Malta, Mexico, Moldova, Mongolia, Morocco, Mozambique, the Netherlands, Panama, Papua New Guinea, the Philippines, Republic of Korea, Romania, Senegal, Singapore, Slovakia, Slovenia, South Africa, Spain, Sri Lanka, State of Palestine, Sweden, Switzerland, Timor-Leste, Uganda, Uruguay, and the European Union, and my own country, Austria. Mr. President, in recent years we've witnessed blatant breaches of even the most fundamental provisions of the UN Charter, including the obligation of all member states to refrain in their international relations from the threat of force or the use of force, often paired with the failure of the Security Council to take action in response. The increasing erosion of rules undermines trust in international law and the UN as a whole. So should we discard the rule of law? Are we riding a dead horse? Mr. President, let me be clear. The answer is no, very surprisingly. Our community of states made a choice 80 years ago for the rule of law. Instead of might makes right. Our community of states, all of us, did so not out of blind idealism, but because of clear-eyed realism, that our peaceful coexistence depends on it. Even the most powerful states cannot secure peace and prosperity without the rule of law. The United Nations Charter is at the core of this. Through ratification, all member states agreed to be legally bound by the Charter. All member states are legally bound to the principle of sovereign equality of all member states. Enshrined in Article 2(1) of the UN Charter and the obligation to refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. Enshrined in Article 2(4) of the UN Charter. Respect for international law includes respect for international human rights law and international humanitarian law, which protects individuals, not only states. Mr. President, adherence to the UN Charter and the rule of law is in the interest of all states, large and small. It serves our collective security and guarantees the safety of our citizens. It ensures that the rules we agreed on are respected and implemented by all in good faith. If a state breaches an obligation under international law, it must bear the legal consequences. Accountability for violations of international law, including through independent and impartial courts and tribunals, is essential to uphold the rule of law and to ensure justice and effective remedies for victims. Mr. President, the peaceful settlement of disputes and prevention of conflict must be the default, not the exception. But if states do not prevent or resolve a conflict peacefully, the Security Council has the responsibility to maintain or restore international peace and security. In this context, the non-responsible use of the veto power, as well as the non-observance of Article 27.3 of the UN Charter, seriously undermine the credibility of this Council. At the same time, the General Assembly must not give up if the Security Council cannot deliver. Mr. President, coming to an end, arguably no other international institution embodies the principle of the rule of law among states better than the International Court of Justice. We emphasize our appreciation for the Court's work. Decisions of the ICJ are binding on the parties to a case and must be complied with. We also recall the ICJ's contributions on legal questions through advisory opinions. Mr. President, we will continue to stress the importance of the rule of law, and let me repeat, not out of blind idealism, but because of clear-eyed realism, that our peaceful coexistence depends upon it. I thank you very much.
I thank the representative of Austria for the statement. I give the floor to the representative of Mozambique.
Thank you, Mr. President. We commend Somalia's leadership during its presidency of the Security Council in a month that has tested the very foundation of our global security governance architecture. Mr. President, the Charter of the United Nations was born from a stark historical lesson that unrestrained power leads to catastrophe, and only law can provide order, restraint, and legitimacy among states. When laws erode, institutions weaken, trust collapse, and social order disintegrates. When the rule of law among nations is undermined, the consequences are systemic. Instability spreads, development is set back, and the risk of conflict escalates. Over 8 decades, the United Nations has built a dense body of international law, treaties, norms, codes, and institutions that brought predictability and restraint to global affairs. For countries like Mozambique, these rules are not abstract ideals, but essential safeguards ensuring that international relations are governed by right, not might. Mr. President, today we face a troubling reality with repeated violations of international law and selective compliance, risk normalize impunity and law losing its deterrent power. The concept note rightly observes that the Security Council's inability to resolve recent armed conflicts fosters a public perception that the international rule of law is being eroded and that the enforcement capacity of international institutions has diminished. This weakens trust in multilateral institutions and undermines peace, justice, and sustainable development. The principle of good faith, enshrined in the Article 2 of the Charter and elaborated in the 1970 Declaration, obliges all member states to fulfill in good faith the obligation they have assumed under international law. While international law is not perfect, its absence would leave us in a far more dangerous world. History reminds us, when law yields entirely to power, the strong do as they wish and the weak suffer what they must. International law exists precisely to temper that logic and protect the vulnerable. If the rules governing our world are to be legitimate, credible, and effective, Africa's growing weight must also be reflected meaningfully in global decision-making, including in the proceedings of this very Council. Mr. President, Mozambique believes that a renewed commitment to the rule of law, anchored in good faith, peaceful settlement of disputes, and genuine multilateral cooperation is our best hope of ensuring that justice, not force, governs our common future. In addition, member states must fully comply and abide to the UN Charter, must enforce compliance with UN resolution, and violation of international law should be held accountable. And finally, International Court of Justice advisory role should be given center stage within the UN system. I thank you, Mr. Chair.
I thank the representative of Mozambique for the statement. I give the floor to the representative of Algeria.
Thank you, Mr. President. Allow me to extend to you my congratulations for the successful stewardship of Somalia of the presidency of the Security Council during this month of January. Let me also congratulate the new members of the Security Council, namely Bahrain, the Democratic Republic of Congo, Colombia, Latvia, and Liberia. I express my appreciation to the Secretary General of the United Nations and to the chairperson of the African Union Commission for their insightful presentation. I also welcome the participation of Judge Abdul Qawi Yusuf. President, Algeria strongly believes that strengthening and promoting the rule of law constitutes the cornerstone for the maintenance of international peace and security. Over the past 8 decades, the United Nations has played an important role, a central role in upholding international law, in promoting collective security and preventing conflict. Yet, recent unfortunate development, marked by repeated violations, repeated disregards of the United Nations Charter, and selective application of international law have fueled a growing perception of the erosion of the rule of law. Against this backdrop, I will highlight the following points. First, the international legal order stands today at a critical juncture. It is why the cardinal rules of international law must be upheld without exception. Without exception. Selective application or inconsistent enforcement of international law undermine trust, erode the rule of law, and weakens accountability. Second, the centrality of the United Nations must be preserved in the resolution of conflicts. The United Nations Charter endows our organization with a comprehensive set of instruments that provide credible pathways for the peaceful resolution of conflict. These tools must be employed fully, consistently, and in a comprehensive manner, in line with the purposes and the principles of the United Nations Charter. In particular, the principles of self-determination of peoples and the sovereign equality of member states. Third, President, considering the growing number of conflicts in Africa, the constitutive act of the African Union provides a solid and comprehensive framework to strengthen the rule of law across our continent, while safeguarding the unity and territorial integrity of states. Furthermore, the continued strengthening of the partnership between the United Nations and the African Union, particularly through enhanced capacity building efforts, will be critical to sustaining peace and security across Africa. In conclusion, President, I wish to reaffirm Algeria's strong commitment to working closely with the international and regional partners to strengthen the rule of law and to promote peace and stability around the world. I thank you.
I thank the representative of Algeria for the statement. I give the floor to the representative of Switzerland.
Merci, Monsieur le
Thank you, President. I wish to join the voices of my colleagues and congratulate all of the new Security Council members, and congratulations to you. Congratulations on this debate on a topic that is more central than ever. Adopted 80 years ago, the UN Charter profoundly transformed international relations by enshrining the rule of law above might makes right, strengthening collective trust and security. On the occasion of the United Nations 80th anniversary, paying tribute to this legacy cannot be limited to simply commemorating it. It must be brought to life and projected into the future. Indeed, international law is currently being subjected to serious pressure, yet a large part of international law's rules remain unchallenged, often invisible in our day-to-day lives, from a simple trip to the supermarket, to buying medicine at the drugstore, to reading the latest novel. International law discreetly shapes the systems on which we all rely. Therefore, we shouldn't make any self-fulfilling promises. International law is alive and well. However, some key principles underpinning our collective security are coming under increasing pressure. They're even being violated. This is why today's debate comes at a decisive moment, when we must mobilize together to defend the very principles on which this organization is built. I would like to highlight 3 points. First, the rule of law is the bedrock of the multilateral system. Consistent and uniform implementation thereof is vital in order to build trust between states, but also to ensure global peace and security. The law applies equally to all states, irrespective of their power, their size, or the political influence they wield. Against this backdrop, the principle of the prohibition on the use of force enshrined in Article 2, Para 4 of the UN Charter is a fundamental rule that introduces guarantees for all states and international stability. Second, respect for international law and the fight against impunity must remain at the heart of our efforts. Consider the example of criminal law. An increase in crime in one area does not render the system obsolete. What it requires is strengthening its foundations and understanding the causes. Similarly, faced with the violations of international law, we must bolster its application and fight relentlessly against impunity. And yet, at a time when multilateralism and its institutions are on the rise, there are parallel institutions being set up, compromising our collective security. We see formation of geopolitical blocs and the proliferation of parallel institutions. In this context, it's essential to strengthen existing multilateral institutions, making them more representative, to promote constructive dialogue based on common rules. International courts, in particular the International Court of Justice, as well as the International Criminal Court, play a central role in interpreting and applying international law, as well as in combating impunity. We support them fully. Third, the peaceful settlement of disputes is one of the central pillars of the rule of law. Switzerland promotes mediation and good offices as effective instruments of conflict prevention. The law is not simply a mechanism for resolving crises. It is also a vehicle for prevention, resilience, and lasting stability. Investing in the rule of law means investing in societies that are capable of withstanding crises and preventing the escalation thereof. On this note, prevention and resilience require greater attention and more resources, in particular by strengthening early warning mechanisms through regional cooperation and the sharing of best practices. As the current chair of the OSCE, Switzerland will seek to reinforce this type of regional cooperation in the areas of security, respect for human rights, and conflict prevention. Mr. President, the rule of law is not a luxury reserved for periods of stability. It is our last line of defense against crises. Protecting and promoting it is a responsibility that is incumbent upon us vis-à-vis not only our current societies, but also future generations. It's encouraging to see that the vast majority of states recognize the importance of international law and the rule of law and act accordingly. As Swiss president of the Swiss Confederation, Guy Parmelin, emphasized last week at the World Economic Forum, and here I quote, "As a neutral nation, Switzerland is able and willing to assume its responsibility vis-à-vis an international order based on rules, international law, human rights, and free trade." True to these principles, Switzerland reaffirms its commitment to supporting and defending the international rule of law as an essential prerequisite for peace, justice, and multilateralism. I thank you.
I thank the representative of Switzerland for the statement. I now give the floor to His Excellency Mr. Stavros Lambrinidis, Head of the Delegation of the European Union to the United Nations.
Thank you, Chair, and congratulations for convening this meeting. We welcome this timely debate on an issue that is of utmost importance in times when the international legal order faces unprecedented strain. These are indeed times when stating the obvious becomes necessary on every occasion. The rule of law and the UN Charter matter and must be upheld at all times. No self-proclaimed national interest can justify departure from them. Violating the principles of the UN Charter undermines the foundations of international law and the UN itself. It endangers international peace, and it threatens the security of all of us, collectively and individually. Article 2 of the UN Charter unambiguously forbids the threat or use of force against another state's territorial integrity or political independence. The principles of political independence, sovereignty, and territorial integrity are universal, obligatory, and to be applied without exception. That is our law. That is our founding law. We recall the particular responsibility of member states of the Security Council, especially permanent members, to uphold them. Chair, the rule of law is also enshrined in Article 2 of the Treaty of the European Union. It is at the heart of European integration. It is a commitment we consistently uphold within our borders and globally. And it is for that reason that we cannot accept violations of international law, neither in Europe nor in other parts of the world. When violations of international law occur, they must entail accountability in accordance with domestic or international law. The European Union therefore reaffirms its unwavering support for the international justice system and the respect of its independence and integrity, particularly for the International Court of Justice and the International Criminal Court, as well as for other international criminal courts and tribunals, along with other international accountability mechanisms. In this regard, it is also vital to acknowledge the role of the UN treaty bodies in monitoring the implementation of international obligations by states parties to the core human rights treaties. Colleagues, some appear to consider that arguing to uphold international law at a time of glorifying transactionalism is somehow a sign of naivete or of weakness. We beg to differ. Over the past decades, as European Union, we have consistently refrained from using power to coerce others. We have instead used it to promote international solidarity and cooperation. The EU's steadfast commitment to international law with the United Nations at its core is not some outdated attachment to a status quo, but a principled commitment to guaranteeing that the voice of all is heard in the realities of today. Supporting multilateral cooperation is a source of strength, not weakness. We know that because that is in fact how we built the European Union itself after the devastation of the Second World War, which was in turn spurred by the proliferation at the time of might is right and of naked national interest over peaceful coexistence and human dignity. And through international law, economic solidarity and human rights, we succeeded in building a united and prosperous Europe. Supporting international law, cooperation, solidarity, and the UN itself is part of a collective strength, not of weakness or naivete. Colleagues, the commitments we adhered to 8 decades ago may remain the same, but the challenges have multiplied. How we respond to them should develop and adapt too. And this is why we all have been engaged in the UN80 initiative, conceived for a better, more efficient, more transparent United Nations within the framework of a multilateralism based on law. To conclude, rule of law is not an abstract notion and not a matter of an ideological debate, but a very tangible framework that preserves human dignity and makes the world a safer place, a better place for all. It is a result of a collective endeavor. It means peace and security. It provides conditions for development, prosperity, and respect for human rights. It protects diversity and difference, allowing all to have an equal say. If upheld, we all benefit from it. And that is why international law, including the UN Charter, remains a shared value and legal commitment, and it is both a joint and individual responsibility to uphold it and to address violations of the Charter to ensure the rule of law. It is up to each one of us to fulfill its purposes through our commitment and through our action. Thank you.
I thank His Excellency Mr. Lambrinidis for the statement. I give the floor to the representative of Lithuania.
Thank you, Mr. President. Lithuania aligns itself with the statement just delivered by the distinguished representative of the European Union on behalf of its member states. I would like to add a few remarks in my national capacity. We thank Somali presidency for convening this timely debate, and we thank Secretary General and the distinguished briefers for their insightful presentations. Mr. President, the uncomfortable reality is that we are debating the rule of law while international law is being violated in plain sight, sometimes deliberately, sometimes repeatedly, and still too often without accountability. The gap between what we reaffirm and what we tolerate keeps widening. This is not sustainable. It feeds a downward spiral in which violations become routine, restraint erodes, and force is treated as an acceptable instrument of policy. Mr. President, Lithuania would like to convey 3 messages. First, the rule of law begins with the UN Charter, our shared foundation that cannot be set aside. It must be upheld in words and deed, not through selective interpretation, not through political convenience, and not through double standards. Every exception invented outside the Charter weakens the protection inside it and sets dangerous precedents. For Lithuania, which marks its 35th anniversary at the United Nations this year, respect for international law and the Charter is not a matter of preference. It is reflected in our constitutional tradition and shaped by history. During 50 years of occupation by the Soviet Union, international law helped Lithuania preserve its statehood and ultimately restore independence. Lithuania's return to the community of sovereign nations was anchored in the UN Charter and its principles. The Charter remains the equalizer. Sovereignty does not depend on size, strength, or wealth. Even the smallest state relies on this, but when it is ignored, no state is truly safe. We therefore underscore that sovereignty, territorial integrity, political independence are non-negotiable imperatives. Second, the UN Charter does not outlaw disagreement. It outlaws violence as the method of resolving disputes. It sets out a clear path through negotiations, mediation, arbitration, and adjudication. These tools reflect strength and responsibility and should not be mistaken for weakness. But when violations of international law carry no consequences, the law becomes a suggestion and impunity becomes a strategy. Lithuania has lived through a cost of impunity under the totalitarian regime. When justice for Soviet aggression and occupation is postponed indefinitely, today's perpetrators, including the current Russian regime, violating the international norms, waging the war against Ukraine, draw the lessons that such crimes will be ignored and forgotten, and they repeat them. That is why accountability is not a side issue, but a matter of deterrence and prevention. Lithuania reaffirms its full support for the independence and integrity of international justice mechanisms, including International Court of Justice and International Criminal Court, and stresses the need to comply with their decisions and cooperate fully with their work. We also recall that the crime of aggression is the supreme international crime because it contains within itself the accumulated evil of war. Lithuania therefore strongly supports the swift operationalization of the Special Tribunal for the crime of aggression against Ukraine, established under the auspices of the Council of Europe. Third, within the UN system, the credibility of rule of law is shaped by the credibility of the Security Council. When this Council fails to respond to clear violations of the Charter or international law, it does not remain neutral. It sends a signal that might makes right. This is why Lithuania supports Security Council reform to make this body more representative, transparent, and effective. We also call for responsible use of the veto, including through the Act Code of Conduct, and for veto restraint in situations of mass atrocities. The veto must never be used to block credible Council action aimed at preventing or ending genocide, war crimes, ethnic cleansing, and crimes against humanity. When this Council is prevented from acting in such moments, the damage is also institutional. Mr. President, Lithuania will continue to defend the rule of law as the foundation of our collective security, and we call on all members to match their commitments with action. I thank you, Mr. President.
I thank the representative of Lithuania for the statement. I give the floor to the representative of Azerbaijan.
Thank you, Mr. President. I would like to begin by conveying my gratitude to the delegation of Somalia for convening this important meeting. The international community is navigating an increasingly turbulent period in which adherence to international law and confidence in multilateralism are under significant strain. The selective application of international law, double standards, impunity, and uneven implementation of decisions have further eroded trust in the multilateral system. However, this is not a challenge that has emerged overnight, but rather one that has evolved over time. Azerbaijan was amongst the first to experience the consequences of these shortcomings when its territories were under foreign military occupation for almost 30 years. Regrettably, the UN Security Council resolutions remained unimplemented. Our persistent appeals to uphold international law were met with silence, thereby undermining confidence in the mechanisms meant to ensure justice. Azerbaijan, a country that has endured the most severe effects of war and is now striving for lasting peace, hopes that all those engaged in conflict today recognize that there is no greater misfortune than war, and that the ultimate aspiration must always be peace. Mr. President, the serious threats and challenges the world confronting today underscore the necessity for meaningful reforms of international mechanisms, a more effective and trustworthy system of multilateralism, strengthened cooperation among states, and conduct guided by good faith and mutual respect. International cooperation has gained increased significance in the current global landscape. Such cooperation must, however, remain firmly anchored in the purposes and principles of the UN Charter. Respect for the sovereignty and territorial integrity of states and non-interference in their internal affairs are critical to any progress in preventing and mitigating conflicts,
maintaining international peace and security, fostering sustainable development. Mr. President, reinvigorating peace, justice, and multilateralism requires more than words. It requires political will, moral clarity, and collective action. Azerbaijan is a firm supporter of effective multilateralism, as evidenced by its active and result-oriented chairmanships in, among others, the Non-Aligned Movement, COP29, Organization of the Turkic States, the Conference on Interaction and Confidence-Building Measures in Asia, where we have sought to foster dialogue, solidarity, and cooperation. Azerbaijan has always maintained its steadfast adherence to international law and to justice, recognizing that lasting peace can only be achieved through respect for these fundamental principles, both in word and in deed. We will continue our efforts to actively contribute to international cooperation and peace, and to ensure that the multilateral system is more effective and better equipped to accomplish its mission. Thank you, Mr. President.
I thank the representative of Azerbaijan for the statement. I give the floor to the representative of Romania.
Thank you, President. I would like to add a few points in addition to the statement delivered by the European Union. Challenges to the multilateral order and the international rule of law are not new. We must remind ourselves that the international order created and developed under the UN Charter did not arise by accident. It emerged from the shared and painful experiences of humanity accumulated over devastating conflicts, from the crystal clear understanding that in its absence, the world would continue its path towards ever-increasing devastation. It is precisely for this reason that, much as the UN system as a whole, the international rule of law is in a state of continuous strengthening. It both shapes and at the same time reacts to political dynamics. And this requires from member states a form of principled flexibility, one that allows us to navigate change without completely losing our bearings. We must remind ourselves that the international order created and subsequently developed under the UN Charter, with international law at its core, has consistently promoted trade, statehood, democracy, human rights, and multilateralism. And the need for these common goods has not depleted, to the contrary. The real challenge is no longer whether to pursue transformation. It is already underway, regardless of our preferences. Instead, the urgent task is to identify the reasons why the elements of the existing order are not fully applied and to determine how to strengthen their implementation, in sync with the new and emerging political dynamics. Mr. President, the economic prosperity and national security of every state increasingly depend on international collaboration. And this reality demands rules and systems for collective decision-making, which is a necessity, not a choice. And that is why we advocate for international rule of law both as a moral imperative and as a practical safeguard for states. On our way to devising innovative solutions, we should ask ourselves, how can we preserve the valuable components of the existing legal system in a radically transformed global landscape? And how do we make our legal framework stronger? Some speak of the opportunities that are a natural byproduct of crises or tensions that lead to incremental change. We agree. But we do not see any opportunity for anybody in a future devoid of the predictability, coherence, and level playing field that the international rule of law provides. And the UN Charter and its core principles, sovereignty and territorial integrity, face unprecedented pressure. Armed aggression, as in the case of Russia's war of aggression against Ukraine, tramples international law and blatantly violates the foundations of international and humanitarian law. And this kind of behavior is becoming a systemic threat. It is essential that ongoing peace processes that seek to achieve the monumental task of ending cycles of violence and suffering in Ukraine, Gaza, the African continent, and elsewhere remain just and securely anchored in the foundational principles of the UN Charter: sovereignty, independence, and territorial integrity applicable to all nations. In order to achieve fair and lasting peace with smooth political transitions and reconstruction processes, we need to preserve the protection of civilians at the core of our peace efforts. Moreover, international humanitarian law must be respected and humanitarian aid should reach those in need. To conclude, President, we once again underscore the enduring relevance of the mutually reinforcing linkages between the rule of law and the 3 fundamental pillars of the United Nations. We join the call for upholding legal commitments, enhancing cooperation with international courts, and implementing inclusive justice and accountability initiatives at all levels. Thank you very much, Mr. President.
I thank the representative of Romania for the statement. I give the floor to the representative of Timor-Leste.
Mr. President, at the outset, we extend our sincere appreciation to Somalia for convening this high-level open debate. We also thank the briefers for their valuable insights. We align ourselves with the statements delivered by the permanent representative of the Philippines on behalf of the ASEAN. We now highlight the following statement in our national capacity. Mr. President, rising geopolitical tensions, growing unilateralism, and selective adherence to international norms are eroding trust in multilateral institutions. The principles that have guided international cooperation for decades are being tested by power rivalries, expanding militarization, and emerging domains of warfare, including cyber operations. Mr. President, for a least developed country and a small island developing state such as Timor-Leste, international law and multilateralism are the conditions for survival. They safeguard sovereignty, ensure equal participation in global affairs, and provide smaller states with protection against coercion and impunity. For SEADs and other vulnerable nations, the international rule of law remains a beacon of hope, a pathway to peace, justice, and sustainable development. Without it, international peace and security cannot be achieved, human rights cannot be protected, and development aspirations cannot be fulfilled. However, today, the erosion of the rule-based order threatens these foundations. To safeguard our shared future, we must reaffirm and strengthen the multilateral system, ensuring it remains credible, inclusive, and fit for purpose. In this regard, Security Council members, particularly the permanent members, bear a special responsibility. The P5 must recommit to the purposes and principles of the UN Charter, uphold international law consistently, and exercise their authority with restraint and accountability. Selective adherence to international law undermines confidence and weakens multilateral itself. Mr. President, reinforced multilateral cooperation is also essential to preventing superpower rivalries from diverting global attention away from the urgent development needs of the Global South. For SEADs and LDCs, the consequences of inaction are severe, from climate vulnerability to debt distress to food insecurity and limited access to finance and technology. Sustainable development is therefore not separate from peace and security because it is its foundation. Mr. President, to strengthen the international rule of law, we propose, first, to enhance conflict prevention and peaceful dispute resolution. Second, to improve coherence and coordination across the UN system. Third, strengthen regional and international legal frameworks. Moreover, reinforce accountability through international judicial mechanisms. By acting collectively, we can restore trust in multilateralism and ensure that international law protects all nations, big and small alike. Timor-Leste stands ready to work with all partners to strengthen the United Nations and uphold a just, peaceful, and inclusive international order. I thank you.
I thank the representative of Timor-Leste for the statement. I give the floor to the representative of Japan.
Thank you, Mr. President. At the outset, Japan appreciates Somalia's initiative to hold this open debate under the theme of reaffirming international rule of law. Japan, as President of the Security Council in January 2023, also held an open debate on the rule of law among nations. What Japan wished to emphasize at that debate was the maintenance of international peace and security, as stated in the very first article of the UN Charter, cannot be achieved unless international law is respected and implemented in good faith. Japan welcomes this open debate, which shares the same concerns that we had 3 years ago. The international community based on the rule of law cannot be achieved without multilateralism. And multilateralism with the UN at its core has been a critical driver of international community's quest towards the rule of law. However, we are faced with the reality that the UN's vision for international peace and security based on the purpose of and principles of the Charter is difficult to achieve when fundamental norms such as the prohibition of acquisition of territory by force is not observed in good faith. As stated in the Friendly Relations Declaration adopted in 1970, after overcoming serious divisions among member states through persistent dialogue, member states must cooperate with each other to confront serious violations of the principles of the Charter. Mr. President, to achieve the rule of law among nations, as Article 2, Paragraph 3 and Chapter 6 of the Charter stipulate, international disputes must be settled by peaceful means without resorting to coercive measures. In this regard, promoting the peaceful settlement of international disputes through the appropriate use of international judicial institutions such as ICJ and PCA is critical. Japan emphasizes the role of such judicial institutions in reinforcing the rule of law in the international community. As part of efforts to strengthen the role of such institutions, given that only 74 states have made a declaration under Article 36, Paragraph 2 of the ICJ statute, Japan calls for the member states who are committed to the rule of law but have not yet done so to make this declaration. Taking this step clearly testifies to their strong commitment to the rule of law. Over the past 8 years, the UN has served as the center of multilateralism. However, as we face today's complex global challenges, confidence in the UN and multilateralism itself stand at a critical juncture. Japan believes that the rule of law based on the UN Charter benefits all nations, as envisioned by the founders of the United Nations 80 years ago. Therefore, Japan will continue to cooperate with fellow member states towards the realization of this far-sighted vision. Mr. President, it is regrettable that the Chinese delegation made groundless statements against Japan. Today's open debate is a venue for constructive discussion on the rule of law. Thus, the discussions should be legal, factual-based, and meaningful for the global peace and stability, rather than criticizing each other with baseless argument. Since the end of World War II, Japan has consistently followed the path of peace-loving nation and made innumerable contributions to the peace and prosperity of the international community, including the multilateral system based on the principle of rule of law. Japan's fundamental defense policy is the posture of passive defense strategy, which is exclusively defense-oriented, contrary to the Chinese side's claims. Japan also defines through domestic law the situation in which the right of collective self-defense recognized under the UN Charter is allowed to be exercised in a restrictive manner. Japan's defense strategy is completely consistent with international law, including the UN Charter. Thus, China's characterization of Japan's defense position and policy orientation is entirely groundless. The argument contradicts the fact-based discussion, which serves as a fundamental principle of the rule of law and is unsubstantiated and irrelevant. China should engage in accurate discourse that contributes to the global stability. To conclude, Japan believes the differences of views should be addressed through dialogue, for that is the core of the spirit of the UN Charter. I thank you.
I thank the representative of Japan for the statement. I give the floor to the representative of New Zealand.
President, For 80 years, we have worked together to establish an international system based on justice and respect for international legal obligations. This system, developed through cooperation and state consent, underpins our collective security and prosperity. It is universal and inclusive. Respect for that system is critical to prevent a world where might is right. A core principle of the UN is the sovereign equality of states. This foundational concept, enshrined in the UN Charter, provides that international law applies to all states equally, not according to their size, population, or military strength. New Zealand considers that the voices of small states matter as much as those of the powerful. We know the system is not perfect. This is why New Zealand has taken a leadership role in the UN80 reform process. But New Zealand remains resolute in our defence of the UN Charter and in support of the international judicial institutions which uphold it. In response to the question, how can we uphold the international rule of law, I wish to make 6 points. 1. The starting point must be that states uphold their international obligations and perform them in good faith. 2. In line with the Charter, we must all refrain from the threat or use of force against the territorial integrity or political independence of any state. 3. We must use diplomacy, the building block of relations between states, to prevent emerging conflict and settle disputes. This includes using the UN's good officers functions. 4. We must remain resolute in our support for international judicial institutions that support the peaceful settlement of disputes and work to end impunity for the most serious international crimes. 5. The Security Council should be at the forefront of our efforts. The Council's uneven record in fulfilling its mandate undermines its authority and effectiveness. Those states which enjoy additional privileges by virtue of their permanent membership of this Council have a particular responsibility in this regard. The use of the veto to prevent Council action and thus block effective responses to emerging conflicts and accountability for violations of international law impacts every member state. We recall Article 27.3 of the Charter, which obliges parties to a dispute to abstain from voting on relevant Chapter 6 resolutions. And 6, we must continue to support the development of international law to respond to the most challenging issues of our times. New Zealand reaffirms our support for the International Law Commission as an engine room of thought for addressing contemporary challenges. Its recent work on sea level rise demonstrates this. History has shown that our prosperity and security is served by respect for the international rule of law, not retreat from it. Thank you, President.
I thank the representative of New Zealand for the statement. I give the floor to the representative of Morocco.
Monsieur le Président.
President, at the outset, I would like to congratulate Somalia, a kindred country. Thank you for convening this debate of utmost importance during Somalia's Security Council presidency. I also wish to thank His Excellency, Secretary General Antonio Guterres, and His Excellency Mahmoud Ali Yusuf, Chair of the African Union Commission, as well as Judge Abdul Qawi Yusuf, former President of the ICJ. We're grateful for their relevant briefings. President, the UN Charter remains a flagship, a lodestar of the rule of law. It provides a clear-cut normative framework underpinned by universal and fundamental principles which enshrine sovereign equality of member states, respect for their territorial integrity, their national unity, a prohibition on the use of force, and the peaceful settlement of disputes. These principles are neither selective nor can they be tailored to specific circumstances. They form a comprehensive whole, providing a concrete and indispensable guarantee of respect for international law. The Kingdom of Morocco underscores how imperative it is to respect territorial integrity and national unity of member states, which are a cornerstone of international law. These principles are enshrined in the Charter, and they cannot be interpreted in various ways nor preconditioned on anything. They are absolutely vital for conflict prevention and for the maintenance of international and regional peace, security, and stability. Furthermore, Morocco attaches strong importance to the peaceful settlement of disputes, as per Article 2 and Chapter 6 of the Charter, which provide detailed implementation mechanisms, including in Article 33, such as negotiation and mediation. We also wish to underscore that the principle of non-interference in the internal affairs of states, covered in Article 2 of the Charter, constitute an essential pillar of international stability, a necessary precondition for the respect of national sovereignty, for strengthening trust between member states, and for the prevention of any instrumentalization which could undermine international peace and security. In parallel, the Kingdom of Morocco would like to reiterate the importance of the principle of good neighborly relations contained in the preamble and Article 74, underpinned by mutual respect, cooperation, and refraining from any actions which could undermine peace, security, or stability. Respect for this principle is necessary to prevent conflicts and to ensure the peaceful, lasting, and balanced settlement of disputes between member states. Mr. President, the UN Charter and the international legal arsenal that stems from it codified international relations. Today, we're facing a multiplication of crises and tensions. Challenges lie no longer in the absence of norms or lack of legal frameworks, but in their effective implementation. This is the precondition for the rule of law, ensuring stability, conflict prevention, and the maintenance of international peace and security. This morning, the Secretary-General forcefully underscored that for 8 decades now, the rule of law has been the principal factor determining balance in international relations, and called on all states to reiterate their commitment to fully respect international law and to live up to the promises and the obligations set forth in the UN Charter, end of quote. The Kingdom of Morocco fully subscribes to this call issued by the Secretary-General. We reiterate our unswerving commitment to the rule of law, to respect for the UN Charter, and the primacy of the law so as to ensure conflict prevention, peaceful coexistence between states, the peaceful settlement of disputes, good neighborliness, and respect for the territorial integrity and national unity of member states, with a view to building a world where peace, stability, and security reign supreme at the international level. I thank you.
I thank the representative of Morocco for the statement. I give the floor to the representative of Kyrgyzstan.
Mr. President, we would like to thank the Somalian presidency for convening this timely open debate. We also thank the distinguished briefers, Secretary General, Chairperson of African Union Commission, and founding president of the African Institute of International Law for their valuable insights. The concept note of the open debate rightly underscores the international rule of law as a cornerstone of multilateralism and the founding for international peace and security. This debate offers an important opportunity to reflect not only on our shared commitments, but also on the credibility and effectiveness of the international legal order. As a landlocked developing country, our security, sovereignty, and sustainable development depend fundamentally on the predictability, equality, and universality of international law. As my president mentioned during the high-level week last September, the organization was born from the horrors of war, but is alive thanks to the belief in cooperation, dialogue, and respect. Respect for the UN Charter, including the sovereign equality of states, territorial integrity, the peaceful settlement of disputes, and the prohibition of the use of force remains essential to safeguarding the interest of all nations. The Kyrgyz Republic strongly supports the peaceful settlement of disputes as a primarily means of maintaining international peace and security. In our own region of Central Asia, dialogue, negotiation, and the preventive diplomacy have proven indispensable for addressing complex challenges related to border and regional security. Mr. President, reaffirming the rule of law requires not only renewed commitment, but also a demonstration of consistency, good faith, and impartiality in the application of international legal norms. Today's interconnected crises are testing the multilateral system as never before. International law and multilateralism are both shared shields, protecting the weak, restraining power, and ensuring that justice prevails. We have to strictly comply with these principles and norms of international law, which form the basis of all international cooperation aimed at saving lives, protecting human rights, and promoting development. Deepening cooperation and strengthening multilateral institutions, working to address the common challenges are fundamental. Mr. President, strengthening the international rule of law are also need for effective coordination among the principal organs of the UN. The Security Council, the General Assembly, and the International Court of Justice each have distinct but complementary roles. At the same time, regional organizations have an opportunity to play a more important role. The Kyrgyz Republic supports the close cooperation between the UN and regional and sub-regional organizations. In conclusion, Mr. President, international rule of law is the lifeline of all states, including small and developing ones, our shield against inequality and our guarantee of dignity. As an acting chair of the LLDCs, Kyrgyzstan will stand firmly for a world where every nation, regardless of size or geography, is equally protected and equally heard. I thank you.
I thank the representative of Kyrgyzstan for the statement. I give the floor to the representative of Mexico.
Muchas gracias. Thank you very much, Mr. President. Mexico is grateful to Somalia as President of the Security Council for this month. Grateful to Somalia for convening this open debate on the promotion and strengthening of the rule of law as an essential pillar for the maintenance of international peace and security. In view of the current global landscape, there is nothing more urgent than reaffirming the centrality of international law and the centrality of the UN Charter. In a context marked by protracted conflicts, rising tensions, and unilateral responses, the rule of law must not be viewed as an abstract concept and one which is subject to arbitrary views and considerations. On the contrary, the rule of law for decades has made it possible to prevent and curb violence, as well as to limit the use of force and to preserve the collective security system. Mexico reiterates that the prohibition of the use of force, enshrined in Article 2, Paragraph 4 of the Charter, constitutes a peremptory norm of international law. There can be no exceptions to its application beyond those expressly provided for in the Charter itself. Absolute adherence to this prohibition is a vital prerequisite for international peace and security. Mexico underscores the need to respect the letter and the purpose of Article 51 of the Charter. The inherent right to self-defense cannot be broadly interpreted, nor can it be interpreted in isolation from the requirements that must be met for it to be exercised, in particular those of necessity and proportionality. Neither can it substitute the central role that it is incumbent upon this Council to play. Practice which breaches these parameters, including the use of force against non-state actors in the place of law enforcement authorities, is illegal. It weakens the multilateral system and erodes the collective legal security system established by this organization. My delegation, Mexico, emphasizes that strengthening the rule of law in the international arena must imperatively go hand in glove with respect for international courts and tribunals. Mexico reaffirms the value of the work of the International Court of Justice, both in exercise of its contentious and advisory jurisdictions. Its decisions and opinions do not only resolve specific disputes, rather they contribute to the progressive development of international law and to clarifying the legal obligations of states, both crucial components in the prevention of conflicts everywhere around the world. Mexico underscores the importance of the International Criminal Court as a central tool in the fight against impunity for the most serious crimes of concern to the international community as a whole. The independence of the court and of its judges and staff, as well as the strengthening of its jurisdiction, respect for its judgments, and full cooperation on the part of states to ensure that their judgments are enforced, including detention orders, are crucial components of the international rule of law and of lasting peace. Weakening international criminal justice perpetuates cycles of violence and leads to the denial of responsibilities. Mr. President, the Security Council and the states that are members of it have a primary responsibility to promote the rule of law. Their decisions and practices must be commensurate with their responsibility, and that should manifest itself as consistency between their action and the Charter and international law. They must act with full adherence to the provisions of Article 24 and in compliance with Article 27, paragraph 3. Peace and well-being are not built on the margins of law, rather through its strengthening, through its promotion, and through effective compliance therewith. Consequently, Mr. President, Mexico, in line with its constitutional principles, foreign policy, and pacifist calling, urgently appeals for full respect of international law, as well as for respect for the purposes and principles of the UN Charter. As was indicated by the President of Mexico, unilateral action, invasion, cannot be the basis of international relations in the 21st century. These practices lead neither to peace nor development. As such, we reiterate our commitment to a rule-based multilateralism and to the strengthening of international legal institutions. We also reaffirm our commitment to an effective Security Council and one which acts within the parameters of the Charter. It is only in that way that we will be capable of moving towards legitimate, just and lasting solutions to the challenges facing the international community. Thank you.
I thank the representative of Mexico for the statement. I give the floor to the representative of Brazil.
Mr. President, I thank Somalia for convening this timely open debate. I also thank the briefers for their valuable insights. International law constitutes the cornerstone of our international order. Article 2, paragraph 4 of the Charter of the United Nations is widely regarded as one of its most fundamental provisions, as it states the primacy of international law over the use of force. It is worth recalling the tragic historical context that gave rise to this principle, particularly in times when lawlessness and unlawfulness are on the rise in international affairs. The prohibition of the threat of or use of force, together with the juridical equality of states, emerged from the Hague Peace Conferences of 1899 and 1907, Latin American states played a decisive role in shaping and consolidating these principles, contributing to their broad recognition in international law. Brazil is proud of being one of the forebears of this Latin American legacy. With that legacy as a guide, the Latin American and Caribbean region remains a zone of peace, free from armed conflict and respectful of international law and the principle of non-interference, a conscious, irreversible, and lasting choice. The resort to the use of force in our region revokes chapters of history we believed were behind us and jeopardizes our efforts to tackle huge challenges, regional and internal, political, economic, social, and environmental. Mr. President, on January 3rd, Brazil came to this Council to condemn the armed intervention in Venezuela. Any use of force contrary to the UN Charter's provisions against a state's sovereignty, territorial integrity, or institutions without express authorization by this very Council constitutes a clear violation of international law. Such actions contravene our Charter and must be unequivocally rejected. There are peaceful means of settling differences and disputes. The consequences of the weakening of international law, governance, and cooperation mechanisms are already evident. A record number of 61 active armed conflicts worldwide, the highest number since the Second World War, and more than 117 million people facing humanitarian catastrophe. At the same time, global military expenditures reached the astounding figure of $2.7 trillion in 2024. When the real challenges to humanity, such as climate change, poverty, and hunger, are disregarded, everyone is left behind. The norms governing relations among states are and must remain mandatory and universal to all states. They do not admit exceptions based on ideological, geopolitical, or economic interests. The multipolar world of the 21st century, which should promote peace and prosperity, must not be converted into spheres of influence where might makes right and where the law of force prevails over the force of the law. Brazil will continue to advocate for non-interference, the peaceful settlement of disputes, and the sovereign equality of states, principles enshrined not only in the Charter, but also in our national constitution. Genuine and lasting peace can only be achieved through the respect for international norms and the guiding principles of this organization. Thank you.
I thank the representative of Brazil for the statement. I give the floor to the representative of the Bolivarian Republic of Venezuela.
Mr. President, thank you. The Bolivarian Republic of Venezuela has the honor to take the floor on behalf of the Group of Friends in Defense of the Charter of the United Nations. The group's members commend the Federal Republic of Somalia on the theme chosen for this open debate. This high-level open debate, which is being held at a moment of profound consequence for the international system. President, the 80th anniversary of the Charter of the United Nations compels us not only to reaffirm our collective faith in its purposes and principles in their entirety and interconnectedness, it also compels us to defend them resolutely against erosion, selectivity, and open defiance. All of which we continue to note with dismay, and all of which are occurring at an increasing pace. International rule of law is not an abstract aspiration. It is the legal and moral bedrock of multilateralism. It is the guarantor of sovereign equality and an indispensable prerequisite for peace, justice, and security among nations. As reaffirmed by both the General Assembly and this very Security Council, the rule of law applies equally to all states and to international organizations without exception, without hierarchies being established, and without double standards. And yet, the international community today is faced with a deeply troubling reality. That is one of repeated and grave violations of the UN Charter. Of grave alarm is the rising tide of violations of that core principle that is the prohibition of the threat or use of force. This reality is one which increasing attempts are being made to normalize, and we reject those attempts categorically. Such actions undermine trust in international institutions, needless to say. They also undermine peaceful relations among states and weaken the credibility of the collective security system that we together have built over the last 8 decades. President, in this context, we cannot remain silent in the face of the unjustified and unprovoked armed aggression perpetrated by the United States of America against the Bolivarian Republic of Venezuela on the 3rd of January 2026. That aggression included widespread airstrikes against civilian and military targets, seen both in its capital city, Caracas, and beyond. It also included the illegal abduction of the sitting head of state and government, President Nicolas Maduro Mores, and that of the First Lady, Cilia Flores de Maduro. These unlawful acts constitute a flagrant violation of Article 2.4 of the UN Charter. They are also a flagrant violation of the principles of sovereign equality and non-intervention in internal affairs, and a violation of the most basic norms governing friendly relations of peace and cooperation among nations. These acts are also a grave breach of the inviolable immunities accorded under international customary law to heads of state and government. These immunities are not privileges, rather they are essential safeguards for international stability and diplomacy. There is no legal justification, none whatsoever, for unilateral military action, for regime change operations, or for the use of force with the goal of imposing political outcomes, or with the goal of exploiting through coercion and threats the natural resources of another sovereign state. Such conduct epitomizes the substitution of the rule of law with the principle of might is right. This is a dangerous step backwards that threatens not only Venezuela but the integrity of the entire international legal order. As such, we once again firmly reject the notion that peace can be opposed through might. This approach attempts to take us back to the law of the jungle, an era which was superseded through the very adoption in 1945 of the UN Charter. We reaffirm that international rule of law requires more than rhetorical commitment, Mr. President. It demands accountability, consistency, and the rejection of any alleged exceptionalism. It requires that breaches of the UN Charter be named as such, regardless of who the perpetrator is, and it demands that these be condemned unequivocally. The international community must demand that the United States of America and Israel cease their scorn of international law and their hostile actions from Palestine to Venezuela, from Iran to Somalia. They must also cease their increasing threats and unilateral coercive measures against Cuba and other countless countries. These are all actions which clearly inter alia undermine the rule of law at international level. Mr. President, our group of friends wishes to take this opportunity to underscore the central importance of guaranteeing respect for sovereignty, unity and territorial integrity of states, particularly in the African context. We in this regard, once again, firmly reject all attempts to fragment the territorial integrity of the Federal Republic of Somalia. We also reject unilateral actions purporting to recognize the region of Somaliland as a supposed independent entity. Such actions, if it's necessary to recall this fact, are flagrant violations of the UN Charter. They breach the relevant resolutions of the Security Council and African Union decisions. They set a dangerous precedent that threatens regional stability. The question of Somaliland is an internal matter of concern to Somalia and must be addressed by the Somali people alone. This through an inclusive dialogue and constitutional processes free from external interference. President, the rule of law among nations is reinforced through stringent adherence to the UN Charter, as well as to the norms of international law and through genuine multilateral cooperation. These principles are not optional. They are legally binding imperatives that must guide the actions of all states, big or small, including the United States of America, which is a permanent member of this body. Therefore, we call upon this Security Council and upon the United Nations as a whole to act decisively in order to prevent further erosion of the UN Charter. They must take action to firmly reject the use of force and to restore confidence in multilateralism, a multilateralism rooted in international law and not in power, not in coercion, and not in threats and not in the selective interpretation of norms. To conclude, our group of friends reaffirms its unwavering commitment to the defense of the UN Charter and to the international rule of law. We will continue to oppose aggression, intervention, and neo-colonial practices in all their forms and manifestations. We will continue to stand in solidarity with all peoples whose sovereignty, dignity, and rights are under threat. We cannot overemphasize the fact that the future of peace and justice depends on our collective resolve to guarantee that international law governs relations among nations universally, consistently, and without exceptions. Thank you, Mr. President.
I thank the representative of the Bolivarian Republic of Venezuela. I give the floor to the representative of Estonia.
Mr. President, when states gathered in San Francisco in 1945 to create the United Nations, they set the goal to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. Despite its flaws, despite the instances of the violations of international law, this order has served us well. It has delivered its purpose of preventing the World War III. It holds the promise that sovereignty, territorial integrity, freedom, and peace can be upheld through law. It provides hope for survival and protection against aggression, especially for small states, that is over half of the United Nations membership. The rules-based world order is existential. Unfortunately, this order has been under great strain already for years. For example, Russia, a permanent member of the Security Council, started with the annexation of Crimea, part of Ukraine, in 2014, and for nearly 4 years continues its illegal and unprovoked war of aggression against Ukraine, in violation of the prohibition of the use of force against another state's territorial integrity and political independence. Power and conversion are increasingly threatening to substitute the commitment to shared norms and principles in international relations. In these pivotal times, we must recommit stronger than ever before to the values and goals enshrined in the United Nations Charter. Let me underline 3 key aspects to maintain the international rule of law. First, all states must abide by international law. The stability of the international community depends on the good faith adherence of states to their obligations. Second, the consistency in the application of international law is indispensable and fundamental to its authority. Without consistency, the international rule of law loses its normative power and creates the perceptions of double standards threatening to divide the international community. Third, the responsibility for the violations of international law must be clearly recognized and addressed. Notably, the acts of aggression against sovereignty, territorial integrity, and political independence of a state constitute violations of the rules at the very heart of the United Nations Charter. The failure to ensure responsibility for such violations also risks weakening the collective security system. In addition to the responsibility of states for their international wrongful acts, the international rule of law entails also individual responsibility for crimes under international law. Ensuring responsibility on both levels is a necessary step to uphold the principles of the United Nations Charter, to maintain or restore peace and justice, and to deter future violations. Mr. President, let us commit to the international rule of law not only in words, but in actions. This is the only way to ensure peace and security for present and future generations. Thank you.
I thank the representative of Estonia for the statement. I give the floor to the representative of Tunisia.
Thank you, Mr. President. I wish to express my appreciation to the Federal Republic of Somalia for convening this open debate. Tunisia reiterates its firm commitment to an international order based on the rule of law in which all the states, with no exception, fully comply with their obligations under international law and the purposes and principles of the UN Charter. These include the peaceful settlement of disputes and the obligation to refrain from the threat or use of force in international relations. Respect for the Respect for the rule of law is essential for the maintenance of international peace and security, the promotion of sustainable development, and the establishment of just and inclusive societies. Tunisia calls for enhanced support for the International Criminal Court in its efforts to deliver justice and combat impunity for war crimes, genocide, and crimes against humanity. We support all peaceful means of dispute settlement, including recourse to the International Court of Justice, whose advisory opinions play a crucial role in clarifying legal obligations and strengthening the international rule of law. Mr. President, failure to collectively address impunity, selective application of international law, and double standards undermine the credibility of the international legal system and push the world toward a logic of power and violence. Unilateral approaches cannot solve our world's problems. They can only deepen them most of the time. They cannot be a successful strategic policy. Strengthening multilateral cooperation is the only human way to live in a better world and planet for all of us. Respect for the UN Charter and its spirit, including sovereign equality, rule-based order, and international solidarity, is the foundation upon which legitimate and effective multilateral action must rest and develop. I thank you.
I thank the representative of Tunisia for the statement. I give the floor to the representative of the Islamic Republic of Iran.
Thank you, Mr. President. In the name of God, the compassionate and merciful, we welcome this timely open debate because international law and the Charter of the United Nations are not merely under strain, but they are under deliberate assault. This erosion is not accidental. It is driven by those who believe power confers exemption from law and that peace should be established through strength and power. Mr. President, the Charter of the United Nations was never meant to be optional. It is not a menu from which powerful states may choose that suits them and discard what constrains them. Through a sustained pattern of unlawful action, the United States has sought to substitute its unilateral decision for the legitimate authority of the United Nations. This includes advancing arrangements in Gaza that bypass the functions and powers of the Security Council under misleading labels such as Board of Peace or an International Stabilization Force, openly defying the jurisdiction and ruling of the International Criminal Court and International Court of Justice, imposing of maritime blockade on Venezuela and conducting the unlawful abduction of its president in flagrant violation of international law and the UN Charter, issuing persistent threats to use of force and military attack against other sovereign states, threatening occupation or control of foreign territories, and withdrawing from the deliberately undermining specialized UN bodies. These illegal unilateral actions erode the international rule of law, undermining multilateralism and gravely endanger international peace and security. Mr. President, as we have informed this Council and the Secretary General on several occasions in recent weeks, the President of the United States has openly and repeatedly threatened the Islamic Republic of Iran with the use of force and military intervention. These interventionist statements by U.S. officials are neither ambiguous nor misinterpreted. Furthermore, the U.S. President has explicitly incited unrest within my country, called for takeover of institutions, and promoted violence under the guise of political pressure. The human cost and the consequences of these unlawful policies are grave. Between 8 and 10 January, innocent Iranian civilians lost their lives in violence that was fueled and exacerbated by armed and terrorist groups supported directly by the United States and the Israeli regime. The United States bears full legal and moral responsibility for the foreseeable consequences of this action, including civilian deaths, injuries, and the destruction of public and private property. Mr. President, if the United States can use threats of force, unlawful military action, coercion, and regime change policies as routine tools without facing any consequences, what remains of the UN Charter? and what remains of this Council credibility. No state, regardless of power, has the right to place itself above the law. When states openly threaten aggression and the use of force, this Council must speak clearly. Violation must be named as violation. I thank you.
I thank the representative of the Islamic Republic of Iran. I now give the floor to the representative of Paraguay.
Gracias, Presidente.
Thank you, Mr. President. The delegation of the Republic of Paraguay is grateful for the opportunity to take the floor at this debate. We congratulate the Somali presidency of the Security Council for this month, and we congratulate the briefings on their reports. We also wish to take this opportunity to wish every success to the elected members of the Council that have this month taken up position. Today's world is facing protracted challenges that are rendered more acute by technological progress and the dynamics that produces, as well as the damage caused by terrorism and transnational organized crime. Consequently, we believe that the UN is more relevant than ever before and remains the only global arena in which each and every one of the countries of the globe are represented. Multilateralism and the rules-based system remain relevant and must have the UN at their core. Member states have the task of ensuring that the organization is effective and efficient in achieving its goals. Paraguay trusts that the primacy of law nationally and internationally, together with good faith among nations and international cooperation, will be able to provide a sustained response to global problems through strengthened institutions and cooperations. We don't wish to undermine other efforts addressed at achieving effective peace on the grounds. We have an opportunity to ensure that the UN can uphold its mandate to spare succeeding generations from the scourge of war. We can further the mandate of facilitating the development of peoples and championing compliance with human rights. And we can do this if we fully implement the principles enshrined in the Charter. President states must decisively commit and do so and commit without delay to ushering in the necessary changes to the organization. These changes must lend predictability to the organization's work in order for the organization to benefit all. Our delegation recalls the international community's firm commitment to building an international system that provides just and equitable conditions for all states, regardless of size or level of development. Paraguay hopes that this organizational renewal that seems to be waiting in the wings can lead to the strengthening of development and human rights pillars. When pooled with efforts on the peace and security front, this will pave the way so that regions such as Africa, but also many others, achieve desired results in terms of peace and development. This is particularly crucial for Africa, a region that's close to our country. We're all too well aware of the difficulties faced by developing countries because we are a landlocked country and we have the similar difficulties at a national level, and we have the same goals. The enforcement of the rule of law and the strengthening of policies and institutions are the two central thrusts of our national development plan, in force till 2050. The plan is focused on strengthening state efficiency as well as on improving security in its various facets and on increasing civic participation in the country's political life. It also aims to guarantee legal security and strengthen the multilateral system. Our country's stances adopted in the international arena are faithful reflections of that vision. We conclude by stating that we recognize that for many regions, the enforcement and relevance of the rule of law at a national level remains a major challenge. Conflicts that lead to inequality and stymie development produce high costs for all. Colleagues, the rule of law is not a simple legal entelechy. We are obliged to rally, to address existing challenges and to make a reality our desire for a better world. Consequently, the UN, through this Council, the Security Council, the General Assembly and the Peace-Building Commission, inter alia, play a vital role. Thank you.
I thank the representative of Paraguay for the statement. I give the floor to the representative of Poland.
Thank you, Mr. President. At the outset, I would like to thank Somalia for convening today's debate on the topic that was, without doubt, both pertinent and timely. Over the 80 years of history, the United Nations system has arguably never been confronted with such a profound crisis as today. The primary reason for this is the gradual erosion of the most fundamental principles of the Charter, which are increasingly and openly being violated by a growing number of the UN member states, including the permanent member of this very Council. The blatant example of such a violation is the ongoing aggression of the Russian Federation against Ukraine, which constitutes a breach not only of the Charter, but also of the numerous obligations arising from the customary international law and from commitments undertaken by the country within the multilateral frameworks, including the humanitarian law. Poland has been has long been and continues to be a strong and consistent advocate of international law. Our historical record in this regard dates back to the medieval times and the 15th century political writings of Paweł Włodkowicz. We have constantly opposed all forms of imperialism, understood as the subjugation of states by other states through use of force, something that we have also experienced in our own history. The backbone of Poland's foreign policy is a vision of international relations grounded in the moral equality of states, mutual respect, and the primacy of the law over force. In this context, let me highlight key points around Poland's position in this regard. First, international law must be respected and observed by all states, as well as by international organizations. Second, political considerations can never serve as a justification for the non-observance of existing norms and principles. Third, the basic precepts of the national law are universal and cannot be affected by regional specifications and specificities and cultural differences. If we are to call ourselves the United Nations, we must demonstrate our unity first and foremost through a common approach to international law. Fourth, accountability is a cornerstone of the entire system. In the absence of an effective mechanism to impose consequences for violations of international law, it risks becoming merely a fair-weather tool dependent on the political will of the states at any given moment. This is precisely why Poland actively supports the international justice system, including the International Court of Justice and the International Criminal Court. Furthermore, in response to the Russian aggression against Ukraine, Poland has been actively engaged in the establishment of the new mechanisms, notably the Special Tribunal for the Crime of Aggression and the International Crimes Commission for Ukraine. We also believe that the frozen Russian assets, including those of the Central Bank of Russia and Russian National Wealth Fund, should be fully utilized to support Ukraine's recovery and reconstruction. Mr. President, today we note with regret and concern that the growing disregard for the core principles of the UN, as well as the inability of this organization to enforce compliance with international law by states that violate it. We see states acting in bad faith, misusing multilateralism and deliberately disregarding their own commitments, including those legally binding. It is often said that history repeats itself. Some may argue that the current erosion of international law is merely a temporary episode and that once the international community, tempted by a might makes right approach, has caused sufficient harm and committed enough mistakes, it will eventually return to the conclusion that the only universally respected rules serve the interests of all. The question we should ask ourselves, however, is this: why should we once again proceed down the same dead-end path before returning to the lessons that we have already learned? Thank you, Mr. President.
I thank the representative of Poland for the statement. I give the floor to the representative of Brunei Darussalam.
Bismillahirrahmanirrahim. Mr. President, distinguished colleagues. Brunei Darussalam congratulates Somalia on assuming the Council presidency, and also to Bahrain, Colombia, Liberia, Latvia, and the Democratic Republic of Congo on the election to the Council. Brunei aligns itself with the statement delivered by the Philippines on behalf of ASEAN. This open debate provides critical reflection on international rule of law and multilateralism as we commemorate 80 years since the founding of the UN. Mr. President, for a small state like Brunei Darussalam, the United Nations and its charter represent our collective commitment to maintain peace and security, uphold equal rights and self-determination, and advance solutions to global challenges. Yet we stand at a critical juncture, where eroding multilateralism, growing mistrust, and fragile geopolitics question the credibility and effectiveness of the international system. For small states, the international rule of law is not a mere preference. It is our primary defense. When multilateralism weakens, the rule of might threatens to supersede the rule of law. Amid these uncertainties, Brunei Darussalam holds the position that respect for international law, rule of law is essential to preserving peaceful coexistence. International law cannot be applied selectively or at the convenience of a few. Mr. President, peace cannot be achieved while grave injustices and sustained violations of international law continue to persist. For many decades, Palestinians have endured occupation, violence, displacement, and the systemic erosion of their most basic rights. No peace process can succeed when one party continues to live under prolonged occupation and is denied the full exercise of its right to self-determination, while the other wields the full attributes of statehood. Mr. President, we recognize that reforming the Security Council is a complex issue. However, the Council must adapt to new political realities by implementing concrete measures to bridge the gap between its permanent members and the wider UN membership. The arbitrary use of veto power is increasingly undermining the Council. To invigorate multilateralism, we must increase the political and legal accountability of those who hold this privilege. In this regard, we support the full institutionalization of the veto initiative for the General Assembly to serve as a venue for transparency and accountability whenever the Council is paralyzed. We also advocate greater working methods reform, specifically increasing formal consultations between the Security Council and small state groupings so that our voices are part of the preventive diplomacy process and not an afterthought. Brunei Darussalam therefore calls on the Security Council to fully implement and adhere to all provisions of the UN Charter relating to its decision-making process and exercise the use of veto with maximum restraint. We commend France and Mexico's call to suspend veto use in situations involving serious violations of international humanitarian law, war crimes, or genocide, to signal a move beyond geopolitical rivalries and towards our shared humanity. The sovereign equality of all states can only be honored when this privilege does not rest in with only a handful of countries. The Security Council must work more openly and transparently, with its work held accountable to all member states. Only then can we reaffirm international rule of law and achieve peace, justice, and collective security. I thank you.
I thank the representative of Brunei Darussalam for the statement. I give the floor for the representative of Sierra Leone.
Thank you, Mr. President. Sierra Leone congratulates Somalia on its presidency of the Security Council for this month, and we thank His Excellency President Hassan Sheikh Mohamud for presiding over this timely, high-level, open debate. We also thank the Secretary General, the Chairperson of the African Union Commission, H.E. Mahmoud Ali Yusuf, and George Abdulakil Yusuf for their valuable contributions. Mr. President, the stakes could not be clearer. The multilateral system and the collective security framework we inherited in 1945 rest on the Charter of the United Nations and on international law. Yet this system is under unprecedented strain. Too often we see a return to the logic of might makes right. History has taught humanity at a terrible cost what follows when power outruns law. Insecurity spreads, impunity grows, and the weak are left unprotected. Sierra Leone therefore aligns itself with the central proposition that the international rule of law is a pillar of multilateralism and a keystone for international peace and security. For countries such as ours, states that have experienced conflict, inequality, and a long shadow of historical injustice, the international rule of law is not theoretical. It is a guarantor of sovereignty, dignity, and equal standing among nations large and small. It is also the foundation of trust in institutions. Where rules are applied selectively, confidence erodes. Where compliance becomes optional, legality gives way to coercion, and the chapter's promise of collective security is is hollowed out. Sierra Leone therefore reaffirms the core charter principles that must guide our conduct: the sovereign equality of all states, the inviolability of sovereignty, territorial integrity, and the political independence, the prohibition against the threat of use of force, and the duty to settle disputes by peaceful means. These are binding principles, the bedrock of an international order where law restrains power. Mr. President, how do we fortify the international rule of law in years ahead? First, we must proactively, regionally, and globally identifying and reversing patterns of regard erosion before they happen into conflict. We should strengthen early warning and preventive diplomacy with a clear rule of law lens, tracking coherent violations, dehumanizing rhetoric, attacks on civilians and humanitarian personnel, and disregard for lawful dispute settlement. Within Africa, AU-led efforts supported by regional mechanisms including ECOWAS, SADC, and IGAD can help translate Charter principles into lawful dispute settlement. Within Africa, AU-led efforts supported by regional mechanisms, including ECOWAS, SADC, and IGAD, can help translate Charter principles into operational practice through regional compacts on constitutional order, non-use of force, mediation, and respect for boundaries and territorial integrity. Second, the Security Council and the wider UN system must lead by example. The Council's credibility depends on consistency and principled action. We should make fuller use of Charter, including Chapter 6 tools, mediation, good offices, conciliation, arbitration, and judicial settlement, so that law, not force, becomes the default pathway for resolving disputes. Even where the Council is divided, it must still protect the core civilians, humanitarian pace, and the integrity of UN mandates. Third, we should better enforce underutilized Charter obligations, starting with good faith. Article 2.2 is not decorative. It is a discipline on all of us, especially those with the greatest influence. Article 2.3 must be operationalized through real investment in peaceful settlement arrangements and the duty to operate central to the Charter's vision of peace linked to economic and social progress. In conclusion, peace must be measured through law. For the Security Council, its authority is strongest when it is principled. Its legitimacy is highest when it is consistent, and its capacity to lead is greatest when it defends the Charter without fear or favor. Sierra Leone stands ready to support strategic pathways that rebuild trust, good faith, compliance, strengthen peaceful statement of disputes, and renewed multilateral cooperation, so that the rule of law is not merely reaffirmed in wars, but restored in peace. I thank you.
I thank the representative of Sierra Leone for the statement. I give the floor to the representative of Vietnam.
Mr. President, I thank Somalia for convening this timely open debate on an issue of fundamental importance. Vietnam aligns itself with the statement delivered by the Philippines on behalf of ASEAN and wishes to offer the following remarks in its national capacity. The foundation of modern international relations rests on respect for international law and the rule of law among nations, as enshrined in the Charter of the United Nations. Yet today, we continue to witness frequent violations of international law, selective interpretation and implementation of legal obligations, and the threat or use of force. These concerning trends undermine not only international peace and security, but also the credibility of the very rules that bind us together. Mr. President, across many regions, wars and conflicts have inflicted deep scars on societies and generations. History has shown that when international law is ignored, instability prevails, and when the UN Charter is disregarded, peace remains elusive. Vietnam's own history affirms that lasting peace can only be built on respect for international law, good faith, dialogue, and cooperation. As the United Nations enters its 9th decade, multilateralism is facing unprecedented challenges, and growing divisions are testing our collective commitment to the common rules and shared responsibilities. At this critical juncture, our response must be clear. This is not a time to weaken the rule of law, but to reaffirm it, strengthen it, and apply it consistently. In this spirit, Vietnam wishes to emphasize the following 4 points. First, all states, large or small, must fully and faithfully implement their obligations under international law, particularly the treaties to which they are parties. Disputes must be resolved through peaceful means. The threat or use of force must be rejected, and diplomatic and legal processes must be respected. Second, multilateralism and a genuine cooperation remain the only viable path to addressing today's complex and interconnected challenges. Effective solutions require cooperation grounded in the respect for sovereignty, territorial integrity, non-intervention, and good faith. Third, the United Nations continue to play a central role in maintaining international peace and security, and in facilitating the peaceful settlement of disputes. Vietnam supports all efforts and initiatives to end conflicts in full conformity with the UN Charter and relevant Security Council resolutions. Fourth, strengthening the rule of law requires coherent and effective coordination across the UN system. The Security Council, the General Assembly, international courts and tribunals, special political missions, and peacekeeping missions must exercise the mandates in a coherent and complementary manner, in close cooperation with regional organizations and the states concerned. Mr. President, reaffirming the international rule of law is not an abstract exercise. It is a prerequisite for peace, stability, and sustainable development worldwide. Vietnam reaffirms its unwavering commitment to the rule of law at all levels, and stands ready to work with all member states and partners to strengthen and restore trust in multilateralism and build a more peaceful, just, and secure world governed by the force of law, not the law of force. I thank you.
I thank the representative of Vietnam for the statement. I give the floor to the representative of Italy.
Thank you, Mr. President. Italy aligns itself with the statement of the European Union and with the statement delivered by Austria on behalf of the group of Friends of the Rule of Law. And let me say that it is an honor for me to address this Council for the first time. Let me also commend Somalia for assuming the presidency of the Security Council and convening today's open debate. We welcome this opportunity to focus on the rule of law in international relations as key ingredient in ensuring peaceful and just relations among nations and people. We thank the distinguished briefers for their instructive contributions, including Judge Yusuf, a formidable representative of the African international legal tradition. Mr. President, as we gather today, the foundations of the rule of law in international relations are being shaken by unjustified wars of aggression and by blatant disrespect for human rights and international humanitarian law in many parts of the world. Italy continues to stand firm in defense of the Charter of the UN, of the sovereignty and territorial integrity of nations, and of the self-determination and human rights of peoples. Mr. President, a multilateral system of peaceful relations among states based on the rule of law requires constant and long-term commitment in 5 different respects. Firstly, it requires adherence to international legal obligations, whether deriving from treaties or from customary international law. Compliance with international legal obligation is not a matter of choice. That applies also to the obligations stemming from the Charter of the UN, including those of a procedural nature aimed at ensuring the proper functioning of the UN Security Council. Secondly, situations that might constitute a breach of international law by states, especially when capable of hampering peace and international security, should be adequately addressed. The UN Charter recognized the primary responsibility of the Security Council in this regard, and it is our collective responsibility to ensure that its decisions are properly implemented. Thirdly, we must redouble our efforts so that the rule of law in societies, including the respect of promotion of fundamental human rights, does not remain a vision, but translates in everyday realities for people and citizens. In this respect, we see a crucial role to be played by regional organizations, including the African Union, in promoting inclusive dialogue, community-based engagement, and more effective peaceful transitions, hence preventing the commission of serious crimes such as war crimes, crimes against humanity, and the crime of genocide that too often characterize unresolved conflicts. Fourthly, disputes which may endanger international peace and security must be settled peacefully in accordance with Article 33 of the UN Charter. That includes resorting to international courts and tribunals when diplomatic solutions have proved elusive and abiding by their judgments and decisions. In particular, the International Court of Justice plays a critical role in promoting the peaceful settlement of international disputes and contributes to the development of strengthening of international law as a fundamental condition for stability. Therefore, the cooperation between the ICJ and the Security Council must also be strengthened in accordance with the Charter. Fifthly and finally, in accordance with the preamble of the Charter, we must strive to create the conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained. That includes a reform for a more efficient United Nations, including making this very body more democratic, representative, accountable, transparent, and effective. Mr. President, in 2013, our heads of state and government gathered at the UN headquarters to reaffirm their solemn commitment to the purpose and principles of the Charter of the United Nations, international law and justice, to an international order based on the rule of law. At a very critical juncture in history, Somalia's timely initiative reminds us that much remains to be done to implement that vision. And it is now time to act if we want to deliver to the future generation a more just world where the rule of law prevails over the law of force. I thank you, Mr. President.
I thank the representative of Italy for the statement. I give the floor to the representative of Cuba.
Gracias, señor presidente.
Thank you, Mr. President. Mr. President, the delegation of Cuba supports the statement made by the Bolivarian Republic of Venezuela on behalf of the group of Friends in Defense of the Charter of the United Nations. The international rule of law is an essential pillar of multilateralism and a prerequisite for peace, security, and the peaceful coexistence of nations. It demands, first and foremost, absolute compliance with the United Nations Charter, whose principles and purposes not only remain in force, rather, they are also particularly crucial in view of the current challenging international context. Today, we are witnessing a worrying erosion of the rule of law at an international level. This erosion is marked by the violation of norms, the use or threat of use of force, unilateral coercive measures, and the systematic disregard of international organizations and of the decisions adopted in multilateral frameworks. The government of the United States has publicly stated that it does not respect international law. It has demonstrated that it will impose its interests at a global level, including through the use of its military might. It invades countries, it violates their borders, their airspace, their freedom of trade and navigation. It issues unilateral proclamations, it commits acts of piracy and state terrorism, and conducts military operations outside of its jurisdiction. In so doing, it threatens the sovereignty of all states. The challenge is one facing the whole of the international community. The threat posed is a global one. Such practices violate the principles of the peaceful coexistence of states. They weaken the credibility of international institutions, and they stand as a grave threat to international peace and security. Respect of the principle of good faith, as enshrined in Article 2 of the UN Charter and fleshed out in Resolution 2625 of the General Assembly on friendly relations and cooperation among states, is not optional. States cannot invoke international law when they believe it relevant to do so, and violate it in total impunity when it contradicts their political or geostrategic interests. We reaffirm that the prohibition of the use of force and the principle of the peaceful resolution of disputes must remain cornerstones of the international system. Moreover, the sovereign equality of states and the right of peoples to self-determination are principles of the international rule of law from which we cannot waver. No state has the prerogative to impose on others political, economic, or social models. Neither can they intervene directly or indirectly in their internal affairs. Unilateral coercive measures and arbitrary lists have no basis in international law, and they constitute flagrant violations of the above principles. Against this backdrop, Cuba reiterates its condemnation in the strongest possible terms of the U.S. military aggression against the Bolivarian Republic of Venezuela. This was a criminal act that violated international law and the UN Charter. We also decry the abduction of President Nicolas Maduro Moros and his companion Cilio Flores by the U.S. government. We decry the ratcheting up of the economic, commercial, and financial blockade against Cuba and the additional external measures. We also decry the evident intentions and public threats of the U.S. government of an aggression against Cuba. We have demonstrated that we have the capacity to defend our independence and sovereignty. We trust in the conscience of the international community and in its ability to mobilize to oppose an aggression of that kind. The escalation of belligerence on the part of the U.S. government is producing a renaissance of its expansionist imperial ambitions. With its aggressions and threats, in particular those levelled against American nations, the United States is intending to reimpose by force the much discredited Monroe Doctrine. This is riding roughshod over the proclamation of Latin America and the Caribbean as a zone of peace. The goal is to subjugate peoples and governments of this region to their control, and that is a violation of the concept of rule of law at an international level. In parallel, the government of the U.S. has decided to abandon fora and institutions created to promote international law, sustainable development, gender equality, biodiversity, climate change, the fight against racism. At the same time, they are attempting to create biased, selective organizations that do nothing other than further their imperial interests and desires to impose peace by force and to swell military expenditure to allow them to threaten tariffs, use force and military inventions, and this is all in flagrant defiance of multilateralism, the UN Charter, and international law. International rule of law involves authentic and solidarity-based cooperation geared towards sustainable development, social justice, and the eradication of deeply rooted inequalities which remain between countries. There can be no lasting peace without development. Neither can we achieve development without peace. We emphasize that full respect for the UN Charter and the norms of international law, as well as the defense of multilateralism, are as urgent today as they are vital. International rule of law demands real political will, and it involves casting aside double standards and the politicization of international relations. Moreover, there is an urgent need in this regard for a just new international order which is democratic and equitable, and one which places human dignity and our survival at its heart. Thank you.
I thank the representative of Cuba for the statement. I give the floor to the representative of Ethiopia.
Thank you, Mr. President. At the outset, allow me to congratulate you on assuming the presidency of the Security Council for the month of January. I also wish to thank the Federal Republic of Somalia for taking the initiative to convene this timely meeting. The rule of law at both national and international levels remains a cornerstone of the United Nations system. It's not an abstract concept, but a practical foundation for conflict prevention, peaceful coexistence, post-conflict recovery, and sustainable development. Where the rule of law is weakened or applied selectively, instability deepens and trust in the international system erodes. International peace and security depend on our collective and consistent commitment to uphold the rule of law in full conformity with the purposes and principles of the United Nations Charter. Mr. President, respect for international obligations and the peaceful settlement of disputes remain indispensable to maintaining international peace and security. The Charter obliges all member states to refrain from the threat or use of force and to resolve disputes through peaceful means. Accordingly, it will be in our best common interest to refrain from undue escalation of differences and unpredictable security arrangements that would undermine peace and security. This is imperative to neutralize criminal and terrorist networks, protect regional peace and security, and safeguard development gains. The rule of law challenges we are facing today are increasingly complex and interconnected. Transnational organized crime, terrorism, illicit financial flows, cyber threats, and the misuse of new and emerging technologies pose serious risks to peace and security for all states, small and big. Addressing these threats requires international cooperation. All UN member states must abide by their commitment to the UN-centered multilateral system while promoting national priorities and ownership. Developed countries must discharge their special responsibility to supporting development, reducing inequality, and addressing the root cause of conflict. Mr. President, Ethiopia firmly believes that the rule of law must serve the promotion of human dignity, social justice, and sustainable peace. The selective application of international law undermines its very foundations and weakens trust in the multilateral system. Ethiopia reaffirms its unwavering commitment to multilateralism, the promotion of international law, and enhanced cooperation at regional and global levels. The United Nations must continue to place peace and security at the center of its agenda, while supporting nationally driven solutions and respecting the sovereign equality of states. For international rule of law to be effective, the UN Security Council, which is vital for peace and security in the world, must be reformed without further delay. Entrenched injustice, like non-representation of Africa in the permanent category of the membership of Security Council, must be rectified as a matter of priority. Only through collective resolve, genuine partnership, consistency in action, and renewed faith in multilateralism can the rule of law serve as a firm foundation for a more peaceful, just, and secure world for present and future generations. I thank you, Mr. President.
I thank the representative of Ethiopia for the statement. I give the floor to the representative of the Kingdom of the Netherlands.
Mr. President, the Benelux countries, Belgium, the Kingdom of the Netherlands, and Luxembourg, aligned themselves with the statement delivered by the European Union on behalf of the EU and its member states. The Benelux countries also aligned themselves with the statement delivered by Austria on behalf of the Group of Friends on the Rule of Law. Mr. President, in my intervention, I would like to highlight 3 elements that we believe are essential to the achievement of the rule of law. First, a strong rules-based international legal order where rules are clear, agreed on, and complied with is essential for justice, peace, and prosperity in a highly interconnected world. The peace settlement of disputes is clearly enshrined in the UN Charter. International courts and their judgments, as well as the UN, are all agreed mechanisms by and through which disputes are resolved peacefully. They also form the very safeguards against a world where might is right. The Benelux countries contribute significantly to the development of rules that embody the international legal order and push for compliance with existing rules of international law. My own country, the Kingdom of the Netherlands, plays a pivotal role in the international legal order. We are home to a large number of international legal entities, such as the International Court of Justice and the International Criminal Court. The Hague is widely known as the legal capital of the world, and Luxembourg City is known as the legal capital of Europe, as it is home to the Court of Justice of the European Union and to the Benelux Court of Justice. We will continue to work closely to strengthen and uphold the rules-based international legal order. Mr. President, my second point very much relates to accountability. When it comes to bolstering the international legal order, efforts to combat impunity for international crimes and ensure accountability are an explicit priority. The international legal order is strengthened by the prosecution of persons accused of war crimes, crimes against humanity, genocide, and the crime of aggression. Such efforts have a deterrent effect and, very importantly, provide a measure of redress to victims and contribute to lasting peace. Mr. President, my third and last point is very much about the cooperation among states. Having witnessed the scourge of war, horrors which shook humanity to its very core, our shared determination have been to save succeeding generations from the scourge of war. The ideas, convictions, and promises enshrined in the UN Charter are as relevant today as they were in 1945. And yes, we all know the UN is not perfect. We all know the UN must reform to be more effective and efficient in delivering on its mandates. And yes, it needs to be more representative of today's world. The Benelux countries are all your partner in working with you on these issues. And let us build the UN and its charter, and let us strengthen together, collectively, the international legal order. In conclusion, Mr. President, the Benelux countries underscore the very importance of upholding and further developing the international legal order with the UN Charter at its very core and heart. And we call for full compliance with the rules and obligations that bind us all and bring us all here together. Thank you, Mr. President.
I thank the representative of the Kingdom of Netherlands for the statement. I give the floor to the representative of Cambodia.
Thank you, Mr. President. First, Cambodia commends Somalia for convening this timely and consequential high-level debates at a moment when the authority of international law and the credibility of multilateralism are being tested. My delegation would like to align ourselves with the statement of ASEAN delivered by the Philippines early this morning. For Cambodia, the international rule of law is the very condition upon which sovereignty, territorial integrity, and the equality of states are preserved. The prohibition of the threat or use of force against territorial integrity of any state, as enshrined in Article 2.4 of the UN Charters, must be upheld. Actions that seek to alter the status quo on the ground constitute clear violation to international law and the risk of escalating tensions. In this regard, I would like to share three reflections. First, Cambodia emphasized that the peaceful settlement of disputes, as required by Article 2.3 of the Charter, is a binding legal obligation. Border and territorial disputes demand resolutions exclusively through peaceful and lawful means. Judicial settlement, including recourse to the International Court of Justice, is credible and principled pathway available to states. Second, Cambodia called for the effective and strengthened implementation of the Security Council Resolution 2788 of 2025, which reaffirmed mechanisms for the peaceful settlement of disputes and preventive diplomacy. Prevention remained the most humane and cost-effective and legally sound investment in international community can make. Therefore, a visible and capable UN presence on the ground, politically, financially, and operationally, is essential not only for the de-escalation but also for prevention of dispute. Third, Cambodia underscored the respect for international humanitarian law is an essential and inseparable component of the international rule of law. The civilian life must be protected in all circumstances. Acts of aggressions involving the targeting of civilians, the destruction and pillaging of civilian property, the obstruction of civilian return, the illegal occupation of territory, and damage for destruction of cultural heritage constitute a breach of international humanitarian law. Mr. President, Cambodia stands ready to work with all member states to reaffirm the primacy of the UN Charter, to strengthen judicial and preventive mechanisms, and to reinvigorate the international rule of law as an indispensable pathway to peace, justice, and effective multilateralism. I thank you.
I thank the representative of Cambodia for the statement. I give the floor to the representative of Angola.
Mr. President, distinguished members of the Security Council, at the outset, allow us to thank Somalia for convening this high-level debate and all the briefers for their insightful remarks. Mr. President, Angola is concerned with the rise of unilateralism as the result of some countries increasingly pursuing their interests at the expense of others. These actions are challenging the United Nations Charter and international law, thus threatening the stability and the effectiveness of the global governance. Since its creation 80 years ago, the United Nations has been playing a central role in maintaining international peace and security, promoting fundamental human rights, and upholding respect of international law, ensuring that interests of all nations are represented and decisions are made to advance multilateralism. In this context, allow us to make 3 points. First, the current multilateral system remains important to address all these multifaceted and complex global challenges through inclusive and concerted collective actions. The UN Charter and international law are the foundation of modern international system to which all states must adhere to uphold multilateralism, settle disputes by peaceful means, and work together to reform and improve global governance. Second, building a just and inclusive world requires a comprehensive reform of the UN Security Council to make it more democratic and equitable and better suitable to respond to new and emerging challenges. It must also address an historical injustice by ensuring Africa's fair representation on the basis of the 2005 Essolini Consensus and the CIRT Declaration, which call for 2 permanent seats with all rights and privileges and 2 additional non-permanent seats for Africa. As states in the Pact of the Future, this quest must be treated as a special case. Third, the UN must reform the multilateral system to maintain its strategic relevance for the well-being of all humanity. In this context, Angola supports the UN 80 initiative to strengthen the UN system and to prepare us for the world's multifaceted and complex global challenges by enhancing inclusive and concerted collective actions. In closing, let us recall the UN former Secretary General Dag Hammarskjöld's statement in 1954. The United Nations was not created in order to bring us to heaven, but in order to save us from hell. I thank you.
I thank the representative of Angola for the statement. I give the floor to the representative of Eritrea.
Thank you, Mr. President. At the outset, I would like to express my delegation's profound appreciation to the Federal Republic of Somalia for organizing this high-level open debate on a consequential theme of reaffirming international rule of law as a pathway to reinvigorate peace, justice, and multilateralism. I align my statement with the statement delivered by the Bolivarian Republic of Venezuela on behalf of the Group of Friends in Defense of the Charter of the United Nations. Mr. President, as enshrined in the UN Charter and pertinent UN declarations, international rule of law is the legal and moral bedrock of the international system, predicated on the principles of sovereign equality, territorial integrity, political independence, non-interference in domestic affairs, peaceful settlement of disputes, and prohibition of the threat or use of force. These cardinal principles have been agreed upon by the community of all nations, irrespective of their size and power, to conduct friendly relations and cooperation. As such, they must be equally respected by all to ensure global peace and security, socio-economic prosperity, and justice. Contrary to these sacred principles, observance and promotion of international rule of law continues to wither away owing to reckless, unilateral, and hegemonic policy measures adopted by certain powers against those who don't conform to their self-professed rule-based order and standards. In utter disregard for the UN Charter, these actors have been intervening in the internal affairs of sovereign nations and instigating chaos, imposing illegal unilateral coercive sanctions, waging proxy wars, and intensifying geopolitical tensions, politicizing human rights, and exacerbating inequalities. Countries in the global south, in general and particularly in Africa, continue to bear the brunt of these ill-premised and imperialist policy practices. This must be rectified, and the community of nations should collectively endeavor to ensure a peaceful and just global order based on international rule of law as stipulated in the UN Charter. Mr. President, Eritrea, a law-abiding nation that has immensely paid to achieve its independence and defend its sovereignty and political independence, firmly upholds the fundamental principles of the UN Charter and international law. It categorically rejects any reckless attempts transgressing these principles in pursuit of perceived regional or global geopolitical interests, as that will lead to unprecedented destabilization. Guided by a safe and cooperative regional policy, Eritrea's resolve to the pacific settlement of disputes and adherence to the principles of international rule of law are matters of public record. Even on those disputes imposed upon it, Eritrea has consistently sought for pacific settlement and faithfully and invariably implemented the decisions of the international arbitrations. The Eritrea-Yemen arbitration decision of 1998-1999 and the Eritrea-Ethiopia Boundary Commission final and binding delimitation and demarcation decisions of 2002 are cases for reference. For the people and government of Eritrea, upholding international rule of law is not a policy choice, but a just and moral imperative. Mr. President, we are reaffirming the urgent need for preserving and strengthening the international rule of law as a prerequisite for promoting peace, justice, and multilateralism. Let me conclude by stating the following 2 points. 1, sovereign equality, territorial integrity, and political independence of all nations must be uniformly upheld. 2, the existing global order has not only reached at a rupture stage, but lacks the political will to self-correct. Thus, it is high time for the UN and its member states to act decisively and restore good faith and trust, and thereby ensure a peaceful, equitable, and just polycentric order. In this connection, I wish to reiterate President Isaias Afwerki's recent remarks. Quote, "The universal aspirations of the peoples of the world is clear: to live in peace and dignity, to benefit fairly from their labor, and support one another in solidarity. If a new world order is to emerge, it must be founded upon these fundamental principles." End of quote. I thank you, Mr. President.
I thank the representative of Eritrea for the statement. I give the floor to the representative of Thailand.
Thank you, Mr. President. I would like to begin by congratulating Somalia on assuming the presidency of the UN Security Council for this month and commend your leadership in convening this timely and very important debate. We express our appreciation to our briefers for their insights. Thailand aligns itself with the ASEAN statement delivered by the Philippines. We are deeply concerned by the growing reliance on power projection and unilateral actions for the undermining the already weakened rule-based international order. At this difficult time, redoubling our collective efforts to uphold and protect the international rule of law is imperative. Thailand wishes to highlight the following 3 points. First, the international rule of law is a cornerstone of the attainment and maintenance of international peace and security. It provides pathways for the prevention and peaceful resolution of disputes by transforming confrontation into dialogue, unilateral actions into collective responsibility, and the use of power into the exercise of restraint. Second, accountability is indispensable to the rule of law. When violations of international law are left unaddressed, impunity takes root. Grievances deepen, and the risk of further conflict escalates. Thailand believes that the rule of law and established legal frameworks must apply to all in an impartial and consistent manner, ensuring that there can be no differentiated treatments or exceptions. And third, upholding the international rule of law is a collective responsibility. Its legitimacy and sanctity rest on universal respect and consistent implementation. We must join hands across regions, political alignments, and levels of development to uphold the rule of law at the international level. Only through genuine multilateral cooperation, mutual accountability, and good faith engagement can we preserve the credibility of the international rule of law and ensure that rules rather than might govern international relations. Mr. President, the challenges before us demand collective efforts and strong political will. Without the adherence and upholding of international rule of law, peace cannot endure, justice becomes selective, and multilateralism loses its credibility. On this note, Mr. President, let me reiterate that respect for international law cannot be selective. The principles of sovereign equality, territorial integrity, and the political independence of any state must be upheld in practice, not merely invoked in rhetoric. Those who consistently call on others to respect international law must themselves adhere to it fully and in good faith. Thailand reaffirms its unwavering commitment to international law and the principles enshrined in the UN Charter that underpinned the rule of law in international relations. We stand ready to work with all member states to uphold and advance the rule-based international order with the UN indeed at its core, in which disputes can then be resolved peacefully, accountability is upheld, and trust in multilateralism is sustained. I thank you, Mr. President.
I thank the representative of Thailand for the statement. I give the floor to the representative of Canada.
Monsieur le Président, cher
President, distinguished colleagues, Canada is delighted to be taking part on this debate entitled Reaffirming the International Rule of Law, Pathways to Reinvigorating Peace, Justice and Multilateralism at a Time of Great Incertitude. For 80 years, the UN Charter has guided us with peace and security as its imperatives. Today, these principles are being put to the test. Geopolitical tensions, protracted conflicts, and selective respect for international law threaten the foundations of multilateralism. However, as the great specialist in constitutional law, Daisy, recalled, the primacy of the law is not an abstract ideal. It is a fundamental value. It is the very bedrock of international stability. It preserves sovereignty, protects human rights, guarantees responsibility, and helps us to settle disputes peacefully. It also, therefore, supports global trade by reducing risks, by combating corruption, and guaranteeing security. But let's be honest, economic interdependence, which had previously been considered a stabilizing factor, is increasingly used as a weapon. The primacy of the law is often ignored by powerful countries, sometimes openly so, when they believe it serves their interests or simply because they believe they can get away with it.
This is profound disruption, but member states are not powerless. We must act with principled pragmatism, steadfast in respecting sovereignty, human rights, and international law, while being realistic about today's challenges. Canada sees three priorities. First, good faith adherence to international obligations. The selective application of these erodes trust. Canada reaffirms its commitment to the Charter's principles, including sovereignty, human rights, and the prohibition of force. Second, stronger mechanisms for peaceful dispute resolution. We need to enhance or develop international and regional judicial bodies that deliver predictable and fair outcomes. These are vital for sustaining peace. Third, enhanced cooperation, both universal and flexible. When traditional avenues and institutions falter, we must innovate. Canada is committed to new partnerships that reinforce resilience and uphold international law. Mr. President, the rule of law is not self-sustaining. It demands leadership and collective stewardship. Canada stands ready to work with all member states to strengthen the institutions and norms that safeguard peace and enable genuine relations between states. The challenges are great, but so is our shared capacity to meet them. Canada remains pragmatic in approach, principled in conviction. The power of the rules and systems we have built together, including here in this body, remain strong when we wield them together, when we recognize their value, and when we act together to build on and from the strong foundations that have served us well. Thank you.
I thank the representative of Canada for the statement. The representative of China has asked for the floor to make a further statement. I give them the floor.
President, the Japanese representative in his statement was distorting facts and misleading, which China firmly opposes and categorically rejects. We feel compelled to respond in an unequivocal manner. First, Taiwan's return to China is an important outcome of the victory of World War II and an integral part of the post-war international order. The erroneous remarks of Sanei Takaichi seriously violate the obligations of a defeated country under the Cairo Declaration, the Potsdam Proclamation, and the Japanese Instrument of Surrender. They also constitute a serious breach of the fundamental principles of international relations enshrined in the UN Charter, including respect for the sovereignty and territorial integrity of states and non-interference in internal affairs. In essence, it is an attempt to deny the outcomes of the victory of World War II and overturn the post-war international order. Such a Japan has become a disruptor of international order. Second, during World War II, Japan waged wars of aggression, inflicting profound suffering and catastrophic consequences upon the peoples of Asia. The International Military Tribunal of the Far East systematically exposed through the trials the crimes of Japanese militarism. However, some Japanese politicians and forces have never truly repented or confessed guilt. Instead, they have attempted to deny these crimes and falsify history. Their so-called reflection on the war focuses ironically on why Japan was defeated rather than on its war crimes. Such a Japan is a perpetrator of wars of aggression. Third, from Japanese leader threatening the use of force against China to a senior official in the Prime Minister's office publicly advocating Japan's nuclear armament, and to attempting changes to the 3 national security documents and signaling revisions to the 3 non-nuclear principles. All of this exposes the attempts of Japan's right-wing forces to promote remilitarization and return to the old path of military expansion. These actions pose new threats to regional and global peace. Such a Japan has become a resurrector of militarism. The international community must prevent Japan from embarking on the old and evil path of militarism again. Fourth, during World War II, Japan perpetrated heinous atrocities, including forced recruitment of comfort women, massacres, human experimentation, and biological warfare. In recent years, the Japanese government has promoted a Japanese-first narrative, while xenophobia has continued to intensify. Indigenous peoples, ethnic minorities, and foreign residents face severe discrimination. Such a Japan is in every sense a blatant violator of human rights. Fifth, the Takaichi administration has grossly interfered in China's internal affairs, hinted at military intervention in the Taiwan question, and deployed offensive weapons in areas adjacent to Taiwan of China, deliberately creating regional tensions and provoking military confrontation. While China claims to be a peace-loving nation, in reality, its right-wing forces persistently provoke neighboring countries, create troubles, and then fabricate a narrative of being threatened, using so-called survival and defense as pretexts, to bind its people to the chariot of war. Such a Japan, in fact, is a true instigator of regional tensions. China will work with all peace-loving nations to expose Japan's true colors and jointly uphold the international rule of law and the victorious outcomes of World War II. We strongly urge Japan to do serious soul-searching, genuinely acknowledge and repent for its wrongdoings, stop making provocations and crossing the line, and earn the trust of China and the international community through concrete actions. Thank you, President.
I thank the representative of China for the statement. The representative of Japan has asked for the floor to make a further statement. I give them the floor.
Thank you, Mr. President. What was said by the Chinese delegation against Japan is unacceptable. Japan's position, including on our well-known path as a peace-loving nation, is already stated in our previous statement, as well as in our PR's letters to the SG, dated November 21st and December 1st last year in response to the Chinese PR's letters. Thus, I will not repeat it. It is unproductive to make such unsubstantiated argument in our important discussions for the better future of the United Nations. The theme of this debate is the rule of law, and I repeat our call for member states who are committed to the rule of law but have not yet done so to make the declaration accepting the ICJ's jurisdiction. Taking this step clearly testifies to their strong commitment to the rule of law, which Japan has been doing since 1958, when Japan accepted the compulsory jurisdiction of the ICJ. Thank you.
I thank the representative of Japan for the statement. The representative of China has asked for the floor to make a further statement. I give them the floor.
Mr. President, the representative of Japan has not only refused to admit Japan's wrongdoings, but also continued to twist the facts. China is compelled to respond again. I would raise 4 questions. If Japan truly abides by the UN Charter and stays committed to maintaining the international order, how come the leaders of Japan, a defeated nation in World War II, dare to interfere in the internal affairs of a victorious country and even threaten the use of force against a state country? If Japan is truly a peace-loving country, as it claims to be, a country striving for a nuclear weapon-free world, why does the Japanese government clamor to revise the 3 non-nuclear principles and even clamor to introduce nuclear weapons? If Japan truly upholds the international rule of law, why has it failed to effectively fulfill its international legal obligations as contained in the Cairo Declaration, the Potsdam Proclamation, and the Instrument of Surrender of Japan and other international legal instruments to completely disarm and not maintain any industries capable of rearmament? If the Japanese government truly keeps its position on the question of Taiwan unchanged, why can't it reiterate completely and accurately its position on the Taiwan question as stipulated in the 1972 China-Japan joint statement? Last but not least, I wish to reiterate that China's demand for Japan has always been categorically clear. That is, to face history squarely, reflect on its wrongdoings, withdraw erroneous remarks, and stop shaping a new type of militarism. We hope that Japan can take concrete actions to come clean with the people of China and the world at large. Thank you, President.
The representative of Japan has asked for the floor to make a further statement. I give them the floor for the final time.
Thank you, Mr. President. What was said by the Chinese delegation against Japan is unacceptable. Japan's fundamental defense policy is the posture of passive defense strategy, which is exclusively defense-oriented and consistent with international law, including the UN Charter. China's characterization of Japan's defense position and policy orientation is entirely groundless. This open debate should be an opportunity to discuss how we can strengthen the rule of law among nations. As mentioned earlier, Japan has been calling for member states to make the declaration accepting the ICJ's jurisdiction. Japan has been doing so since 1958, and this clearly testified of our strong commitment to the rule of law. States who claim to be committed to the rule of law should do so too. Thank you very much.
I thank the representative of Japan for the statement. There are still a number of speakers remaining on my list for this meeting. I intend, with the concurrence of members of the Council, to suspend the meeting until tomorrow afternoon, directly after the adjournment of the 10,097th meeting. This meeting is suspended.